Good afternoon, ladies and gentlemen. I want to welcome everybody to the monthly meeting of the City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear requests for variances and exceptions from the regulations in the zoning ordinance, conditional use permits, and appeals from the decision of the staff in the administration of the zoning ordinance, and to make decisions in such matters. The members of this board are citizens of the City of Des Moines and have been appointed to the board by the City Council. The board members are volunteers and receive no compensation for their public service. I'm going to go ahead and introduce our board and staff members here. On the audience's left is Brooke Rosenberg. Next to him is Cindy Smith. Absent today is member Cherie Mortiz. I'm Mel Pins, board chair. Next to me on the audience's right is Larry McDowell, our legal counsel. Next to him is Linda Westergaard. Next to Linda is Dave Gare. And Jake Christensen is our final member of the board. Jake is absent today. Our staff also with us today are Bert Drost, city planner. Is Eric with us today? He'll be in later. Eric Lundy, city planner. Anupreet Minhas, city planner. And Sue Ann Donovan, zoning enforcement officer. I'm going to give everybody a little background on the procedure here. For some of you, this may be the only time you'll be in front of this board. For some of you who have been here before, just a few reminders on how we conduct the hearing. First up, this is an open and informal meeting. It is being recorded. It should be broadcast live on the City of Des Moines cable channel. The board members have received a copy of the agenda for today's meeting as well as the staff recommendation. There are copies of the agenda and the staff recommendations available for the audience in the trays by the door. So if you want to kind of know the agenda flow and at least what the recommendation is from the staff on the items, feel free to hop up and grab one of those. The board is required to base its decision in these cases upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case is identified in the written staff report, and if the facts, as determined by the board, demonstrate that the criteria established by law for granting the relief has been satisfied, then the board must grant the relief. Otherwise, the board must deny the relief. Each appeal today will be announced in order, and the staff will present a brief explanation of the appeal. Any written comments received by the staff prior to the hearing will be distributed to the board or otherwise identified during the staff presentation. The appellant or the representative of the appellant will then be allowed to speak first and will be allowed up to 10 minutes to present their appeal. Anyone else present in support of the appeal requested will then be allowed up to 5 minutes each to present his or her comments. Anyone present in opposition to the appeal will then be allowed also up to 5 minutes each to present their comments. The applicant will then be allowed up to 3 minutes for a rebuttal or other closing comments. All speakers are requested to speak from the podium here to your left and begin their presentation by giving both their name and address. All speakers are requested to focus their comments only upon those facts that demonstrate whether or not the criteria established by law has been satisfied. The board will then close further public comment on the agenda item, and the board will then immediately deliberate the request and make a decision right here at the hearing today. If your appeal is approved today, we ask that you wait until tomorrow to go to the Permit and Development Center for any building permits. Items listed on the consent portion of the agenda, which is the first portion of our agenda here, we will not plan to individually discuss those items. We will consider them for approval as a group in accordance with the recommendation in the staff report, unless an individual present or a member of this board requests that the item be removed from the consent agenda and separately considered under the public hearing agenda. The decisions of this board can only be appealed in the Polk County District Court. So if you believe you've been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the City Council to change those regulations. All material written or otherwise used today as part of any presentation will become a permanent part of the record and will not be returned. So if you want to share some photographs or some documents, you either have to leave those with us, or we can make probably a copy of those would suffice. Just some quick housekeeping items. We ask that here in the audience, please avoid any conversation so as not to be disruptive or distracting from the hearing that is in progress. Ensure that your cell phone ringer has been silenced. And once the agenda item you are interested in has been completed, you're welcome to leave the hearing. Feel free to stick around if you'd like to armchair quarterback some of this, but again, as soon as your item has been heard, you're welcome to leave. If you need to use a restroom, you can leave through the main door here and walk through the atrium to the far north end, and restrooms are on your left. Subject to the length of the agenda, if we get past the 3 o'clock to 3:30 mark, we may take a 10-minute break if needed. Otherwise, we kind of plan to plug through this and get everybody's items out here to be heard. So, first item of business then would be to look at our consent agenda. At this time, we have items 1 through 8 on the consent agenda. Any changes, Bert?
We don't have any changes to the 8 that are on there. However, item number 14, which is an appeal at 1221 Birch Lane, we feel that that could be moved to the consent agenda if the board is comfortable with it. It's an item where they're proposing to construct a garage that would be within 24 feet of the front yard or the front property line. So they need an exception of 8 feet less than the calculated average 32-foot front yard setback. So if the board is comfortable moving number 14 to the consent agenda, staff would be in support.
Any discussion or motions by the board? On item 14, to consider that on consent, any thoughts? Good? Oh, sorry, Brooke. Yeah, is there anybody to speak in opposition to item 14? Okay, hearing none. Anybody want to put that on consent?
Hearing no objections, I would put item 14 on the consent agenda. I would move.
Okay, we got a move by Cindy, second by Brooke. All those in favor, raise your right hand, say aye. Aye. Opposed? Okay, no opposition. Motion carries unanimously. Okay, so we have items 1 through 8 and item 14. Those include exceptions, variances, and a special permit. Any motion to approve the consent agenda?
Can we read through them one time?
Sure. For the audience's benefit, just depending on why you're here, item 1 is a variance request at 2752 Chicago Avenue. Item 2 is an exception request at 4 Lincoln Place Drive. Item 3 is a variance at 2816 Beaver Avenue. Item 4 is an exception at 2726 47th Street. Item 5 is an exception at 1215. Would that be your street?
Yeah.
Item 6 is a special permit for 979 Oak Ridge Drive. Item 7, an exception and variance request at 111 and 130 East 3rd Street. Item 8 is an exception at 604 44th Street. And then item 14, an exception at 1221 Birch Lane. Before we vote on these, is there anybody that wishes to speak against any of these items I just listed? Okay. So hearing none, do I have a motion to approve the consent agenda as presented?
I would move staff recommendations for the consent agenda as stated, including item 14 for the variances, exceptions, and special permits.
And I'll second that.
Okay, we got a motion and second. All those in favor say aye. Raise your right hand. Opposed? None. Okay, motion carries unanimously. So if you're here for item 1 through 8 or item 14, you've been approved, and you don't have to stick around. So good to see you, Denny. Okay, so this is for a regular agenda, then we would start with item number 9, and I'd like to have Bert and or Larry give us a little bit of background on this item.
Before we move into these items, item number 12 has asked for the continuance.
My apologies,
to the
Bert,
June
yes.
25 meeting.
Okay, before we start the regular portion, we do have a request for a continuance for conditional use permit at 1401 Buchanan Street. Thank you, Bert.
And they've requested the continuance because they're still in the process of having an audit done, and the audit will determine whether or not they're a limited food and retail sales establishment, or if they need to be renoticed as a liquor store. So
Is this the first time this would be appearing on the agenda here?
this is
Okay,
be the first continuance on this
okay.
item.
All right. Any questions or thoughts from the board?
Which item was it?
12,
Item 12.
1401 Buchanan.
Do we have anybody here in the audience that wishes to speak against item 12? Because if you come down today, we'd be happy to hear your comments for a few minutes if you have any concerns. Otherwise, we may look at continuing this to next month when we have some more information. Okay, don't think we have anybody there. A motion for continuance then?
Mr. Chair, I'll move to continue item 12 to the June meeting.
And do I have a second? All right, thank you, Dave. Motion and a second. All those in favor to continue item 12 to the June regularly scheduled Board of Adjustment hearing, raise your right hand, say aye.
Aye.
All right, motion passes unanimously. Okay. All right, so now, for getting back to the items left on the regular portion of the agenda, we would be starting with item 9. And I'd like to have Sue Ann give us a little background on that, why we are here today.
Chair, members of the board, we are here at the behest of council, who has remanded this back to the board for reconsideration. In order to go through the reconsideration, I thought I would just do a presentation to the board, similar to what was previously
Okay,
presented.
appreciate that.
So here, to start with, is the remand from council, asking that the board reconsider this. As a result of that action, we renoticed the people within 250 feet. So here is our current consent map. I'll send around the cards that were received. As a reminder to the board, here are photos of the particular structure in question at 1617 Oakland. The brief history on this is that Harbor of Hope previously owned the structure, and it was granted a variance from separation of other supervised group residents in order to run a supervised group home in this structure. The Board of Adjustment attached a condition onto that approval for the variance, stating that the variance elapsed when the Harbor of Hope moved out. Harbor of Hope relocated. The structure stood empty for a number of months, and then Kelly Wolfcool bought it. When she occupied it, it came to the attention of staff. There was a neighborhood inspection division inspector in the area who talked to her and told her she shouldn't occupy it until she had proper authority, either through zoning or the rental certificate process. Should be noted that this property was downzoned. It's now an R160 lot. There are certain things that are allowed on the R160, single-family dwelling, supervised group home as long as it's not within a quarter mile of another home, supervised group home, and it does not meet those requirements. Ms. Wolfcool actually occupied the structure as a correctional placement facility. March 29th, we sent her notice saying that she needed to bring it into compliance with zoning requirements. She came in for a pre-application, and that is exhibit number 1, is that letter of March 29th. Exhibit number 2 is the pre-application site plan conference minutes. That's exhibit number 2. Kelly did come in, Ms. Wolfcool came in, met with staff about how to legalize or legitimize the use of that structure as a proposed transitional housing recovery center. It's always been a little difficult in dealing with this case, trying to determine exactly what she wants to do with it. It did come down that it was going to be occupied as a correctional placement facility. And through that process, she went into a rezoning process. At one point, she wanted to do it half correctional placement, half supervised, sort of a combination use, and we told her that that was not going to be possible. So she was sent another letter on August 26th stating that she couldn't do that particular use. In the meantime in there, the structure lost water service and had a water main break and was vacated. We informed her on April 26th of 2013, and this is exhibit number 3, that she couldn't reoccupy the building. Now, she had told people at pre-application that she wouldn't reoccupy it until the zoning was brought into compliance. She went ahead and reoccupied it. We also have, in order to bring this into compliance, we had rental code issues. So we did a rental code inspection to make sure that the people who were in there that we were having trouble getting out of there were safe. We got an order against her to vacate it. She didn't do it, so we went in and got an order granting the plaintiff's motion to vacate the structure and for a writ of removal. That's defendant's exhibit number 5. It's still occupied. Part of that order was that she was going to prove to staff that it wasn't being operated as a supervised group home. I'm still not convinced she's not operating it as a supervised group home. In fact, at the last hearing, she had told the board through her attorney that she had taken down the website for one-way recovery. And Mr. Hildebrand had brought in a copy of the website that was up on that date. This is the copy of that. I confirmed it was still up during that date. So she was still advertising at that point that she was one-way recovery. Exhibit number 6, these are, for sort of the accumulation of facts. She has a Facebook one-way recovery. It is still up and running, where it says One-Way Recovery is a nonprofit organization created to help men who are recovering from substance abuse. We provide a safe and structured environment for men to live and seek skills to successfully recover. So that's still up and running. On her webpage, on her Facebook page, she says that she is nonprofit organization management. One-way recovery again, that's exhibit number 7. She on her LinkedIn pages, she says she's one-way recovery director. Exhibit number 9, again, executive director of one-way recovery. This is her, this was her LinkedIn, this is her Facebook page. She has up on the Des Moines meeting schedule for AA that she does AA meetings in this on Wednesday nights. That's exhibit number 10. On May 16th, I printed off the One-Way Recovery Facebook page, and it said at that meeting they're going to discuss having man-to-man talk with your daughter date. That was part of the meeting that was first scheduled for that particular AA meeting, I believe. It's a little hard to figure that out, but this stuff is all over the web that she's still doing meetings there. Exhibit number 11, she has she has tax exempt status for this property. So she is holding out still to the county that she's getting tax exemption. She doesn't pay taxes on this property as a charitable exemption under property taxes. It troubles me as a zoning enforcement officer that she says she's going to be a boarding house, but she doesn't act like a boarding house when she holds herself out to the public online. Council remanded this with what I took from sitting in the audience listening to it, upset that this wasn't going back to the R160 district regulations and being occupied as a single family, or at least under the R160 district regulation requirements. Staff thought a boarding house would be good. We've stayed with that staff rec. That's what's before you. I, as the enforcement officer, I'm not convinced that this will be a boarding house if she gets the boarding house use. So that's where we're at. You are charged with reconsidering this.
Questions for Sue Ann?
The council sent it back to us to reconsider. What was there's nothing in my notes saying why they did it. Was there any specifics?
My best recollection is Councilmember Moore was upset that he believed that she had provided falsified documents during the rezoning. What I believe that she did was she had signatures on a petition that she submitted to the Plan and Zoning Commission, and she had taken that list, handwritten it for another hearing instead of having the original signatures submitted as the document that was the petition.
And that was a list for what?
Or people saying that they supported rezoning.
May I step in? I wasn't at the meeting, but I did see it on the video, and I don't recollect that being part of the conversation at the council at the table. So that's not part of the official record then. I just want to make that clear.
Okay, and then the exhibits you showed us, the Facebook and LinkedIn, does it connect specifically between what her profession is and this facility, this address?
She's held this address out as one-way recovery. She holds it out in the meeting places for AA, that one-way recovery is at this address. These are sort of links that she holds herself out as being the director of one-way recovery. She goes on the AA website and says, we're having meetings at one-way recovery at 1617 Oakland. So,
Suann, my question is, and I don't see it in the paperwork today.
Turn your mic on, Linda.
At the last meeting, when you looked at the police records that you provided to us, there were quite a few police calls to that address. And I just hope that we can maybe see those again. I don't see it in the packet today, but if our fellow board members will recall, there were an impressive amount of police calls to that address, if I'm thinking
I'll
of
see
it
if I
correctly.
can find it.
And Linda, you're not just stating the within the 500 feet radius, but specifically at that address?
Specific at that address, I believe. As I recall, that's,
And I'm not finding that
Okay.
piece of paper right now.
We can maybe come back to that.
yeah,
I'll keep looking for it.
I saved it, but I just didn't bring it.
Sue Ann, when I think of a boarding house, this is a statement and then a question here for you. When I think of a boarding house, I think of a place where people are just living temporarily. Maybe they're a student teacher for a semester. Maybe they're a nursing student at Mercy. It's where people, for non-related reasons, would lodge temporarily. You know, they rent a room, basically. That's my understanding of what a boarding house would be. Is that the general definition or thought process as well?
That's what we would consider boarding house, is that you have a room, you rent, you may have shared kitchen facilities.
Okay.
But you have a private room of your own.
Right.
That you can rent and
Right.
come and go as you please. No hours, I mean, you're just, that's
Sure.
your space.
Sure. With, and even with the concern by the council, my inclination at our last hearing was, well, if this operates as a boarding house, it's a very large structure, I wouldn't maybe see that kind of concern with it. But what I do see with what you've presented here, and this is my question, when we talk about one-way recovery being like a term, a nonprofit leading to, group living where people have needs and concerns and are recovering from various ailments, that's not what I thought this was about. And with what you just provided, I don't think you had or we saw some of those exhibits last month, did we?
The unfortunate thing last month is that I didn't realize that the website was still up until the
Exactly.
meeting was closed.
Okay.
And you
Right.
guys were in consideration,
Sure,
and
sure.
there's always that protocol.
So with council asking us to look at this again, you have some new information which we did not have to consider during our deliberation last month. Is that correct?
Correct. I was under the impression that she had taken down those websites and that it was no longer being advertised as this place was being used for this.
Right.
I'm now concerned when I go back through
Sure.
websites that she hasn't stopped the use,
Yeah.
that it is still.
And when you look at a boarding house or a bed and breakfast or even a multifamily unit in general, do they usually operate as a nonprofit?
No, those wouldn't be nonprofits.
Okay,
You get nonprofit status if you are providing services but you're not making money for it.
Right.
At a boarding house, it's a landlord-tenant relationship,
Yep.
and you would be making money.
right, okay. Any other questions for Sue Ann? Okay, all right, we may come back to you. Okay. Anything else from staff? All right, so with those opening comments from staff, the appellant or the appellant's representation, you have 10 minutes.
Mr. Chairman, members of the Board of Adjustment, Dan Manning, 317 6th Avenue, Des Moines, Iowa. Representing the applicant, Kelly Wolfcool, the owner of the property at 1617 Oakland. I'll start by saying that we made a detailed presentation and representations to you at the last meeting, and I was handed this packet of information from Sue Ann right before this hearing started. So much of the information in the packet that Sue Ann has provided to you has already been provided, already submitted, already a part of the record in this case. And what I would point out, I have the utmost respect for Sue Ann, but I understand in these reconsideration situations that she works for the city, she's a staff, works for the city as well, and I think there's a significant amount of pressure to try to alter the decision that this independent board made last month. And I just simply ask that you consider that as you look at these exhibits, because they're much of the same information. Now, I'd like to go to this additional information that she has submitted. And I want to put this in context. We didn't spend a lot of time talking about this at last month, but we have pending litigation because we don't necessarily agree with the staff's interpretation of how this property should function. Kelly Wolfcool purchased this property from Harbor of Hope with the clear understanding, maybe she was mistaken, maybe she's right legally. That's what is pending before the district court. So it's not inappropriate for her to continue in the status that this property had before she bought it as to the issue of whether this is or is not exempt property. It's not proof of anything to submit to you as is submitted in Exhibit 11, the status of this property imposed by the assessor's webpage. It's not something that she understands. I understand that if this body stands with the recommendation that was made last month, the pending litigation goes away, and she will operate this facility as a boarding house, and she would not be entitled to any special status if she were able to operate as a boarding house. These other references in here, and I'm kind of going, I started with Exhibit 11, which I think was an important item for you to consider, because it's like, aha, you're holding this property out as exempt property. Well, that's the status that it already enjoyed when she purchased the property, and that's the status that she believed she had and it was entitled to. We understand that that status will change in the event that it's upheld as the decision to uphold this as a boarding house. These other exhibits, there is no reference to 1617 Oakland as, or let me put it this way. We made certain representations and promises in 2013 that we would operate this as a boarding house. We agreed to inspections. We agreed, and we're upholding that status. That's exactly how we've operated that property since at least October or November of 2013. And this AA form, that's something that was printed. I just got it this morning. I talked to Kelly. Kelly tells me that's printed, as I understand it, once a year. There aren't any AA meetings being conducted there. And that's, that's an important factor, I think, as you analyze whether this matter should be reconsidered or not, and whether this particular whether anything has really changed since your meeting last month. I think the innuendo from the documents that have been submitted by Sue Ann is that, aha, we've caught Kelly Wolfcool doing something other than what she professed to do. And that's just not true. Now, one clarification is that on the date of this hearing last month, I believe I came up to this podium and represented that the web page was down, and it wasn't down. Information had been taken off of the property. I didn't know it until the end of the meeting myself and talking to Kelly, and the next day it was down. So I want to be clear. Sue Ann is absolutely right that as of the date of this hearing, that one-way recovery webpage was up. A bunch of information had been taken off of it. Kelly understood that was what we were asking her to do, and we made it very clear. I made it very clear. Take it down. It's been taken down. The other thing is to what was any sort of directive. As an independent body, I would caution you, I think you know this, but I would just simply want to make sure it's part of the record, is that we stand with the record that was made here. I was present at the city council meeting, and there was no additional information presented other than one of the former members of the Board of Adjustment, who is now a city council member, I think understanding his role, understanding the role of the Board of Adjustment, was simply to remand this back and give it every consideration as to whether this was the right thing to do. That's the only directive that I saw, the only appropriate directive that the council should be giving you, and that they did give you. but there was no underlying, we want you to check A, B, C, D, and E. And
Right.
I think that on her Facebook page, Exhibit 9, there's no reference to one-way recovery. One-way recovery is a legal entity that still exists. She's still the director of it. She's not referring to 1617 Oakland in that Facebook page on Exhibit 9. So I guess it's important from my standpoint as a person who's going to stand before you again, is that nothing has changed since the hearing last month. Nothing has changed. These documents may refer to one-way recovery, but there's not an effort to advertise, to hold herself out as operating one-way recovery at 1617 Oakland, which is the subject of this conversation. What we did submit to you last time, and what is a part of the record in this case, is that we have affidavits from individuals who have established that they send people to that site with the understanding that there is no type of correctional care. There is no type of supervised group residence being conducted there. And so we simply ask that as I recall the chairman saying last time, this is a tough call. These cases always are. This is a 6,000 square foot building that simply can't function as a single family residence. It being boarded up is not the answer. The solution that was thought through, talked through, deliberated, and that we concurred in, when we started this application, we were asking for 27 residents. We're now talking about 9. And we simply, we want to make it clear for the record that there is nothing that's changed, and that the recommendation and the decision of the board is something that we'd ask that you uphold. Do you have any questions for me?
Yes. Questions for Mr. Manning? Brooke?
On the AA mailing that you, where did that come from?
It was, I'll let Kelly answer that directly because I don't know, Mr. Rosenberg. But what I've been told is that it is prepared once a year, it is submitted. It was prior to the commitments that we've made to make sure that that facility is only used as a boarding house and not any sort of facility for supervised group residents. Come on up. Mr. You heard Mr. Rosenberg's question. Address the board and answer the question.
About the AA pamphlet?
Yeah.
Give him your name and.
My name is Kelly Wolfcool. I live at 1306 Southeast Trilene, Ankeny, Iowa. It's printed, I think, once or twice a year at the central office. And so I haven't notified them to take my address off of the list. And that was just an oversight on my part. They're not holding meetings there.
No, I'm just curious how it was
Yeah.
distributed. Thank you.
It's printed only a couple times a year and distributed, at various sites.
Okay, further questions?
Excuse me, I've got a question. You mentioned that one-way recovery, she's still the director of one-way recovery? Where do those meetings take place, or where's the business function?
About 12 weeks ago, I took a position as the healthcare administrator for City View Residential, and I'm in the process of purchasing that business, and it's going to be one-way recovery doing business as City View. So I'm taking One-Way Recovery, the nonprofit, with me. That's just the name of my company. It's not the name of 1617 Oakland. The name of 1617 Oakland now is the house, the boarding house. There's no name. And, the men live there by themselves. I'm not even there. I'm a landlord. I haven't even been to the house.
Who stays there as the manager then?
There's a house manager. His name is Brad Wood, and he takes care of everything. If they have some kind of a problem, landlord type issue, then they would call me. Otherwise, I'm not involved at all. Since this last hearing here, I have not been involved at that house. I made sure and I made clear to the residents that I cannot be involved. And that breaks my heart, but I did it.
Well, I think that was part of the requirement we had. It's just, this is really confusing to me, because it seems like there's a lot of evidence at Sue Ann, and I'll just say, I think you inspect what you expect, so thanks for doing what you've done. And I don't know that this isn't a witch hunt. I think the information that was presented to us at the last meeting is far different than what I've seen today, which to me is pretty disappointing. Your name and everything is affiliated with an organization that had functioned there, or that you intended to function there, and it doesn't look like you've done anything to dispel that to me. So it's pretty easy to come to some conclusions that may or may not be accurate. That's just my thoughts.
Thank you, Dave. Kelly, you mentioned that Brad Wood is kind of the resident manager?
He's the house manager.
He's the house manager. Do you pay him?
No.
No, so he just stays at the house for free?
He has a reduced rent rate.
Okay. So with reduced rent then, do you have lease agreements with your tenants or
Yes.
contracts for that?
Yes.
Have you presented any of that information to this board to show how you're doing your leasing and running your boarding house?
Mr. Chairman, we did submit that at the last meeting.
Okay.
We sent a lease, provided a copy
Okay.
of the lease that's provided.
So when they have a lease and you collect income for that, how do you report that income?
What do you mean? I file my taxes every year, and
Okay.
that's income that I would incur.
So-
I have other rental properties as well.
Right. So in running it as a boarding house, then you are, in essence, that's your personal income from that rental, and then you pay
I'm a
taxes on it.
landlord.
Okay. So they don't pay it to any other entity or to the nonprofit you're affiliated with or anything like that? Okay. Do you have any examples or evidence of any advertising or other notifications you've provided that these rooms are available for rent? Do you have some network of how people learn that you have a boarding house?
I actually do not advertise at all.
Okay. You do it by referrals
It's
then?
mostly word of mouth.
Okay. All right. And something Mr. Manning said, that it was your intention since October, November 2013 or so to operate this as a boarding house. Is that
Yes.
correct? Okay.
I have been steadily, working towards that.
Right. Do you currently have a certificate of occupancy for rental as a boarding house?
No, I've gone through the inspection and I was waiting for my occupancy permit.
Okay. Was that contingent on some other physical things you needed to do, or is it more contingent on?
I think it's
On this.
contingent on this hearing.
Okay.
Because everything that I have done is in response to what I was told to do.
Okay. All right. Thank you.
Mr. Chair, I have a question. There was some discussion on the tax-free status of the home. Is that still in effect? I know you mentioned that there was going to be some changes to that. Have there been changes to that?
No, on this particular property, I would pay taxes just like anyone else,
So
just
it's,
on a rental property.
so it's no longer under a tax-free
No.
exemption? So when,
Since I have owned it, it has not been under a tax exemption. Had to pay taxes,
So you've paid taxes since you've owned it?
yes.
Okay, that's a clarification then.
I went before the board and asked them to consider me for an exemption, and I did not get that exemption. I've paid taxes.
Okay, well, Kelly, perhaps you can read this better than I can, but you can see Exhibit 11 up here.
it's
It,
charitable.
it shows a negative value there that, I guess, what I would understand from that is, no, there are not taxes being paid, unless somebody can help me read that a little bit differently than what I'm seeing.
Paid the taxes. It was $1,600 the last time. I paid it. Harbor of Hope was tax exempt, but I have not been tax exempt.
And you owned it since when?
November of 2012. And I have been responsible for the taxes since that time.
Okay. Larry, do you have a comment?
Yeah, there's a few things here. One is the question of, do you have a CO for this purpose of boarding house? And what's happened with the council remand, the use variance has been delayed 30 days. So they can't get a CO until
Gotcha.
the use variance comes into effect.
Right.
And as to the taxes, fortunately, you don't have a tax statement, but I'm not really sure how relevant that might be, because as Mr. May indicated, they do have ongoing litigation as to questioning the status of being I think a correctional placement, having some rights still there. But when this does become a boarding house use, it will be taxed. And from that day, it will be crystal clear that it is a taxable property.
Well, I got a question just for
Yes, Dave,
clarification.
go ahead.
then. At the time it was sold, the status changed from the previous owner. Wouldn't that have also affected the?
Well, and this may be.
Everything else, or is that
Sue may
just
need to
semantics?
explain. Basically, this was purchased, and I believe Ms. Wolfcole, as the purchaser, thought it had an ongoing status as a correctional placement center, but it had lost all grandfathering rights. And Sue had the determination that it was not a correctional placement center, and so I don't think there's really much dispute on that, except for they did appeal, because this did come before the Board of Adjustment in last August. Yeah, last August for that, for the request to, use variance to become a correctional placement facility. And that was denied by this board, and they have appealed that decision. In the meantime, in terms of trying to find a way that potentially could use the property, they've now applied to be a boarding house. So.
Any other comments or questions?
I guess one more question. The only thing that ties your business or your professional business to this property is that mailing from AA? Did your Facebook or LinkedIn of yours have any?
The house or the address. It
Okay.
has one-way recovery,
Yeah.
which
But-
is my organization,
Right.
and I can operate that.
But it doesn't,
Kind of a
it doesn't give the address or anything. This is the first time I've seen these exhibits. They weren't passed around. I don't see where there's a big difference here from what we were represented the last time, except that obviously the council sent it back to us. I'm a little perturbed that the applicant didn't get the packet of information till today. I don't think that's fair. I've commented on this several times in the past, and I don't see how they can properly present their case if they don't know what's being held out there.
Kelly, just a brief question. I'm just trying to understand the character here of what's going on at the house. Without any names or any big detail here, do you know anything, the general background of the folks who are renting from you now? Are they nursing students? Are they construction workers here on a new building renovation project? Any idea?
They're basically folks that have no place else to live,
Okay,
and they need a place to lay their head at night.
okay,
And they work. All of
Okay.
them work. They have to work.
okay. And you receive no direct payments from any governmental entity or any social service program? Any
Not-
goodwill grants from any philanthropy groups?
It's not allowable because I don't have a
Right.
occupancy permit.
Okay, all right, thank you. Okay, I think at this time, unless anybody's got any other questions, at least for the time being, we'll go ahead and hear from some of the other folks here that may have some comments on the request here today. Thank you. Is there anybody else here to speak in support of the appellant? Sue Ann?
Chair, if I could
Yes.
correct one thing, it does
Yes.
appear that she paid September's taxes in the spring of this year. So
Okay.
she is paying real estate taxes.
Okay, so
I'm not
even
sure
though
why
the-
it's listed on websites
Right,
as
right.
tax exempt, but I wanted to clarify
Right,
that.
and we realize sometimes what the county shows isn't always the same things that the city's concerned about.
Yep.
So there are real estate taxes being paid at this property. Okay, thank you. Okay, anybody else here, or is there anyone here to speak in support of the applicant? Is there anybody here to speak in opposition to the applicant? Okay, you'll have 5 minutes each for any comments. I would suggest, if there's more than a few of you, just to line up against the wall here. And again, we'll need your name and your address.
Mike Hildebrand, 410 Franklin Avenue. I'm a resident of the Riverbend neighborhood. I'm also on the board of directors. First thing I would like to ask, if it pleases the board, can I
Yes.
avoid having every one of the residents that took time out of the day to come up here and speak, to just raise their hand for recognition and avoid all of them coming up to speak?
If they're interested in having you speak for them, they can certainly raise their hand. Okay,
Thank you.
all right.
Secondly, I received an email from a resident that couldn't make it today about
Sure.
2 hours ago, and I'd like to submit that if that's at all possible. I made copies as well as, I got 9 copies.
Are these all the same?
Yes, they are. And I would like to, if possible, clarify a position that I held at last hearing, because I think it directly impacts
do.
this hearing.
Okay.
I was asked what I thought should be done with the large structure.
Right.
I do take exception to it could never be a single-family home, but we're not going to debate that.
Okay.
We're on different ends of the spectrum there. But what I said at the last meeting, whenever I was asked by one of the commission members, I made a statement off the cuff, no research. Personally, I thought I did well clarifying that was my personal opinion, and that personally this is what I would consider. I thought I did a good job of that, but at the end, whenever the decisions and discussions were being made, that was brought up. And so I want to make sure that that personal opinion was no research, my personal opinion, and does not hold true today. Because I would expect that I would be treated no different than any other resident in our neighborhood. So if the neighborhood opposes rezoning or variances for this individual, I guarantee you they will oppose it for me. So anything that I would plan to do with a facility like this they would be consistent. There would not be any favoritism or any, well, Mike wants to do it versus Kelly wants to do it. So what I said I wanted to do would not have fallen underneath the R160, so that would not have flown with the neighborhood.
Okay.
I think we get on a slippery slope if we start making exceptions for people who've made bad business decisions or poor judgment or just didn't understand what they were getting into. We'll have a smorgasbord of zoning and use in the neighborhood. And we'll start chipping away at the years of work that our neighborhood association, as well as the other commissions and boards, have worked on. So I think we need to be careful with that. I have as much compassion as the next person, but I don't think we can base decisions on feeling badly for somebody making bad decisions. I guess the final thing I'd have to say is, I think it was very apparent here today with what Sue Ann presented. Kelly is, I'm certain she is a great person in the treatment facilities. I can't really question her business abilities, but I think it's a sort of a common theme that Kelly doesn't focus on the business aspects of things, and there's a compliance issue for the past 19 months. I don't expect that to change, and I think it'd be a disservice from this commission to grant something and pile more restrictions and more requirements on top of that, because I think it's setting Kelly up to fail. So that's why I personally, as well as speaking for the Board of Directors of the Riverbend Neighborhood Association, supports the R160 zoning of the property with no variances. Thank you.
Thank you, Mike.
Questions?
Yes, any questions for Mike?
Thank
Okay,
you.
thank you. All right, who's up next?
My name's John Larson. I live at 306 College, and I guess he said a lot of stuff that I was going to say, but I was just going to let you know that since this has been going on and there's been a lot of shady activity at night going on, and I have kids, and if this goes through, I'm moving. So I just want to let you know I will be gone. I'm not in favor of it.
Okay. Could I have staff put up an area map? So John, could you show us where you live in relation to the property in question? Thank you, Sue Ann. Just maybe that consent map would work. Can you point to where you live?
Right here.
Okay, where the red is.
And that's
Okay.
right where
Okay.
all the activity comes, and everybody that comes down that driveway, and
Okay.
I got people lurking around at night, and I'm not going to put up with it.
Okay,
So
All right,
I will
thank
be
you.
moving. So.
next.
Hi, Carolyn Jennison, 1330 Ninth Street.
Mm-hmm.
I have been a resident of Riverbend for 15 years.
Mm-hmm.
The great people that have joined me today are many of the people that I talked into moving into our neighborhood, and many who have been there before me. What we did was, when I came into that neighborhood, there were a strong group of volunteers that we worked together to make the decision, not based by city, but we chose as residents to change the zoning to R160 to protect our investment. We did that, we walked the streets and made that happen. As representatives of your citizens, we ask that you honor that. This new group of people have gone even further and turned it into a local historic district. These were improvements that your residents made, not you, your residents. And so you honored those. And so what I'm asking is, 10 years ago, I sat in this room, and another individual came in and didn't do their research very well, or did, but we're gonna ask for forgiveness and not permission. She asked for permission. We guided her. And I'm going to ask that you not have us sit here and do this again, for you to not honor that group of individuals that have worked so hard for one person that doesn't even live in the city. So I'm asking you not to repeat history. I'm asking that you carry forth your duty to represent the citizens of our city and honor their work and their desires to continue to improve our city.
Thank you, Carolyn. Mr. Thompson.
Roger Thompson, 2000 Ninth Street. First of all, I'd like to apologize for my appearance. I just found out about this right at 1 hour ago.
You're talking about your
At
shirt,
work.
right?
Yeah.
Okay.
I have been involved in Riverbend for 18, 20 years, way, way long. And my point in the neighborhood has always been law and order. We have to have rules as a society. You look at the inner city of Des Moines, and you see one neighborhood stand out with a low crime rate, and that's Riverbend. That's the work we have done. I feel sorry for this lady that didn't do her due diligence, but failure for her to do due diligence doesn't give anybody the right to victimize the people in my neighborhood. It's my understanding there's been a lot of rule violations. Even when called on it, there was more violations. If this goes through, I don't think rules mean anything. Thank you very much.
Thank you, Roger.
Laura Hanson, 1828th Street. I just wanted to comment on, it's been brought up about the square footage of this residence and some concerns about what could it be used for. Certainly there are properties in Sherman Hill of large square footage. We have houses in Riverbend that have been converted from apartments housing 12 people into a residence of 4,500 square feet with 2 residents. I think that there's been great strides in Riverbend. I've lived there for 10 years now. It's an awesome group of people working together to really improve this neighborhood. And when I see the downtown and the East Village neighborhoods and the housing boom and the apartments and the condos, I wonder then about those young people then when they start to be looking at houses and for families, is it unreasonable that a family might not want with several kids to have a house this size? Or what is happening with the zoning is I want to stay in Des Moines, but I can't because I can get a big house with big square footage out in the suburbs. And I think it really does a disservice to say a house like this needs to be turned into a boarding house or it has no other use. I certainly have concerns and would reiterate when we have an individual who has not been compliant with what the board and the commission has asked her to do and is a constant cat and mouse game, frankly. I certainly don't want to be the neighbor that's putting up with that. And I ask you to think about, is that the kind of neighbor that you would like to have next to you with now what's being proposed as a boarding house with 9 residents? Thank you.
Thank you. Yes, sir.
I'm John Royal, 1838th Street. I live in a house built by my great-grandparents in a neighborhood. And my mother was one of the founders of Riverbend who sat on the street corner with the prostitutes to chase off the Johns. So I've gone through it being a very nice middle-class neighborhood to being a pit to coming back. The new zoning has been one of the things that's helped in trying to recover our neighborhood to back where it can be nice, comfortable living. When my children lived with me, and I was divorced, they lived half the time with me and half the time with their mother. When my son turned 14, he could no longer have his friends come in from West Des Moines because their parents wouldn't let him because of the neighborhood reputation. So we're talking about real things about attitudes and stuff like that that happen in terms of communities, and we have been overburdened with density of population for a long time. We've been trying to correct that problem and move back to a reasonable balance. We are the most diverse neighborhood in the community and very proud of it, and we work well with that. So it's not about not wanting diversity, it's about wanting balance in that process, and we have a difficult time maintaining that. Additionally, it's about economics. I have a house built in 1887. It needs a new furnace. My furnace is 60 years old. It needs a garage. I'd like to build a carriage house so it was consistent with that. All those sort of things. My house in West Des Moines would be probably $350,000. It's $112,000 or $120,000 on the assessed value. When I try and go get a loan to try and do those sort of things, then I get into problems with that. So we're talking economics here of how do we increase the neighborhood and value the neighborhood when we're taking the projects and making undervalued because we're taking care of somebody else's business decisions. So it has real impact on us as people to try and upgrade the neighborhoods. Thank you.
Thank you for your comments.
Good afternoon. Brian Bai, 523 Franklin. I sit on the neighborhood board, and I also am a commissioner for the Historic Preservation Commission. First of all, I also do not support, well, I support maintaining the zoning that is today, and the consistent compliant issues also from the local historic district perspective, not going through the proper procedures to do that, and then, oh, okay, I guess I have to do that. So all of that aside, there is still, we heard today that there was nothing linking the house with one-way recovery, the address linking one-way recovery. I pulled it up on Facebook. I'm happy to show it to you. That's probably, let's just pass it all around.
They might be able to focus
Maybe
again.
able to zoom in.
Oh,
Can you
great.
zoom?
There we go.
There we go.
Okay, One Way Recovery, nonprofit organization, 1617 Oakland Avenue, right there. So there's a description of the organization attached to that site, which was misrepresented. What's that?
What was that on again? What's that?
That's on Facebook, where it is being advertised as a nonprofit organization. For many of us, it is much more important than a website. It is a way to communicate
Right.
in ways that websites aren't. So, again, just continued frustration with misrepresentation of facts, and I would encourage you to deny city staff's recommendation.
Yes, sir. Go ahead.
Good afternoon. My name is Aaron Tide. I live at 803 Hickman Road. I'm also on the Riverbend Neighborhood Association Board, also serve on the Historic Preservation Commission. But my main point is that this has taken up a lot of people's time. We have worked really hard to make changes in the neighborhood, one of those being rezoning, one being local district, and others. And we really need them to be enforced in order for our neighborhood to take the next step. As residents, you can see how committed we are to this, that we've spent 18 months dealing with this issue. And every time a decision is made, something has not been followed. And the reason why we end up back before boards and commissions and back before city staff is because something's not being complied with over and over again. It's a pattern that's been repeated month after month. And so if we don't go back to what it's supposed to be, we're just going to keep doing this over and over again. We're exhausted by the process. I'm sure she is as well. But we're tired of chasing compliance. And we would like this to be settled. We'd like it to be the right decision, which is the policy that was set by council.
Question.
Yeah.
Were you at the last meeting? I don't recall.
I was not.
I only recall one of the gentlemen at the last meeting. Can you tell me why there was such a crowd today and not at the last meeting?
I think just the word has gotten out that we should be having more people at meetings. So we spent a lot of time discussing and deciding strategy and communicating with council and communicating with staff. And when meetings are at 1 o'clock in the afternoon, it's pretty hard for people. I personally work for the legislature. Until we adjourn, there's no way I can make these meetings, even evening meetings. So my schedule is now free. The communication is out to the neighborhood, and so we're showing up.
There was the same communication that went out the last meeting. I'm just
It's one of
trying
those things where it waxes and wanes. So 18 months. How many meetings? I mean, we should count up how many times we've met with staff. We met with Kelly a few times. All the communication. Eventually, like, I'm not going to another darn meeting. We've had enough. So you end up at just different points where we have more people showing up and fewer at other times.
Okay, thank you.
Thank you. Anybody else to speak in opposition? Okay, before we give the applicant a chance for rebuttal, I would like to ask Sue Ann a question or two. I'll give the appellant a chance to comment on anything mentioned here. Sue Ann, they need to have an occupancy certificate, an inspection certificate, correct?
They'll need a rental certificate.
Yes. They don't have one now?
They have the inspection, but until
Okay.
the zoning determines what it's going to be through
Right.
these processes,
Yep.
we're holding this rental certificate.
So how are people allowed, she has leases, she has tenants, people live there, how is that allowed to continue? Is there some continuance from something before? Or is that just an assumption on their part?
You have two different code sections in play.
Okay.
You have Chapter 134, which is the zoning part of it.
Mhm.
We have Chapter 60, which is the rental inspection.
Right.
We filed a civil infraction in the rental inspection
Yes.
side.
Yes.
We got an order to vacate.
Right.
She didn't. We did an
Okay.
application order show cause why she shouldn't have to
Okay.
vacate. We only entered a consent agreement with her, which is in the packet of materials.
Okay.
Saying that she had 60 days to vacate unless she came to the board for
Got it.
a use for a boarding house and proved to our satisfaction that it wasn't being operated as a supervised group home. That 60 days lapses tomorrow.
Okay.
If we're not satisfied that she's operating it in compliance as a boarding house, we will go and ask for the writ of removal.
Okay. So kind of in a way, they are allowed to be there at this time,
Till tomorrow.
till tomorrow. Okay.
And then we'll have to decide, based on the information that I've found, I'm not convinced that it's not being operated outside of the confines of our agreement, which was a boarding house.
Okay. All right. Thank you. Okay, since I got Sue Ann up here, any questions for her? All right, thank you. Okay, applicant, you've got 3 minutes for response rebuttal.
Mr. Chairman, members of the board, Dan Manning, 317 6th Avenue, Des Moines, Iowa. I guess I'd like to just, from an overall standpoint, when this property was purchased in October of 2012, Kelly purchased the property, put approximately $60,000 in the property. The property has never, since Harbor of Hope was in the property's never looked better. We've allowed the city in to inspect it. They say the same thing. I've asked Sue Ann Donovan to come and take a look at the property to see for herself, because the standard that we agreed to was that she'd have to be convinced that we're not operating the property since the fall of 2013 as anything other than a boarding house. The information is provided to you. The only additional information is not proof that anything has changed. We're representing to you that nothing has changed. I say nothing has changed since the fall of 2013 in terms of how we're trying to utilize this property, and that is as a boarding house. The only thing that I've heard anyone say, and from our perspective, is that, we certainly respect and understand that the Riverbend folks want and have worked very hard to improve this neighborhood. We see the effort by Kelly is to improve her home, which helps improve that neighborhood. And we believe that the decision that was made last month was a sound decision that would be beneficial to the neighborhood. I can only emphasize again that the effort being made to operate as a boarding house is something that we took seriously when we made the promise to Sue Ann that we would operate it that way. Nothing that's been presented changes that. You may ask a question or two as to why do we still have these lingering references to one-way recovery, but we're not operating it that way. We asked that certain representatives of the Riverbend neighborhood come and inspect the property with myself and Kelly, and I believe they took us at our word. They didn't want to inspect the property because we were living up to the representations we were making. We simply suggest to you that simply because this matter was remanded doesn't require a change, that the decision that was made was a good one, good for the neighborhood and good for the property owner. And by having a property that they can have some income from, they can continue to maintain their property and keep it in the manner in which the neighbors want it maintained. So we would ask that the decision be made to support last month's decision of this board.
Okay.
Thank you.
Thank you, Dan. Any other final questions for Dan? Okay. Sue, I have another question for you. I think this is just a brief one. I don't think this will surprise Mr. Manning or his client. If we were inclined to approve this, subject to the staff recommendations, is that like a 30-day clock? If we approve this and they don't come up with a rental code inspection certificate required by Chapter 60 within X time, does the whole conditional use permit then expire?
They have 2 years.
They have 2 years.
The condition, unless you put a.
Other conditions on
other
it?
condition for time.
Okay. Larry, do you have something you'd like to add to that?
But Sue, it'd be fair to say they couldn't occupy it legally until they got that rental certificate, even
That's-
under the use variance.
That's what I'm getting at.
Correct.
Okay. So how soon, yeah, so she wouldn't be able to, until they get the rental certificate, they could not live there per se, but they'd have up to 2 years to get all that figured out. Am I
Well,
correct?
we have an order under
Right.
Chapter 60 to vacate unless they prove to our satisfaction.
Right.
It's being used as a boarding house.
Okay.
I believe we're ready to issue the rental certificate.
You are, okay.
Because
all
they
right.
passed inspections.
Okay, all right,
So it's just the logistics of what they are
okay.
at this particular point in time.
Because whether this fails or passes, if it would be inclined to pass, I'd want to know that we get something and the place gets moving and things look good, and we've got a way to then measure and meter this going forward.
I would also, I believe that staff recommendation, although I don't have it in front of me, authorize the zoning enforcement officer to bring it back to the board.
Yes.
Should there be a belief that it's not being occupied as a boarding house.
That's item 5, the last condition,
Correct.
yes.
If
Okay.
you approve, if you reapprove what you approved last time, that would still be in place.
Okay, thank you. Okay, I think we have followed our due process for input. Now it's time for ours. So we'll close the public portion and go to board deliberation. I need to have some good discussion on this.
I was opposed to this 13 months ago. I was opposed to it every single time that it has been brought before us. I'm opposed for it today. I am so happy that the city council asked that this be brought back, because I just believe that we needed to hear the additional information. We have, thankfully, the neighbors were here today, but they have investments in their neighborhoods. We are all about listening to what neighbors want and what is best for the neighborhood. And to have somebody have a boarding house that's managed by somebody who gets reduced rates to live there. I remember looking at the police reports last month. There have been police calls to that residence for different things. It's not an appropriate place. It's not meant to be a boarding house in that area. This neighborhood, that house could be fine as a single-family home. Yes, I understand that you'd have to come in and do some converting, but ask the neighbors that have lived in that neighborhood. They have spent thousands and thousands of dollars in their neighborhood to make it better. Even if you don't take into account any of the dollars that have spent, our time is precious these days. Our time is worth a lot. And when you have a neighborhood that has spent so much time working on something to make their neighborhood so good, it would just be an injustice to let this happen.
Okay, thank you.
I urge my fellow members to vote against it.
I would concur with Linda, and I voted for it last time, but in hearing all of the new information, I'm a bit remiss in thinking that things would change according to what she says, how she says it would change. And there was a comment made by the applicant's attorney that, you know, this is good for the neighborhood, and I don't agree with that. And maybe it's good for the owner since she has invested some money into this property, but I think there's other uses for the property. And I just don't see it as good for the neighborhood. And I appreciate everyone's comments today from all sides.
Okay. Gentlemen, anything else?
No.
No,
It's been
this is discussion.
So we could have a motion.
Okay. Larry, hang on just a
Before
second.
there's a vote, I'd like to speak for a minute.
Yes, okay. Dave, any final thoughts?
No, I'm just, I'm confused based on what I'm told and then what I see. And 15 minutes ago, I'm showing a Facebook page and I'm told that there's nothing that's connected to this one-way recovery, and it's right there in black and white. We're told by people that it's not being operated the way it is. I just have, I've got some real empathy for the residents around there, because I think this is a tough deal, and it's, I'm trying to put myself in their shoes. So we've all got to vote.
Okay, thank you, Dave. Larry, do you have something you'd like to
Yeah, I'd
add?
just like to mention a couple things. These remands are relatively rare. They're just slightly different than what we do.
Here, let's put you.
I'm sorry. Basically, the city council remanded this for further study by the board. And that's what you're doing here at a hearing, further study. The council remand did not extinguish or terminate the existing variance. It simply delayed the effective date of that variance for 30 days so this board can act. So the actions before the board could be either to uphold the previously given variance or overturn or extinguish that variance as an alternative motion. And any of those motions would only require a majority of this group, three to five, because basically they've already have the approved variance on a four-person vote. So the uphold or the overturn could go on a straight majority. If no motion passes, the prior variance will be approved after 30 days.
Okay. So if we vote to overturn the decision from last month today, then with that vote to overturn it, it then fails and the use cannot continue. Is that correct?
Correct. And that would be the case.
With a
if it were-
simple majority.
Yeah,
here.
in original variance, that would be the case too. A no could be done by a simple majority.
Okay. Yeah, all approvals for something would take 4.
Right.
Correct, okay.
Right.
All right. Okay. We do have a motion on the table. I try to give people the benefit of the doubt when I can, with evidence provided to support their positions and their opinions, just the way that I approach these things in accordance with the variance standards we have. But when this was remanded to us for further study, and then I hear more information and I see more things, and I see more connections, whether they're real or perceived, they provide me with concern about the neighborhood, concern with compliance with the criteria that this board does have to consider. And when I see on a Facebook page that I know Facebook is something you can update at the moment, to think that this nonprofit, this Recovery in Action, which supposedly we're disconnecting ourselves from, is still being addressed as 1617 and probably has been updated recently. It's just kind of amazing how technology provides us with more opportunities, but also more evidence, and sometimes a trail that goes back to what's really going on. Whether it's intention, whether it's perception or not, I'm seeing too much here that tells me she has not separated herself from this property and what her intentions are. I just have not seen enough here to, in good faith, with this further study, I haven't seen any new evidence that we're running a really nifty little boarding house and we put an ad in the Drake newspaper, or who we have here. Apparently we have people with nowhere else to live, probably with very little income, and they're just kind of showing up here. That's really not what I thought a boarding house was supposed to be about. I thought you put an ad in the paper or you're somehow marketing this thing. If you're running through word of mouth and that's all we have, I didn't hear anybody who is a resident speak today. Usually that carries a lot of weight for me as well. So with what I would consider to be new information provided, I have some difficulty in further supporting this. So we do have a motion on the table here.
Is there a second?
Getting to that. We do have a motion on the table here. Is there a second for that? Okay, that motion is did you motion to approve it, Brooke?
Motion was to move staff.
Okay.
And I'd like to get a vote before 5.
Okay, all right. We're just going through the due process. I try not to say anything we don't need to. Okay, we've got a motion on the table. Do I have a second? To approve staff. Okay, motion fails.
I would make a motion to overturn the previous decision made by this board last month.
Do I have a second for that? I'll second. All those in favor, raise your hand and say aye. Aye. Okay, that motion carries 4-1. I'm sorry, Brooke, you didn't raise your hand, though. I apologize. So we have 4 that are voting to overturn? 4-1? Okay. All right, thank you very much. Okay, that's item 9. Let's move on to another item, item 10. I'm gonna duck out very briefly. If you miss this, 60 seconds. Yeah.
Did he turn the chair over, or am I waiting for? Okay, I'll wait.
Jesse duck out for
Yeah.
a second.
I didn't think I heard it.
You didn't turn it over.
Okay. Just wanted to make sure that you weren't waiting on me. This is, Mr. Chair, members of the board, this item is a continuation from the March 26th and April, is it? It's just from March 26th, wasn't it? Yeah. I think it's just from March 26th, 2 months ago. And the basic, I think, request by the board at that time was to get some clarification on how the appellant had interacted with the Parks Department in seeking opportunities in the Grandview Golf Course and Grandview Park areas that are just to the north. And again, the subject property is in the gold outline here. Areas that would be in the park are just to the east. They would continue all the way to east 33rd and then north even another block further into the golf course. There is a significant terrain change as you go north and to the east where the terrain rises to some extent and then begins to fall again. The RF engineering provided, actually at the previous hearing, indicated that points on the golf course that were being looked at didn't provide the sufficient coverage that was represented by the appellant. One of the things that was asked then was to look at areas further east to this property, which might, the appellant indicated that might be something that was workable from an RF standpoint. They've since come back and met with the Parks Director and indicated that the locations to the east here that we're going to work from an RF and RF stands for radio frequency. It's a kind of a lingo for the engineering of the communication signal. And if you have any questions on that, I would think that you should ask the appellant to explain that. But they provide the coverage maps to us using a propagation software. But they had indicated the only location to the east that was workable from an RF engineering standpoint was near this historic entrance area. That was not an area that the Parks Director was willing to consider at this time, just from a character perspective and impact on the users of the park and the historic nature of the park. And I believe he's here today too, if there's any questions for the Parks and Recreation Director, Ben Page. So there should be a letter in your packet, or that was included or handed out, that was from Ben Page. And then there's also a revised statement that was sent from the appellant on the letterhead that says Buell Consulting, I believe. It should be in your packet to reflect, based on this being strung out over a series of applications and meetings. I think they wanted to ensure that you understood their current position on all the matters. From staff's perspective, we looked at this, and we've maintained and held that the initial application made, or the most recent application made, satisfied the criteria that the board is charged with reviewing and upholding in granting such a request. In looking at this to comparable facilities throughout the city that exist and operate, we believe that they sufficiently demonstrated meeting those criteria. From that standpoint, you're able to listen as a board and put further conditions that you believe are necessary to achieve those criteria. Some things you might hear are looking at alternate methods of camouflaging or integrating or minimizing the impact, visual impact, as an example, where you could put additional conditions to what staff has recommended and still grant the request. So I want you to understand that the board has some ability to place those further conditions based on the testimony you hear from neighbors and questions that are brought up. Certainly, we've basically determined, other than the golf course, there really isn't any other properties that would meet what they call their search ring, or to provide the RF engineering that they need, that are of that 10 acres that's the requirement in the R180 zoning. So it has been pointed out that this location here is smaller than another property that would be closer to the 10 acres, which is the hospice site to the west. And the appellant has indicated that that was a negotiation they were not able to make happen, and has put that on record at the hearing. And so from staff's perspective, we are taking that statement at its face value. And so we still believe that granting that approval as presented would follow the criteria necessary to grant this. And we're recommending approval, and we haven't revised the conditions from the previous hearing with the 11 items that are outlined in the staff report. One of them is that if there's some issues with how this is operated, or this becomes a nuisance, if the backup generator becomes too loud or high impact on the neighborhood, that there's the ability to bring this back and revisit the consideration. I'm sorry, I'm looking at the wrong staff report. I'm sorry. Cancel that, what I just said. I apologize. Looking at the wrong line. The 5 items on page 37 are what we recommended. And one of those was the signed lease agreement. We do have a signed lease agreement. I do want the appellant to provide some explanation as to how that complies with our provision to remove this structure. I think there's an item 14, but I want to make sure that this condition is executed at the time before we issue a permit. Right now, we tend to get unsigned versions of the lease or redacted versions of the lease, and there is a point where we do want something that actually is in force. So that's why we have that condition in there. We do also want to make sure that there's any shelter that would be for a second carrier, meets all the character and design and materials as the initial equipment shelter. They're not really demonstrating exactly where that would be located or how that would occur. We generally review co-locates on an administrative level so that we would ensure that it met the same level of design and construction and compatibility with the main church structure that we are seeing in the proposal. And it'll be argued that there's no requirement compelling the applicant or the carrier, the tower owner, to allow any second carrier on it. They can design it to accommodate it and still not allow it. From that standpoint, that this having the second co-locatability gives staff leverage when we have other requests from other carriers, that is an approved option for a secondary co-locate. And we could actually deny another applicant for another location based on the fact that this may be available. They would have to demonstrate that that was not a solution for their network, for example. So even if the church never chooses to lease to anybody, it gives us some leverage to reduce the impact in the area as a whole. So, and that's why the original requirement was put in the ordinance. So I did want to point that out as well. I can go through photos again. I don't know if you've seen enough of this, or I don't want to prolong the presentation, but I do have that available if you need to see it. At this point, it's still, the rendering is shown is what's being proposed. It does have the cross element on a stealth pole design. From a staff perspective, we believe that meets the intent of granting the conditional use. However, if the board has other ideas or concepts that they believe also would achieve that, staff is not locked into this exact design. I think we're comfortable with anything that the board feels is in character and meets that criteria. So that's just what's being proposed. That's what we understand the church has approved. And so and we believe that meets the criteria. So that's what's still on the table at this point. Any questions? I can show you the.
I have some questions for the park director.
Okay. And I'll just have the chair call him up then at whatever opportunity.
Okay. Brooke, you got your microphone on over there? Okay. All right. So before we get to any questions for others, any questions directly for Eric before he steps away? Going once, going twice. Okay. Okay, as part of staff presentation, since we do have a letter on the table here, and Brooke, you'd like to hear from Mr. Page and ask him a question or two, is that correct?
Yeah.
All right, Ben, there you are.
Chairman Pence, members of the Zoning Board of Adjustment, I'm Ben Page, Director of Parks and Recreation.
I'd like to know why you couldn't work this out, since in my opinion, it would be the best route for the city to bear this burden versus private property, and with the input from the neighbors, why you couldn't come to terms, both financially, which I'm a little confused on why the financial aspect would be a big issue negotiating with the city, And I understand in your letter that had to move some things, or it could impact some of the trees or whatever. But I would think the city would bend over backwards to try to accommodate something like this versus having to put it on private property.
That's some great questions. I can first hit the financial consideration piece. We never got that far down the road because there was never a location. Financially, I think we were open to whatever we could negotiate that met the best need, as well as the current fair market value of this type of arrangement in city parks. But I have a few maps, if I may, to illustrate
Yes.
how we started.
Please do.
So, if you will, it's kind of hard to read, but you see the footprint of the golf course is in gold. And you see the park is right here. When we first became aware of the situation, that there was a desire to place a cell tower in this area, we looked at this site, but we also said we'd step back just to make sure. Again, we didn't understand their business, but we understand we had a lot of land that was managed by Parks and Recreation for the city. So I had my team and myself look at just the region, if you will, of park spaces. Again, it's kind of very difficult to see, but I started down here, which is called East Town Park. It's also a softball facility. We thought, ideally, that would have been the best site if the city was going to figure out this, because that softball field is lit. It has large light poles. It kind of could have blended in. Upon some discussions with the siting company, that was too far off of their path. But you see, we own several properties in the area, so we started zooming back into Grandview Park. Again, trying to accommodate the need. We said to them, okay, right there is Easton Boulevard by my finger. That was the desired location. I said, you know, that's the historic entrance. That park will turn 125 years old in about 2 years. One of the first 4 parks the city purchased. And that's your front door. As you know, when these things come in, it's just not a pole. I will tell you another graphic here. This is again provided to us by the siding company. This is what also goes with the pole. You have a building, you have a fenced-in area, and you have, most times, little 1 or 2 parking stalls off the beaten path. So that would be a pretty huge impact to the front of our front door of our park. I mean, when you go to parks, you look for the majestic view of a park. So you said, again, we could probably still figure this out, but just not there, in my opinion, as a staff member. I just can't recommend we put that at the front door. So back to the map, we showed them a few other locations. We showed them the corner down here by our tennis courts. Again, not that far off geographically, but we were told that wouldn't work for their business. I also liked a little site on East 33rd, right where the golf course starts up here. We have a little back of house operation where we keep our dirt and compost for golf course operations. It's kind of tucked around the corner. As you can see, only a few houses across the street at least. We thought we could tuck it back in there. Again, that wouldn't work. We showed them several other properties. Again, that wouldn't work. So we finally said, is there any site in this big, large acreages of parks we own that would work for you? He said, if I can't have the front door, then I can't work with you. It wasn't a personal thing. My engineering says right here or nowhere else. We tried, we just can't find a spot that, in my opinion, would impact the park, the trees, the disc golfers, the public's use of that facility. Does that answer? Can you leave?
Yeah.
Yeah, sure can.
Thank you.
Do you want all
And
that?
I guess one other thing, it wouldn't work because of the coverage area, is that, or should I ask?
That'd be better for them.
Okay, thank you.
Thank you, Ben. We appreciate that graphic, too. We may need to refer to that here later. Okay. Okay, applicant or representative of the applicant?
Good afternoon, Mr. Chairman, members of the board. My name is Kurt Walter, live at 2897 Lake Vista Drive, Northwest in Rochester, Minnesota. Do represent Verizon Wireless on this project of ours. Try to make this as brief as possible. It's been a year now since we originally applied. We discussed this last year, a couple meetings. Decided that we should talk to the park board after talking with the board here and some of the members of the residents nearby. We did that over the winter, came back here 2 months ago, said, here we go. Talked to the park board, talked to city real estate people, financial terms, where we can go, where we can't go, all the things that Mr. Page has demonstrated today. Didn't work out, came to you guys, said, hey, this is what we're looking at, these are the coverage maps, this is what does work, this is what doesn't work for us. Some more input from the resident, the neighbors saying, hey, we've talked to the park boards, we get a different story. We've taken 2 months off, made sure that we've fully looked at everything between Verizon and the park board, and we have gone over items. We'll start off here real quick. We believe we've demonstrated what we're looking to do. We are, in some of our original documentation last year, our goals are to cover the area better and to offload other sites that are basically, in layman's terms, getting almost to capacity. More people using smartphones, more people using internet on their phones, all that stuff takes up so much bandwidth. Each space has to be offloaded, basically. Here's the existing coverage, as we've demonstrated before. Our location is right here of our proposed site. We've demonstrated that the AT&T tower that's off at Mecca doesn't give us as good a coverage as this site. See the green and the black are not as good areas. This covers our objective, the topography of the area. Most people get confused. We need the highest point in the world. That's not it. We need to be where the technology is being used. We've gone to the golf course area. If I can borrow one of Ben's pictures here. We've demonstrated that this particular area of the park would work for us because of this coverage. It gives us pretty close to our proposed coverage. It's not that far off. Talking to the park board, this area really doesn't work. Here or here works for them. Golf course coverage from this location here, as close as possible behind some sheds that they've got, still leaves us some gaps along Easton and along Hubble there. We've demonstrated that if we move down close to Kmart, now this is different colors on these two particular maps because they were done at a different time. But here's the existing coverage with different parameters that were used last year. And then this is the coverage with the Kmart spot, which is very close to that other park with the softball fields, compared to the coverage with our proposed Presbyterian Church location. We have taken into consideration a lot of the comments from the neighbors. We believe that this particular style of cell phone facility would blend in really well with a church facility. We've built many of these. This particular style, bell tower style, different styles we've done before. This one fits here, we believe. We've taken into, there were comments about the generator that we have. We've changed that from a diesel generator to a natural gas generator. The hospice next door, just a few hundred feet to the west, has a generator similar to ours that we're proposing that no one seems to doesn't seem to bother people. It'd be very similar to that. We've looked at, people commented that we'll be looking at the shelter. It's going to be matching the same existing brick of the building. We're going to be planting some shrubs and some screening in front of it on both sides of it, so you won't be able to see it as clearly from the street or from the houses behind it to the north. there's no really getting around not seeing the 120-foot tall structure. It's hard to camouflage that. I know there was comments about pine trees and that kind of thing. Problem with a pine tree is it's more stuff. If it snows, then we have to cover it. There's certain requirements that a pine tree will be much more large and beefy, and I think more intrusive in this type of facility. We do have some of our engineers here that can answer any coverage capacity questions that you might have that you don't fully understand with our propagation maps. Other than that, we're doing the best we can with what we've got. The only real difference here is there's not 10 acres. In the coverage area between where the golf course doesn't work, Kmart doesn't work, and the AT&T tower doesn't work, in that particular area, there is nothing there that is 10 acres. So nothing will work other than the park, and our discussions that where we can go in the park to make it work, doesn't work for the park board. So.
Okay. Is that your presentation, Kurt?
Yes.
Okay, we have some anxious questions here. Ladies first. Cindy?
Oh, thanks. Hey, Mr. Walter, if you don't mind putting the map of the park up again, and you had pointed to the area, you kind of had placed your hand over the front entrance area that showed that it extended all the way to East 33rd and Easton Boulevard there by the tennis courts. I thought I heard Ben say that there was potential for placing it in that area, but you're saying that that's not workable?
The tennis courts themselves have small playground for small children. We don't like to put these items on elementary schools, anywhere where there are small children playing around. In the winter, as freezing rain gets on this, there are some falling ice concerns. We don't like to do that at all.
So does this mean churchgoers take their own risk as they come into worship?
Yeah.
I mean, it's right by the front door.
Yeah.
Okay. Brooke?
Mr. Page mentioned that the only spot you thought would work was right at the entrance. Is that correct?
Not exactly in that general vicinity. We've been, see if I can get away here. Basically anywhere south of Thompson Avenue works really well, would still work for us. So basically this area right there, that's what we looked at.
So any area south of Thompson Avenue down to Easton is workable?
Roughly, yeah.
Roughly.
It'll give us.
But you and the city couldn't come to an understanding?
From my understanding, and I believe what Mr. Page has mentioned, that he couldn't support something in that area. I don't want to put words in his mouth, but I believe.
All right.
Okay, thank you.
This would be a perfect spot up here where the park board would like. It just doesn't help our coverage at all. I mean, there are great spots, commercial buildings, that kind of stuff that would be a great spot for these. It just doesn't happen to be where we can use the coverage.
Right. Okay. Kurt, the proposed height is 121 feet. And I'm not sure if height is our issue here or just the, proposed location of it. But with the height you have room to co-locate on this.
Correct.
Is that correct?
Correct.
And based on agreements, FCC, et cetera, do you have an obligation to allow other carriers then to co-locate? Or is that just kind of an industry handshake thing?
We have master lease agreements with all the major carriers.
Okay.
So if AT&T wants to come and use this, we've
Right.
already got an agreement
Okay.
already set up with them. US
Yeah.
Cellular, T-Mobile.
Yep. If we knock the height down another 20 feet, could that impact your ability to facilitate co-location or your own coverage?
I can let our engineers discuss the coverage part. We need to be above the tree line so that we can get out there. Leaves and trees do have an impact on what covers, but I've been informed that if we dropped it 20 feet, we wouldn't have the coverage that we need.
Okay. And for co-locating, there's certain boxes and transmitters and stuff. Others have to have room to install, so you need some vertical room for that too, right?
Yes, and we've provided that here. As for the shelter that Eric or Mr. Lundy has discussed, we're leaving that up to the church themselves. When a new facility comes in, the technology that they're going to use might be different than today's technology.
I got you.
Depending on what they use, we can put, sometimes you can put the shelter 300 feet away and run fiber line up there and be fine. Some of them you can't. So it depends on the technology.
Okay.
So we could put something on a roof that's going to look like, large, air conditioner facilities on the roof and then attach it to,
Okay.
We can do a number of many things.
And since you mentioned it, the way you are designing the kind of the shelter per se, do you have some room in there now with current technology to allow for some expansion or co-location of other carriers then?
We don't put anybody else in, nobody else has
No,
access.
oh, okay, so that is just your own then?
Yes.
Okay. all
Shelter
right.
itself, nobody else
So if
has.
somebody wanted to co-locate, they might have to add on or do something else or have another little outhouse or something? Okay.
Yes, and depends, some carriers can use a tiny little
Sure.
cabinets, size of this.
Right.
Some of them have their own shelters.
Okay. Other questions for Kurt? Okay, all right. Thank you very much.
If you have any questions for our actual engineers who designed this?
Do you have them here today?
Yes.
Any questions for the engineers? Okay, we'll just let that hang for now. I appreciate them being here.
Thank you.
You bet. Okay. Anybody from the public that wishes to speak in support of the applicant? Is there anybody that wishes to speak in opposition to the applicant? All right. Whoever would like to go first, feel free to, and then you can just go in order thereafter. You have 5 minutes each. Just give us your name and address.
Julie Bright. I live at 3108 Thompson. And the first item I brought for you today addresses something that Eric mentioned in his opening statement. It had to do with hospice. And he made the statement that's on record that hospice would not entertain this being located on their property. I have a letter that is addressed to you from HCI Care Services, who is the corporate office for the Bright Kavanaugh House. And I would like to read it. It says, to the City of Des Moines Zoning Board of Adjustments, after the June 26, 2013 Zoning Board of Adjustment meeting, a neighbor of ours by the Bright Kavanaugh House located at 3000 Easton Boulevard brought to our attention that First Presbyterian Church of DM was seeking a variance for the property located at 3100 Easton Boulevard for the installation of a 121-foot tall tower, communication tower, to be installed by Verizon Wireless. At that meeting, the Verizon Wireless representative, Kurt Walter, made a statement that he had contacted our organization about the placement of the tower on our Easton Boulevard property. A Verizon Wireless representative has not contacted our corporate office about the project. In fact, after that meeting, which was in 2013, we contacted Kurt, and he said he wasn't interested in looking at a different location. If you have any questions about this statement, please feel free to contact me by my email, kdennis@hcivns.org. It's signed sincerely, Kelly Dennis, who's the Chief Financial Officer at HCI Care Services. So this is for you guys. The second thing I brought today is a petition. 5 people in the neighborhood have gone out and collected signatures. We have over 140 signatures of neighbors who are opposing this. So I have for you the petition from the neighbors. I also took from this petition addresses and made a map that shows you of the people. We did this in 5 days, started on Friday, so we did over the holiday weekend. There were, people not home, but the ones that are marked in pink are the residents who have signed the petition who are opposing this cell tower. So if you really listen to the people, we're saying, please don't put the cell tower here. And one other thing I'd like to challenge this whole thing is, if this church property was a residential property, where would Verizon be looking? Who would they be approaching? I mean, because they keep saying nothing else will work, except for one place that the park says, no, don't put it. So that's all I have. Do you have any questions? Yeah.
You read the letter from the hospice and said you weren't contacted, but it didn't say if the hospice would even have an interest.
Well, that was not the issue. The issue was Kurt Walter has said he contacted hospice, and hospice said it wasn't an option. And they have never been contacted, so they can't say if they would or not, because they've never had a discussion.
Okay. But the hospice doesn't have an interest in it either, I would presume.
I can't say that. They would entertain a conversation,
Okay, thank you.
because they don't know enough about it to say yes or no, so, yeah. Okay, thank you.
Good afternoon, Board and Mr. Chair. My name is Brian Ruggles, and I live at 3042 Easton Boulevard. Do we have that map? Again, I feel like I'm kind of on recording here, but I own the property right adjacent to the west of the church, and then two lots also that adjoin that property. So myself, my neighbors to the east of the church, then right across the street, and of course the people right behind are the most affected by this. My wife and two kids moved again to this location. Lived in Ankeny for 10 years, loved the community, but really loved the location over here near the park. Very historic park-like setting. We've reiterated that a number of times. In fact, I found out that directly across the street and kitty corner from the church on Easton is an address 3111 Easton, also known as Rose Hill, which according to the historical records is the oldest home in all the Des Moines metro, which is kind of interesting. We're kind of glad that we had this previous hearing right before ours, because you guys seem to consider that the view of the residents and those who live there was important, that the value of the neighborhood was important. So that's kind of helpful to us. I personally went out and helped with some of these petitions, and of about 50 or so that I had signed, I only had one gentleman in the entire neighborhood that I talked to that would not sign it. So there's a pretty overwhelming response from the neighborhood. This is now our fourth appearance before you on this issue. I don't know if any of you had a chance to actually go up and kind of get a feel of the neighborhood, maybe walk on Thompson or anything behind there. But it really helps to get the feel for that. Again, our neighborhood is a neighborhood that the community would try to encourage residency in, people to come and buy homes and settle down there. In talking with our neighbors, they're very thankful to be able to live in that area. One of the requirements, to my understanding, is that if there's an exception granted and a variance, according to section 134-64-4A5, that it needs to be in harmony with the essential character of the neighborhood. Again, I think we could demonstrate quite easily that it just simply is not. I cited a case last time, case number 053049, U.S. COC of Greater Iowa versus the Zoning Board of Adjustment. This was from October 11th, 2006. It's on the record there. This was according to the 8th Circuit United States Court of Appeals, and they actually upheld the decision of the Board of Adjustment to deny access for a cell tower based on two things. One, well, really three things. The size, it was much smaller than the required 10 acres. Number two, the safety factor. And number three was the impact on the value of the neighborhood based on the aesthetic appearance of the cell tower. And you can go back to the previous record. I won't take the time to quote that whole thing, although I guess I could share just a little bit of that. Okay, so you have it on the record. We also found out that just before hospice came in, that Sprint actually had tried to put a cell tower in somewhere in that hospice area. And when the neighborhoods found out about it, and Sprint realized how many people were opposed to that, my understanding is they actually just pulled that. That was back, again, prior to hospice being located there. Again, we're talking about a 70% variance on a spot that only has 3 acres. Again, with the park, you saw the map, there's an overwhelming amount of land available right there. We had heard that it was stated that the representative from Verizon had said, well, we already have $30,000 invested into this project and we don't really care to look elsewhere. I know we're a little bit at the mercy of the engineers who are here. It would almost seem that the city would be well served maybe in having their own RF engineer take a look at this to verify that what we're hearing from this one viewpoint is actually in fact correct. We maintain that there are actually alternative sites that are available. We still maintain that even though the representative from Verizon claims that he has checked every possible option, you just heard a letter from one of the sites that says that he hasn't. So we have a little question as to the actual due diligence that has been done. Ms. Westergaard last time made a statement at the end that she didn't feel like she would be willing to vote on this issue unless there was a letter from the city saying that the tower could not be placed up in that park, which we clearly don't have, just not in that one little slice of the park. In closing, let me just say this. It's very clear from the neighborhood that there's an overwhelming majority of our neighbors that are not in favor of the tower. Number two, at least from a lay perspective, that this is not the only feasible location. In fact, I don't think it's very feasible at all. We're a little bit concerned about some of the misrepresentation. And then number four, that we don't see that it's a benefit, certainly to our neighborhood, nor really to the city for that matter, when you consider the issues of property value and that kind of thing. That house that's the historical house actually is on the market at this very moment. So it's been for sale for a little while. Some curious questions, I guess, that I would pose is, in light of the overwhelming voice from the community saying we don't want this, it's interesting that city staff continues to recommend this. Certain members of this board seem to demonstrate an apparent prejudice almost in favor of the tower. And just one little note that's a side note, there have been actually survey crews already out observed making preparation for the tower to go in. So it just makes us wonder, you know, what's going on that there's been such confidence that this was going to go in. So thank you very much.
Brian, hang on a second. Any questions for Brian?
I do have one
Yes, Cindy.
question. Would you be opposed if this tower were to go onto the hospice site, if they had discussions with them? I mean, would you also be opposed to that site?
I wouldn't personally be very much in favor of the hospice site myself. It may be the better of two, lesser of two evils perhaps, but the park makes a whole lot more sense.
Okay.
Okay.
Thank you.
All right, thank you, Brian.
Thank you.
Next speaker. And again, we just encourage everybody to use your 5 minutes as best you can.
I have a signed note from Luella Vitalis, who has asked me to speak on her behalf today because she is ill.
Okay.
What's your name?
Suzette Jensen, 3127 Thompson Avenue.
Okay.
Luella Vitalis resides at 3113 Thompson Avenue. She also owns the lots adjacent to her property. So her property backs up to the site. And this is, I don't know if you can make this bigger. This is actually the view out her kitchen window. This house is a passive solar home, and most of the windows are on the back side of the house. So everything that she looks out on looks out right over the top of this church and will look right at the White Tower. Mrs. Vitalis is very concerned about the impact on her property, her view, her ability to sell the property should she need to, because this is going to be right in her backyard. Her concern is that the noise that might be created by any generator, any additional generators, if there's a co-locate, will also impact her ability to enjoy her deck and her backyard. She has a lot of flower gardens and a greenhouse, and she spends a lot of time outdoors and has a beautiful home. She's very concerned about the impact on her property value and the impact on her view. Thank you.
Suzette, just one brief question based on your camera picture there. Thank you for that. Is that a 2-story or do we have a 3-story with the school there? How tall is that structure?
It's a 2-story home. Well, no, it's actually a 1-story home. It's a walkout basement.
No,
'Cause it's on a
I'm
hillside.
sorry. I'm talking about the church and its ancillary school there. Is that a 2 or 3-story
2-story.
building? Okay. So she looks at an existing 2-story building with 2 rows of windows. That's what she's got in her backyard now.
Right, and that white space you see, that's right over the
Right.
top, that's where that tower is.
And then the
So
tower would be on the other side of the
right on
building,
the other
but then
side. So
coming
there's
up
a
above it.
Big, open view right there.
Gotcha. Okay.
There's right at it.
Thank you. Okay, next.
Board and Chair, Randy Lippert at 3120 Thompson Avenue, which is right there. And also I have a lot right here, adjoining right there. I'd like to start out with, I've got a letter that I want to read to you here and stuff, which is going to take every bit of 5 minutes. So, but just quickly, I heard a couple things from Kurt Walter up there and stuff that kind of bothers me a little bit because this is kind of an indication on how this whole situation has gone for over a year and stuff. He talked about a meeting and stuff and about getting input from the neighbors and stuff. I'm pretty sure if you ask the neighbors, I don't know that anybody said that they wanted to see it there. So where's he getting input from? Was I ever asked about what color to have the monopole with the cross? I don't think so. But if I was going to have it there, I would say hot dip galvanized pole instead of a white pole. Okay. But my point is that again, I think that's Brooke had a question about that letter from the HCI, okay, the Bright Kavanaugh House. It goes to show you again that he had said that he talked to him. The reason for the letter is they hadn't talked to him. So again, it shows that he's not been extremely transparent. He tells us what he thinks you need to hear, okay, and doesn't tell you the whole story. So my point is that I just think that we need to be a little careful. I'd kind of like to see if you could see this here. It is basically a map of everything. Does that show up okay? Okay. All right. Just real quick, just because I want to read my letter here and stuff, I want you to understand the Mecca Tower is right here. I've got a big black X there. And the area that I think that he said will only work is right in the historic entrance right here in the park. And I know Ben Page had mentioned right up here also. And keep in mind when I get to talking and stuff here, you heard Kurt Walter said that they don't want to put it there because of kids playing and ice falling and so forth, okay? But keep in mind too that there's a lot of high winds in the winter that can make that stuff like projectiles. So anyway, here's the church, here's the hospice. And if I'm not mistaken, hopefully I'm not stepping out of my boundaries here, but in talking with Bob Mahaffey, Ben Page, I thought that they were talking about proposing up here, which is where the old maintenance house was that was torn down. Now you'd have to ask Ben, but I thought him and I were on the same page about that. And I want to just say real quick before I read here, I'm not an RF engineer, but common sense kind of tells you this a little bit. And you can drive around the city and look at some of the antennas. I don't believe they have to be totally omnidirection, meaning three-sided in a triangular shape. If you look, some of the cell towers can be directed. They'll have them only on one side, or maybe two. So my point is, I'm going to say that why can't you put it up here in the park if this is available, for example, and so it doesn't interfere with the towers that are over on East Hubble and Euclid Avenue. Why can't they be directed, okay, maybe bring it down lower if the height is too high, and be able to serve the same purpose, the same area, okay? So again, I'm not sure if I established my name. I think I did. Randy Lippert, and I gave you the locations. We have a horizontal ridge of hilly terrain in the Grandview area between the Guthrie Avenue and Easton Avenue. With the difficulty of this terrain, there will be future needs from many wireless communication service providers for cell sites. We need to minimize how many cell sites along this terrain by strategically planning where these sites can be. Currently, at the Mecca Cell Tower, which has been pointed out, at 3451 Easton Boulevard, that's only 1,500 feet away from the subject property that we're talking about here today, First Presbyterian Church. The Bright Kavanaugh House is right next door, which has 9.38 acres, okay, 3 times as much land, and it's less than 500 feet away from the subject property. Grandview Park and Rec area is less than 1,500 feet away from the church. So the last two properties have future potential for becoming cell sites in the future, so please keep that in mind. No cell tower should be approved on the R180 subject property at the church because the lot is too small in size. It is only 3.12 acres, which has been pointed out by Brian and many others. It's 70% deficient from meeting the required amount to place a cell site. The site does not have sufficient acreage to allow for future co-locating of multiple carriers and their equipment shelters. I want to point out in one of the neighborhood meetings that we did have with Bill Eden, the representative for the church, which I don't believe is here today, and the pastor, we were told with a handful of us at that meeting that they only wanted the tower with one equipment service building, okay? And on that property, because they felt they didn't have sufficient room for others. When we brought that to their attention, they were livid. They went back to Kurt Walter and said, what's going on here? We're not wanting two carriers here, okay? Because they didn't have the space. That was his words, Bill Eden. Board members, based on this fact, as substantial evidence, you should determine that the exception be denied because the site needs to be able to allow co-locating, be guaranteed. A concern of mine, which was mentioned by Kurt Walter, by the way, just a few minutes ago, about not putting it up here in the site, which is part of the park and rec where the kids play and stuff. A concern of mine is regarding ice forming on the tower and antennas. It is a fact that the ice does form on cell towers during the winter months, and this ice will on occasion not only fall onto the property, objects, and persons below, but occasionally it will be propelled through the air by high winds onto the adjacent properties, objects, and persons below. So remember, this is a residential neighborhood that will in fact from time to time have neighborhood kids that will wander innocently onto this adjacent to this land and also the adjacent properties to play. In fact, it is undisputed that Verizon Wireless Equipment Building below is to be constructed at the base of the tower to be hardened to protect it from falling ice and other objects. So to this point, the proposed cell site on the back of that 3.12 acre lot will not adequately safeguard the health, safety, and welfare of the occupants of the adjoining and surrounding property as required for an exception. Further, the danger of falling and blowing ice will diminish property values in the area of the tower. This is a zoning factor that prevents the board from granting the requested exception based on the Muni Code Section 13464, subsection 4. Exceptions shall by their design, construction, and operation adequately safeguard the health, safety, and welfare of the occupants of adjoining and surrounding property. Exceptions shall not increase public danger or fire and safety, and shall not diminish or impair established property values in the surrounding areas. Again, board members, based on these facts as substantial evidence, you should determine that the exception should be denied. Currently, the subject property does not have adequate landscape screening, especially all year round. Muni Code Section 134-347, subsection 10 states that the adverse visual impact of a tower shall be minimized through careful design, siting, landscape screening, and innovative camouflage techniques. Having an unobstructed view of a tower from one's home every day would diminish most property owners' enjoyment of that property. Common sense dictates that having such a tower in the sight line from and so close to one's home reduces the value of that home, especially when the property owner is not the one receiving the income from the lease. Ask yourself in making the determination today, taking into consideration protecting the essential character of the surrounding area, how would the appellant be able to meet the code requirement and criteria when the practical difficulty of the subject property's elevation is lower than most of the adjoining and surrounding residential properties, especially those to the north? Board members, based on these facts and substantial evidence, you should determine that the exception should be denied. In this area, there is a much better location, which has been pointed out by Ben Page and others. That would be the Grandview Park area, which is less than 1,500 feet away from the church, and in particular, at East 32nd Street in Guthrie. The elevation of this land is much higher than the subject property. It is one of the highest points in the general area. And this is just pointing out from an aesthetic point of view more than anything else. Again, if they need to lower the antenna, if they need to direct the antennas, whatever they need to do, do it. Make it work. It also has sufficient acreage to allow for multiple wireless service providers to place their antennas on one monopole cell tower, and also would allow them to place multiple equipment service buildings below. So that way we could take care of this area for a future of maybe 15, 20 years, who knows, or longer. This location with adequate planning will protect the essential character of the surrounding residential properties for now and into the future. If we don't make good decisions now, then we will be guaranteed a horizon of cell towers in the area with one or two carriers on each one. This area is part of the City of Des Moines Park and Rec, as Ben Page mentioned, the director, and they have offered a portion of this real estate as an alternative site at a substantially reduced price, but Kurt Walter, the representative for Verizon, has indicated that he's not interested. In closing here, Kurt Walter, the representing Verizon Wireless, has only been pursuing the church and not adequately investigating all other feasible alternative sites, including Grandview Park and the Bright Kavanaugh House, in full. So board members, again, based on this, as a fact, as substantial evidence, you should determine that the exception should be denied. And one last thing, the telecommunications...
One last thing, Randy.
You got it.
One last thing.
Telecommunications Act of 1996 has a considerable amount of standards, but what is most relevant to this issue is that Congress intended, in spite of the high degree of federal regulation in the area of wireless communication, to allow local zoning boards to continue to do what local zoning boards traditionally do best: make reasoned decisions regarding the appropriate use of privately owned property for the public. Good, thank you. Any questions?
Any questions for Randy? All right, thank you very much. Okay, I do want to remind everyone, I try to be as generous as I can. As I stated at the beginning of the hearing, everybody has 5 minutes to comment. I don't like to be rude to anybody, but I do have the military time watch. And I know that some of our speakers can be concise and effective in their comments. So timing watch is on. Who's next?
Suzette Jensen, 3127 Thompson Avenue. We're all here because we're concerned about the value of our property and the impact that this might make on the value of our property. But we're also concerned about the church property, about a church in our neighborhood that didn't bother to contact any of us that they were considering this tower. The only contact we had with the church was after it came before this board. The church is choosing to do this because they need money, as many churches do. But this church also has a very low attendance and a very low membership. So as neighbors in an R180 neighborhood, we're very concerned about that property. What happens if that church fails? Today I was reading the contract with Verizon, and in the contract, there is a first right of refusal, that Verizon shall have the right to buy that property should the church fail. Is it your intent that a business should buy this property in an R180 neighborhood? I also had a conversation with Ben Page about, looking at the park. And he told me that basically they weren't interested in looking at the park, that they had $30,000 invested in this site and they weren't interested in spending any more money looking at someplace else. I find it very, very, very hard to believe that this is the only spot. We were told that they sent a letter to the Baptist Church on East 33rd. We've had some confirmation of that, but we weren't able to get it documented. And that would be further away from the park property that he was looking at. We're told that he's concerned about children and all that. Well, why is a church allowing a site to be located right by their front entrance, their handicapped entrance of their church? So we're very concerned that we're not being told the whole truth, that Verizon's agents have not explored the other options that are available to them. I know there's a ridge there, and I know that I sit on the downhill side, the church sits further downhill than I do, and all of us do, and it's uphill from there, but that ridge goes around the park. There's a lot of property. It might take a different design of tower, but the map he showed that a lot of the area they're trying to reach is right down by the Kmart area, right down where the city says they could locate one. It might cost them more money because it might have to be a taller tower. So I would ask you to refuse them, make them look at something else, make them truly investigate something else, because they're not going to until this board turns them down. Thank you.
Thank you, Suzette. Any questions? Okay. Next speaker.
Good afternoon. Marty Mock, 2701 Arthur, speaking on behalf of Northeast Neighbors. I watched the last meeting on YouTube this morning, the whole thing. Glutton for punishment.
Yes.
My comments and reasons for standing against this location has not changed, and that's already part of the record, so I won't repeat any of that.
Okay. Appreciate it.
I do want to make some comments regarding the applicant's statements after the public portion of the meeting last time. And since we could not respond to any of those particular comments. One common thread that I see researching this issue in regard to both the Telecommunications Act and court cases in relationship to this is that wireless carriers are required to prove that there are no other viable locations that will work. They're the ones that have the burden of proof, not the citizens that are coming up and speaking against it. Saying that, as has been mentioned before, there's a claim that they've already invested over $30,000 on this particular site. That's fine. That's a business decision, but it does not go towards burden of proof. Burden of proof comes from a zoning position. In the last meeting, the applicant said, "We have never said that this property is the only location," and that's a quote. Later, from Buell Consulting letter that you have as your on your record here, it says, "We have met with the Park and Rec staff and concluded that the city staff is not in favor of placing a facility in the only location in Grandview Park that will provide the needed coverage for Verizon along Easton Boulevard." Arising out of that last meeting, the possible location of Easton and East 33rd, 2 blocks from the existing site and in the park, was discussed. The applicant has stated that they had checked every part of the park to see if it would work, and he said yes. When he was asked by, I think, Mr. Gear, did you check the site at East 33rd and Easton? He said, well, no, we haven't checked that site. One of the things he agreed, I quote, "I will make sure that gets done." Yet we see no report in his testimony today that that was done, nor do we see a report in regard to the footprint on how that site would work. I did go back and check again. I mentioned in error last time that that site might be lower. It is actually higher than the existing site that they're looking for right here. And again, it's just basically 2 blocks away right along Easton Boulevard. Ben Page has submitted a letter and has answered the questions there. Maybe the real question is, and maybe we should ask Mr. Page, is did the site at East 33rd and Easton actually get discussed during that meeting? And what was the actual words being said? In conclusion, the Telecommunications Act does give cities the ability to regulate the location of cell towers within the limitations of the federal law. In the staff recommendation, we find the following standards for granting an exception, and it's found on page 35 of your staff recommendations. The board shall ensure that exceptions by the design cannot do a number of things, or have to do a number of things, and down towards about 2/3 thing, and shall not diminish or impair established property values in surrounding areas. And then the list 4 different tests that have to be met. 4 that have to be met, not 1 that has to be met or 2, but all 4 should be met. The 1 is kind of the starting of the exceptions. The number 2, the exception is reasonably necessary due to practical difficulties related to the land in question. Such practical difficulties cannot be overcome by any feasible alternative means other than an exception, and the exception is in harmony with the essential character of the neighborhood of the land in question. The Telecommunications Act has nothing to say regarding this. We can still follow those exception rules, and they are rules as part of what this board should do. And so in conclusion, I believe that he has not met, they have not met the test of an exception during this way, that they have been less than candid about the different people they've talked to and the conversations that they have had, and they have not done due diligence in looking at the one property this board asked them to look at the last meeting. And I ask you to deny the exception.
Right on time, Marty.
Thank you.
Any questions for Mr. Mock?
Thank you.
Okay, thank you very much.
Looks like I'll get to be the last person. Sorry, my name is Dale Marks. I live at 2103 East 29th Street, so I'm outside of the 300-foot thing. That's why one of the reasons I'm down here, one of my neighbors came over, the ones that's going to live right next to that, and asked me to sign the petition last night. And I did recall, and I don't know if any of you were in the meeting when Sprint tried to apply for this on what's currently the hospice territory right now. That was 18 years ago. And I got notified that very day that there was a meeting that day, because that was the day I was moving into my house at 2103 East 29th. That would be my house right here, completely obliterated by the trees that are covering it from that aspect there. So like I say, I live a little bit outside of that area. I probably won't be able to see this. I haven't been able to had the time to look at all that yet. But Miss Smith, you talked about would one of the guys have opposition to the hospice territory for that, and I definitely would have, because where they were going to be putting it, it would have been the view out of my back window. So to me, that is not an option. I don't know about the Mecca site, but I do kind of know a little bit about the Grandview Park site and a couple of the spots that they talked about putting it there. And I can understand Mr. Page's opposition to putting it at the entrance to the park. It is actually a beautiful entrance. I could maybe understand neighbors having an aversion to being right there where the old maintenance house was. I know Mr. Dar that lived there for many, many years until that house was torn down. But there are some beautiful homes across the street that might have an aversion to that. The spot that you looked at where the wading pool is, that my wife takes our grandchildren to, and the tennis courts, I think you talked about out here in the parking lot of that. I wouldn't see that as to be an option, but I could see somewhere in this area, and it's difficult for me to point and look at the same time here, but right in behind this area, and I'm not sure why Mr. Page has an aversion to that being part of the Parks and Recs area, except for this year, and this year alone, they've decided to turn that into a nature trail area. But there is still, as you can see, numerous acres there of wooded area. If you went in behind the shelter house and the wading pool, back in there a little ways, you'd have exactly the same elevation and coverage that you would have from the church area. So I believe that the Parks and Recs in how they've set it out is to you can have this, you can have this, you can have this. I'm not sure what their aversion to that is, but I would suspect that building that nature area in that has just started this year might be part of that. You'd have to ask him that. Like I say, that's my opinion from that. And I know cell phones are the way of the future. I have a Verizon cell phone in my pocket right now.
On vibrate or silenced, right?
It is on
vibrate,
vibrate, yes.
Thank you.
So, but neighborhood safety-wise, the kids, obviously it's going to be protected somewhere, but at that meeting 18 years ago, I said if I were a middle school-aged kid in that residential neighborhood, I would have made it my goal to climb that pole. So safety-wise, you can't protect it anywhere, shape, or form for that. But property value-wise, if any of you are from this area of this city, I like to look at this square here and so forth as basically being the Upper East Side, because it's absolutely beautiful homes, beautiful landscape. It's one of the reasons I moved into the area. Previous to that, I lived a half a block down on East 30th Street here, and then moved 2 blocks to my current house, which who does that? Except for I moved into a beautiful house with a beautiful yard and so forth. So I can understand all the neighbors that are right around that area. If they wanted to move it down into, like I say, into the hospice area, I would be down here protesting the same way, should I find that. So, and again, most of that is my opinion, but I was here at the meeting that Sprint tried to get that on it was the Phil Johnson florist at the time, and it was a monetary issue for them. They needed money. They went out of business, folded, they were done. And I would be concerned that a church that's necessary to that, to look for that type of funds. And that was the first that I had heard of the the church being so low, but I had to think in my mind previous to that, that had to be for them, the income issue of that, so, thank you very much.
Okay. Any questions for the gentleman? Okay, thank you, sir. Okay, is there anybody that wishes to speak in opposition? Just closing this out. Last call. Okay. Kurt, you've got some time for rebuttal.
I'll just take 3 minutes.
Okay.
I appreciate your time again. Like we started at the beginning of this, elevation really doesn't matter. It's location of it, coverage, what we need to cover. I should have started with correcting Eric's statement to begin with. None of my testimony in the past, and again, you can look on YouTube, we had contacted the hospice last year, end of 2012. Not knowing, I went to the door, gave them my card, said, hey, have somebody call me. Called them a couple more times, nobody returned my call.
Okay.
This is in testimony previously. I've never ever. Last year, after our first meeting, we did have a neighborhood meeting. I did talk to Julie Bright. She says, hey, talk to this person. We were in the parking lot over here. And hey, talk to this person, she's my boss, or however it happened. We did talk to them. We did not go any farther than that. I've never, ever made a statement that says we were in negotiations with the hospice. The hospice does not meet your criteria, neither does the church. Until we get denied here, we are not going to go to the hospice. We are not required to search every single property everywhere. We're not required to. This is what we're looking at. We are required, as one gentleman here said, that for an exception, this needs to be proven reasonably necessary for this exception. There is no property where we need to be at to cover what we need to do as a quasi-utility, except for the park. And we've discussed that. Sat down with a good hour with city staff. We've discussed that completely. That's pretty much it. We do have our experts here to tell you why we need this here and why it can't go down by Kmart and why it can't go up on the golf course. So if you have any questions on to why, any further discussions that particular area, we're more than happy to explain it to you.
All right. Thank you, Kurt.
You bet. Any other questions?
Okay, board members, as Kurt said, not only is he here, if we have any questions about studies, RF, maps, coverage areas, now's the time.
I would like to hear from Larry on, isn't there federal law that we have concerns about as a city versus what we do?
Sure, yeah, and I was looking at, spent a few minutes summarizing kind of an overview of the law at the appropriate time. If this is the appropriate time, Mel, I can do it now. Okay.
Perfect.
And I mentioned some of these things at the last meeting. I'll go a little more in depth. The Telecommunications Act of 1996 is really what instigated the whole revolution of wireless communications. The Eighth Circuit, Federal's Eighth Circuit, which is what we're in, it's the most direct precedent for anything in the state of Iowa. In one of the cases, they state that the Telecommunications Act strikes a balance between two competing aims: to facilitate nationally the growth of wireless telephone service and to maintain substantial local control of siting of towers. So there's a natural tension there. The desire of the federal law is to get national wireless service, but they still want to retain some ability for local jurisdictions to have some control for that these things are at the most appropriate places. So under the law, local governments have authority over decisions regarding the placement, construction, and modification of communications towers, subject to limitations. And I'll kind of go down the most important limitations as I see them, down the least important. The first one is that the regulation of placement or construction of a communication tower shall not prohibit or have the effect of prohibiting the provision of wireless services. And this is probably the most central issue in this case. there was a Fourth Circuit case that said the standard is, are there reasonable alternative sites to provide coverage? And that's, I think, really, look at the facts here, that's one of the most important decisions this board will need to make. Is there an alternative to what's being proposed here? The second important limitation that in any decision to deny a request for placement or of construction or of a communication tower, the decision for denial shall be in writing and be supported by substantial evidence contained in the written record. There's a split of between circuits in the United States. There's a couple in the minority who say a stamp of denial is sufficient. The Eighth Circuit, I think, takes the more conservative view that we need to show that that the written decision must describe the reasons for the denial and contain a sufficient explanation of the reasons for the denial to allow the reviewing court to determine whether there's substantial evidence to support the decision. The United States Supreme Court will be looking at this standard of what's sufficient for the written record. There's a case currently before the court which hasn't been heard yet. I think looking over a Georgia decision which has a circuit which just allows a stamp denial, whether that's sufficient or not. But I guess I would advise that if there's a motion to deny or even a vote being put forward for denial by any individual, that that in that case, the reasons for denial be stated and explained and articulated based on the ordinance requirements for issuance of the conditional use permit and an exception. That's what's involved here, is conditional use permit for the tower and an exception for the 10-acre requirement. The other limitations which aren't quite as germane here, the board needs to act within a reasonable time period. That's probably becoming more important now because we're probably in excess of 90 days from the application. The FCC has a limitation of 150 days, and that limitation from the FCC has been supported by the United States Supreme Court. So basically, a decision has to be made at the very latest in 150 days from the date of original application. And I think at the last meeting, we were plus 30. We're about another 60. So, you know, there's a little time, but not much. We're pretty much getting there. Another thing that, you know, fortunately, there's really been no discussion here on this, but that again, the environmental effects of radio frequency emissions can't be considered. That's just an absolute no-no. There's a Fourth Circuit case recently where a board, you know, had some legitimate reasons for denying a tower, but they brought in all the RF emissions and the radiation factors and all that, and the court said that's really the reason why you decided this and overturned the board in that case. The only other thing here is that any action may be filed in federal court under this law if someone if someone believes that the city or this board has violated the terms of the Federal Communications Act. That's a kind of a concise summary of things. I will mention a couple things. Some of the opponents mentioned the Eighth Circuit case from about 10 years ago involving the city of Des Moines. That was a very good case, but I'll just state that, you know, facts are different. That case did involve a site of a little over an acre, but actually a mini parcel on that about 40 feet by 40 feet. They kind of shoved it in the back, and in that case, they actually asked for not only the exception of the 10-acre, but a variance of the setback requirement. It's an 80-foot tower, but only had 20-foot setback from the property. And so they were asking for not only the exception, but a variance of 60 feet from the required setback requirement. Here we have 129, 129. But otherwise, everything stated in that case is good law. Basically, they did analysis of the board looking at the requirements of the exceptions and the variances. I'm happy to answer any questions in case anyone was confused over what I said.
Okay. Larry, a procedural question. Staff is recommending approval on this item. For us to grant approval, since we have 5 members here today, a minimum of 4
Correct.
would have to vote in favor of granting the request. Is that correct? Okay. I just want to clarify that. This isn't a simple majority. 4 of the 5 of us would have to vote yes for this to pass.
Yes.
Okay, thank you. Okay, so we've had input, we've had rebuttals. It's time to close the public portion and go to board deliberation. Let's have your thoughts.
Well, a thought, I guess there's a clock that ticks, and you have 150 days, is that correct? And we're probably 90 days into that.
A little over 90, I believe, yeah.
Okay. So if we wished to continue it and have it, try and work out with the city and Park and Rec, it's doable, but it would be very short.
I believe that's accurate, and I'll ask staff to say whether they believe those times are appropriate, or correct, I should say.
Repeat that again so I can digest it.
If we continued this,
Yes.
and the clock has 150 days, and we're 90-plus days into that,
That'd be cutting it real close. I mean,
Eric, do you know the application date?
The second question is, while Eric's looking at that, it seems to me that the proposed applicant is saying this is the best position for this tower. It doesn't say by law we have to give them the absolute best position. So if A is the best position and C is 20% less than that, are we in violation of any of the federal regulation?
I believe the standard is the Access Board can't be viewed as deny wireless service. So that's really the question, the hard question is there a viable alternative or not?
But let me ask this, because I know that thank you, that we are very specific about what we can and can't do. I heard the Verizon person say they're not really going to even look at other options because this is where they want to be. So if we deny it, then they would, I mean, if we say they can't build it there, then they would be forced to go find some other place, correct? I mean, I'm not convinced that there's not another place, but what I understood from all the testimony today is that they're not really focusing on anything else until somebody says absolutely not here. Is that correct? Are you with me? Does that make sense?
Okay.
Yeah.
I want to be careful that I'm not a board member, so I can't
No, I'm asking
take
you
the
for the
interpretation or
legal-
anything.
yeah.
Basically, if this is denied, their alternatives would be find an alternative, or they could take action, and assert action, and with the evidence they may or may not feel is appropriate, that it might be their position that they've presented everything they need to show that this is the only viable location. So I can't speak for them. They have presented evidence. I can't, it's really for this board to determine whether they've shown enough evidence to convince you.
Question. Does the board have the authority to approve this in a different spot? In other words, if we said we either have to deny it or approve it?
No, you'd have to basically only act on the application before you.
That's what
I've got a quick question. Because I'm a little bit confused too. It sounded like he said that they're not obligated to even consider any other spots. So based on our last discussion, if we said, could you look into this place, 33rd and Easton or whatever it was, and I don't know, I haven't committed to memory on what the record said. If he agreed to do that and didn't do it, he's not in violation of anything anyway, is he? Because we can't force him to look elsewhere, it sounds like. We can only deny this location?
Yes.
Okay.
Yes, that's true. But as part of the decision is for this board to make, that the city can't be viewed as denying wireless service. So then that begs the question, is there an alternative or not?
Right. Well, and based on what he said, is he's not obligated to find another one. It's burden of proof's on us, to why we deny it.
In that Fourth Circuit case, there is a standard of reasonableness.
Yeah.
You know, I think it's probably pretty clear, you don't have to look at every single property in the world, but a reasonable approach is, you know, in a reasonable conduct of the business.
The other thing that I had a question about is, explain this right of first refusal on this property piece to me, because
Well, that's something that I have not seen. I'm not sure if community development staff's seen it.
Well, and we don't review the lease for those provisions. That's an arm's length situation. There's nothing in the criteria that we would evaluate an arm's length restriction on. We do look for it to make sure that they would remove the tower when it's discontinued, or if the carrier abandons the tower. So that's the criteria we look for in the lease, and that's the provision that obligates them to provide us the lease.
What I'm concerned about was we had a statement from one of the opponents stating that they looked at it and seen it and they had this provision. Well, I'm not sure if staff's seen it. I certainly haven't seen it. I can tell you typically what a right of first refusal has in is that if someone approaches a property owner with an offer to buy the property for X amount, if they'd had a valid right of first refusal, the wireless company would have the ability to buy the property for that same amount under like a typical 30-day period or something like that.
Or you can get in a bidding war.
Well, it depends how well it's drafted.
Because I guess my question is, Eric wanted to see an executed contract.
Yes, that had that provision
there
for
was
the
some
removal.
formalization.
Right now, we have a redacted form which doesn't have all the signatures.
So I don't want to split hairs here. I'm just,
We put that in there so that before we issue the permit and approve the site plan, we want to see that in its full form.
Okay.
But what if there's something in there that would impact our decision? I mean, I'm not real wild about being forced to approve this and then have the church sell the property to Verizon.
I guess you would have to ask if there was something that led to your criteria that you have. So you could request information to be able to make that determination. I don't know if they have to provide proprietary information that's not relevant, that's.
Yeah, I believe the criteria where staff is concerned about it in the conditional use permit is that if the tower is discontinued, that the wireless company will take it down. And that's the important provision. That's in our ordinance, that's a requirement to get a conditional use permit. So we just need verification that that is in the lease.
We don't generally review other elements of the lease
Right.
for any other purpose under criteria.
The other thing that concerns me is that, I mean, we're just a group of citizens made up, we're not attorneys. And I heard somebody here say earlier that if somebody makes a motion to deny it, we would have to cite, the exact reason. I don't know that, am I qualified to say such practical difficulties cannot be overcome by any other feasible alternatives? I mean, that's might be what I think or don't think, but I don't know how I can say this is why I'm denying it. Property values, I don't know. I don't think any of us know.
Yeah, and I stated that because that is a requirement under the federal statute, that the decision to deny has to be based on substantial evidence in the record. So the reason has to be stated and an explanation for that. So that's just the requirement, and that's to be able to, so that a reviewing court can determine that this board has appropriately looked at the factors and has given a legitimate reason for denying.
So if we denied it and then Verizon took the city to court, and I don't know how many times the city's been in lawsuits with towers. I know they've been in there more than once or twice, which is expensive. I don't know how we come out on them, but it's based on our decisions that we're making. Would that then force Verizon to say, look, there are no other places for this tower to go? Because I don't think that I've received enough evidence to say there are no other places that this could be built.
Okay. Now that, of course, then that's your decision as a decision maker. You're in a quasi-judicial role here, making almost like a judge in some respects. Frank, what was the first part of your comment? I'm sorry. Yes. Has the city been involved in litigation? Yes, we have, but I believe the last one has been that Eighth Circuit case. It's been about 10 years. We had probably a couple before that. But I think the city does a good job, and the staff does a good job of ferreting these things through and hopefully find appropriate locations for
I mean, the
towers.
city's recommended that we put it here. This is what their research has said. And we're hearing from the neighbors, and when I make decisions on variances or exceptions, I know that we have to follow the law, and we are asking for an exceptions, but I think it's also important to what the neighbors think. You know, it impacts them. They're the taxpayers.
Correct, and those factors could be involved in the determination of whether exceptions should be granted or not. There are several exception criteria, including that exceptions by their design, construction, operation adequately safeguard the health, safety, and welfare of the occupants of adjoining and surrounding property, and then shall not diminish or impair established property values in surrounding areas. There's a few other things, but probably not real applicable.
I don't think any of us can say one way or the other. I mean, I can't predict what the future is going to be.
That's every case that comes in front of you.
Mr.
Those are
Chair.
the criteria
Yes,
you have.
go ahead,
Eric,
Cindy.
one point that was brought up was co-location issues, and I can't remember who, but someone said that there could only be one, the church had agreed to only Verizon and no other carriers because the other carriers would have to build little buildings and et cetera and so on. Had you heard that, or was that?
I've only heard that secondhand, statement made by Mr. Lippert, that he had spoken to Mr. Elder, or I'm trying to remember his last name. Yeah, so that's the only thing, and that's been placed on the record, so that you have that testimony in front of you.
And Eric, if somebody wanted to co-locate and they said, hey, I need my own little shed, they'd have to come back here in front of this board, and we'd have to consider that at that
I think you'd have to
time.
make that a separate action, a condition, because right now, it would be set based on the staff recommendation that we would evaluate it on an administrative level.
Okay.
That it met the same level of design and construction
Okay.
as the one that you're looking at.
And whether we agree with that or not, in essence, you would require it to be addressed before a little building would pop up.
We have a site plan review and a building permit, yes.
Okay.
So we would follow that order in our review of that.
Okay. Any other thoughts or questions for staff? As Eric mentioned, in any case, we have to apply the criteria for exceptions and variances. We have to justify our decisions. We have to make our decisions on the evidence and testimony provided and use your best judgment to do so and articulate that. So that is a heavy load for anybody. So let's have some discussion here. I know this is a long meeting. These are very important things to everybody who's in this room, so we need to discuss this thoroughly so we can make our decision as informed as possible.
Well, I just keep going back to this number one item for staff recommendation when they talk about at least one additional provider to be able to co-locate. I mean, if Verizon's having coverage issues there's, I don't even know how many more cell companies there are out there. There's more than, maybe there's 5, I don't know. Let's say there's 5. There's got to be more than 1 or 2 that are going to need to co-locate. So if we only set it up for one more co-location, now we're back here, whoever comes forth is back here saying, we need another tower, we need another site in this area, if this area seems to be a problem area. And I didn't ask the engineers, but I'm just wondering, if you move it, are you going to lose, and I think, Brooke, you mentioned this, are you going to lose 5%? Are you going to lose 10%? Or are you going to lose 50%? So without really knowing and understanding that, they show you those maps with all those colors and your eyes get blurry and you think, okay, I can't really tell one from the other. It gets very conflicting and confusing, but I just have trouble supporting this. I think it's a very small site. You go from 10 acres to a 3-acre site. That's real minimal. And there's also some safety conditions, you know, you talk about the ice falling down on a tennis court. Well, I can't really imagine that many kids out on a tennis court in the middle of winter playing out there. But yet they're going to put this at the main entrance of a church. That just seems to me to be a little bit contradictory. And then the aesthetics for the neighborhood, that bugs me. So that's my issues with supporting this, and they may not all fall under the legalese standards that we need to comply. So I could be swayed, but those are just some of my concerns and thoughts that I have just listening to all of this.
Very intriguing. Okay.
Well, one of the things too, I think we brought it the last time this was on the agenda was, have we exhausted options? And I'm still not convinced that they've looked elsewhere. And we asked them to do that. Nobody mandated that. We can't. What we're trying to do is, we can't prohibit them from having a tower or restricting service or whatever. But what we can do is we can look for middle ground that everybody can live with. Who can talk about this other site that we didn't get looked at? Is that Ben? This 33rd and Eastern or whatever? Is that city property? What's there now?
Well,
No, that,
if you feel a need to do so, we can bring him back up here.
well, I just want some clarification, because I expect people to, okay, I'm gonna meet you halfway, and I don't feel like we've been met halfway.
I think there's one thing
I feel like I'm in a corner.
I think we've got to keep in mind, it's the coverage. It's not that there's another site nearby. There's already coverage in those areas, so they don't need to look at those sites, and it wouldn't do them any good.
He didn't say that, though. He said, we don't need to look elsewhere, and until you deny this, I'm not going to, because we've already spent 30 grand. He went and knocked on the door at the hospice. That's like me driving by there and throwing my card out in the parking lot and hoping that somebody.
And he
picks it up.
called back twice, and if you got a manager
So,
asleep at
I
the
guess I'm
switch,
just
I'd,
thinking here,
yeah.
is everyone looking toward the greater good here? And I don't feel like it is. Now, that's my opinion personally.
Okay.
I thought we ran him through the ringer at the last meeting, I thought. I know I did. And I thought, okay, we're going to have some middle ground here. Hopefully he'll come back. And I saw it on the agenda. It's like, great, I'm looking forward to hearing what he's saying. I didn't hear anything new.
Okay.
So.
Okay. Brooke.
Regarding staff recommendation number 1, which says accommodate the necessary ground equipment for at least one additional provider. And then someone from the neighborhood said that the church thought or feels, and they're not here, that it's only one provider. I would think that would be, we would need that information to vote on the proposition. I would say we continue it and see, for 2 reasons. One, we don't know the answer to the staff recommendation number 1, and number 2, to ask the applicant and the Parks Department to see if they can work anything out.
Okay, I don't disagree with your premise, Brooke, but continuing to push the city to come up with the answer here, the city's not the applicant, and we can't ask the city to come up with solutions that they don't want to. The director of the Parks and Rec Department is here. If there were any alternatives he could provide, I'm sure he would have done that, and I think he did that. As far as getting into the church not being here, I wish there was somebody from the church here to step up and speak, besides good old Kurt from Rochester. We need to have the people from the church here to speak about this.
The church signed the application.
But yes.
And it's a condition of any
Okay.
approval to have that second carrier. So they've.
Does the church
signed into-
agree with the staff recommendations then from at
That's
least
a
your
different-
perspective?
That's we don't know that.
And I think that's what Brooke is getting to here. If we would approve this, we have this in here. Does the church agree to it?
But their application obligated them to that standard. So
Okay.
I just want to point that out.
Okay. Perhaps that helps a little bit on that. But I don't want to continue this and put the people from this neighborhood and those that are concerned about it to make them come down here 3 times in a row. I think it's pretty obvious where the 2 issues are here. It's our job now to make that decision. Whether it's good or bad for one party or the other, we just need to make the decision that we believe is right, justified, and defended by the exception criteria. That's our job. That's why we're here.
Mr. Chair, I wanted to get back to you on the question of the time. The application
Yes.
was made on February 26th, which puts you around July 26th for the shot clock provision. That's before the July meeting, I
Right.
believe.
Okay.
Which is the 28th, if I recall.
Yeah, it's the 22nd, or...
Oh, okay.
Yeah.
So it's right on that. The other thing is we have an administrative action that has to occur after the board's approval on to issue their
Right.
permit. So there's a little bit of time that staff would need to have after that. So to give you a sense of the timing, and if you're looking to continue it from that standpoint.
Yes, Rick?
I would move staff recommendations, and I'm going to preface that with, I think we're in a very tough spot, and it's one of the few times I would side with the city and probably vote for this, just because I think we're going to get sued, and probably can't win. So I'm recommending staff recommendations.
Okay. I think to have a little discussion on that, we've got a motion here for staff recommendation. If we look at the exceptions by their design, construction, operation of what's being proposed here, and this was mentioned, and I want to go back to it. We have to ensure, if we want to approve something, that it adequately safeguards the health, safety, and welfare of the occupants of adjoining and surrounding property. If the church people want to stand under this, if they want to swing from it, whatever they want to do, that's their property. You can be perhaps as silly as you would like to be. But we have to make sure, is this going to affect the health, safety, or welfare of occupants of adjoining and surrounding property? We have to make sure it won't impair an adequate supply of light and air to adjacent property. Decide if you think it does or doesn't. Will it increase congestion in the public streets? You have to decide that. You have to determine that it will not increase public danger of fire or other safety concerns. And you have to determine it shall not diminish or impair established property values in surrounding areas. I think that's probably, that last one is maybe the most important one. And everybody's talked about, they don't want to look at it, that it might, and I underline that word might, I heard that 3 times, that might affect my property value. I'll tell you what affects your property value. The neighbor that doesn't mow their yard, the neighbor that doesn't shingle their house, doesn't paint their house, has their dogs running loose, their fence falling over. We all know that's what affects property values. These people take care of their properties. I don't think if a realtor comes to this neighborhood, they're going to stare 150, 250 feet away and be perplexed and mesmerized by a monopole cell phone tower that's in the middle of a church's lot. It's not shoved in the corner. It's not right up in somebody's face. But I think that'd be the keyest provision here, that if it does diminish or impair established property values. I don't necessarily think it does. But then we can get down into the 4 exception criteria as well. A big one is that the applicant has determined that there are practical difficulties that can't be overcome by any feasible alternative means other than the exception. He's looked at other sites. The city's basically told him no. The only site that would work for both of them is the entrance to a 100-year-old historic park. We talk about the historic neighborhood. Do we want to ruin it by putting it right in front of the park? And the city said no to that. If he looks too far elsewhere, it does no good to even have the tower. He's got to look at this area. I believe that he has provided the information. I can't see them messing around with pixels to try to fool us with a diagram here. They've given the best that they can. You have to decide if Kurt's argument is the best or not. But I believe they've tried to look at any feasible alternatives. It has to be reasonably necessary due to practical difficulties related to the land. The only land he could find a deal for is this little over 3 acres. It's less than the 10 required. What are they trying to do? Put it in the middle of the site. The person that's going to look at it and trip over it are the churchgoers. It's right in the middle of their property. So if anybody's taking it in the shorts, it's them. And finally, it's got to be in harmony with the essential character of the neighborhood of the land in question. It doesn't have to look exactly like something else. We have light poles, we have fire hydrants, we have telephone wires, cable wires. If you're going to have a cell phone tower somewhere, the brick will match the building. I don't think I see that often like that. The monopole will be next to the church. Unless you're really breaking your neck, I don't think you'd even really notice it. That's just my opinion. I'm one of 5 people who are present here today on what is a 7-member board. But that's how I'm going to base my vote. I believe that they have met the requirements for the exception. Do I think it'll pass? I don't know. But I tell you, we have had cell phone towers in other neighborhoods in the city, which we've approved here on acre-and-a-half parcels on Hartford and South Union. And they didn't look like this one. I would apply the same criteria whether this was South of Grand, East Side, South Side, Beaverdale, same thing. I think everybody's trying their best here to come up with an application that works as best it can. This is the best one I've seen for years. I'm not sure what cell phone tower presentation we've seen that looks better. I think this is the best that can be done with the factors that the applicant has and the things they're trying to deal with. So with that, I'm going to second Brooke's motion. So we've got a motion and a second. Any other comments before we vote? Okay, all those in favor to grant approval subject to staff recommendations, raise your right hand, say aye. Okay, that's 3. All those opposed? That's 2. The motion fails.
Could I just have clarification? Like I heard from the Niles, is issues with co-location, capacity for co-location on the tower, a small site, safety conditions, and the aesthetics impact of the neighborhood, and that for those reasons not satisfying the exception criteria. Is that accurately?
One other one is that there's other sites available.
Okay.
Mr. Chair, typically
Yes.
on this situation, on a tower, we've asked for then the decision to be brought back to you to vote, that it reflects your decision. That's an option, I suppose, and I know we're on a shot clock too, so that.
I suppose it's an option, but I think that's typically been done when there's been an approval. And I don't want to be, in a position of next month and getting a procedural mess with the votes. And I think.
Point well taken, though, Eric.
The statements haven't stayed on the record. I think we can boil those down, and then Mel, before he signs, can take a look to see if it's accurate.
Right. No, that's a very good point. Right. Right. But as Larry said, usually in that case, we're granting something, we want to make sure that why we're granting it is clear. I think that those that have voted against this have made it clear why, what their concerns are. That'll be reflected in the record for the decision and orders that get signed. And that'll be reviewed by the chair to make sure that's accurate. Okay. All right. Okay, all right. For those here for item 11, we need a very short break. I think it's well earned. Thank you for the rest of you for coming down and spending the afternoon with us. this afternoon.
So we'll jump right into item number 11. It's a request for a conditional use permit at 500 Grand Avenue. It's actually on the second level of a mixed-use building. It's the Hawkeye Pantry. It's been operating as a limited food sales establishment or grocery store for several years. As such, they've been allowed to sell beer, wine, and alcoholic liquor so long as they don't exceed 40% of their sales from, or drive at least 40% from the sale of alcohol or tobacco. They have supplied an audit to the city that demonstrates they have been meeting, or have only been selling or deriving 39.55% of their sales from alcohol or tobacco in the past year. The zoning officer is still working on getting that audit, I guess, formally approved. There's some question about whether the person who prepared it's licensed in the state of Iowa or not, but that's covered by condition number 1 in the staff report. So here's the layout of the pantry, or the Hawkeye pantry. It's just I believe a 2,596 square foot area within the skywalk level of the building. Here's a photo of the building, or of the business from the skywalk. This is taken from one of the skywalks. The business is operating in this portion of the building here. There are a few signs inside of the windows for the business. And this is just next exhibits the liquor agreement that shows how they've been giving their liquor licenses in the past as a grocery store. And then here's the consent map. The cards are going around. Staff has recommended approval of the conditional use permit. Since this has been an existing limited food sales establishment with a current liquor license since July of 2012, they are not subject to the separation distances. And also, even if they weren't existing, since this is in the downtown C3 district, they're also not subject to the separation distances. So they do meet the condition or the requirements for granting the conditional use permit. In the interest of time, I won't read through all of these conditions, but we have recommended approval. The first one's just that they get final approval of the audit by the zoning inspection zone, or the neighborhood inspection zoning administrator. So, any questions?
Police reports for that. Were there any specific things related to the specific location, or could you sort that out from the radius?
Yeah, I had made note of very few. In fact, yeah, I think the only one I had noted was shoplifting, which I think that's pretty common for any business, so.
Right.
What's the address?
501, well, it's on the parcel known as 500 Grand Avenue, but their mailing address is 501 Locust. It's in the staff report.
Well, so what are we looking for here? 501?
Yeah, 501 Locust.
Well, do
Or
both addresses show up on here?
multiple times?
Yeah. So which address?
Well, either one. Another way to look is if the premise is for a grocery store or for a liquor store.
So were we supposed to look for both 501 Locust and 500 Grand? I'm confused. Which is on the police report are we supposed to look for?
501 Locust would be their business address, so you can look for that one.
Well, then is your notes wrong? It says 500 Grand.
Correct.
The parcel that it sits on is 500 because it goes through the.
Both addresses show up on the police report.
Right, and 500 is a big parcel, has many, many different uses, so it's, yeah. As you can, here it says it's on the, within the second level of the mixed-use structure at 500 Grand Avenue. The businesses within the area access directly from the skywalk. Its mailing address is 501 Locust Street, Suite 202. So when I went through the list I looked both for 500 and 501. The only one I could find that was relevant was this one here at 501 Locust. Any other questions?
Okay, we'll check back with you. Thanks, Bert. Okay, applicant or representative of the applicant? Thanks for your patience this afternoon.
No
problem, and may it please the board. My name is Brandon Brown. I'm a lawyer with the Parish Law Firm here in Des Moines, and it's my pleasure to represent Hawkeye Pantry. I also represent two other convenience stores that you will hear from. One has been continued to next month, the Fast Mart at 1401 East Buchanan, and there's a third application on the horizon out there, Oasis over on Payne. So it's my first time in front of you, but not my last. And I will be able to respond to your question, Mr. Rosenberg, about the address. I can clarify that in a minute. But before I move on, I would like to thank both Bert Drost and Sue Ann Donovan. They have been very helpful in our efforts to present our case and this item to the board. A lot of the work that we do is behind the scenes, and you probably can appreciate but don't know all of what goes into it, and they have been absolutely fantastic to work with. If I have a telephone call or an email or a correspondence, they get back to me immediately with information that I'm requesting, and I just want to give them some public recognition for all of their efforts.
We're happy to hear that. They do work hard.
By way of background, I just want to also introduce my clients. Chancellor Cholera is right in the back there. Yeah, if you just stand up for a second, Chancellor, just stand up. And Harry Kama's here. His wife, Reka, could not be here, but both of these individuals are here. Chancellor is the operator at Hawkeye Pantry. Okay. And he and Reka, Harry's wife, they own the business. And they also have the two others that I discussed, the one at 1401 East Buchanan and the one on Payne. Just a little bit of background. I think it's important for all of us to know who we're dealing with when we're making these kinds of decisions that could impact their future and their lifestyle. Harry was the first of the three to immigrate to the United States. He came here after his father had worked for several years with the United States Department of Agriculture out in California. Harry moved there, established a residence, and eventually his wife joined him in the late 90s. Early 2000s or so, they decided that they wanted to have children. At that time, Chancellor was going through a divorce. He had two children, and he was also looking to make a move. They looked all across the United States and decided that Des Moines, Iowa fit the appropriate profile for them to start their family and continue with their businesses. At that time, they had some Subways out in California. They sold all of those and picked up all their belongings and moved to Des Moines, Iowa. They've been here since the early 2000s. They've slowly worked their way up to 3 businesses. They also own a Subway out in Indiana. They are raising their children here. They're all 4.0 students in school and have been doing a tremendous job. I also want to point out, I think there was some question about the criminal history at this particular address. I want to address that. There's 2 addresses that are in play here. One of them is the parent leasing company, which is located at 500 Grand Avenue, but the actual pantry's physical location is at 501 Locust. So when we're looking at the crime reports, you should be looking for the 501 Locust. And from my review, and I agree with Bert, it appears that there's only one citation or one criminal complaint filed, and that was for shoplifting. Right. The hours for the food pantry or Hawkeye Pantry, they operate from 6 in the morning to 8 at night, Monday through Friday, and then on the weekends they're open from 10 a.m. to 6 p.m. They did this for a couple of reasons. One, as we all know, especially in my line of business, there's an old saying that nothing good happens after dark. So they try to close their doors to avoid any of the issues being a downtown business with people leaving the bars and the restaurants and the like and causing issues there. Mm-hmm. So they have been very particular on selecting their hours. Mm-hmm. Also, one thing that I think it's very, very important that I established with this board is that there's been a lot of press coverage about synthetic marijuana busts and arrests and K2 in the Des Moines metro area. And it should be noted that none of these 3 locations are involved in any of those investigations. They're not involved in any of those arrests. And in fact, both Harry and his partner have had many times been approached to sell this product. However, even being told that it's very profitable and you can make a lot of money, they've been completely steadfast in declining these offers because they know, and they've represented to the solicitors, what you're trying to do is convince us to sell product like this near schools because one of their locations is near a school. There's downtown where people, young individuals are. And we don't want to do that. We don't want to create harm in a community where we're raising our own children to be very productive members of society. So these are the kinds of people that are operating these businesses, one of which is Hawkeye Pantry.
And Brandon, I might encourage you, you're doing a fine job, but
Yeah.
let's just focus on this.
That's what I'm
business
getting to.
alone. Yeah.
And that's what, it's important because it kind of ties into
Sure,
this
sure.
issue
Little
with the audit.
Okay.
And we originally contacted a firm out of California because that's where Harry was originally from. That's where he had set up all of his accounting sites for doing the taxes and things. Unfortunately, because of the timing, we were right around tax season. And we were referred to an individual in Chicago. And we knew that we were on time lease and extensions, and this is actually our third one, and it expires, I think, the 1st of June. So this is the last meeting that we can present our case before we run out and our liquor license expires. But we were able to get an audit done. And we went back and we did an audit that was much more thorough than even that was requested from us. The audit goes back rather than 6 months. We go back, I think, through all of 2013, then January through March 31st of 2014, because we wanted to be very clear that the total gross sales from alcohol and tobacco did not exceed 40%. And it's clear in that audit that we're right below that threshold, which would meet the criteria for us to obtain a conditional use permit. However, there were some questions about the preparer of the audit, and we gladly went back and contacted this gentleman, and he originally provided us with a certificate indicating that he's a registered tax preparer. However, the letter that Hawkeye Pantry originally received requested that it be done by a certified public accountant. And I wanted to clarify that, so we went back to our accounting firm and again talked to them. And they said, well, although I'm the president, I provided you with my information. There is an individual who's involved in all these types of audits, and I have provided a copy of his CPA license. I have one here for the board as well. I'm sure we can mark it as exhibit if first we're graciously accounted with a stamp. And I can circulate them as well. But it shows that we have an individual, Mr. Patel, who is a certified public accountant in the state of Illinois. But again, when we were originally contacted, it just said, have somebody verify it who's a certified public accountant. So that's what we did. I spoke with the individual who runs this accounting firm. He has indicated that Mr. Patel is a manager there. He was involved in the review and the preparation of our audit, and everything comports still with all of the appropriate standards for a CPA. So we're asking the board, because we do have some verification that it was a CPA involved who prepared the audit, and we meet all the other criteria. It's a very low crime area for us in terms of activity in or around our office and facility. Also, it's in the Skywalk, as Bert had indicated, so we have 24-hour security there. There is patrol officers, there's private security that comes through. We have all of the notices and the signs conspicuously posted. I mean, the Hawkeye Pantry is an institution in the Skywalk. It's been around for, I think, 14 or 15 years if you look back at the liquor licenses. So it has consistently maintained good standing in the downtown area, and we would ask that the staff recommendation be approved. However, in lieu of awaiting a conditional use permit for verification of a CPA, since we've provided that already, we would ask that the board summarily approve our request for a conditional use permit. I'm trying to be quick. I know you have an ambitious agenda ahead of you, so if you have any questions, please feel free. And if there's any issues, I would like to reserve just a brief period to talk if necessary.
Sure. And Brandon, an initial question that I might have, and this might go before my time or your time here, but you said it's been there 14 years. There used to be an issue with one of these in the Skywalk, maybe Sun Mart or something?
Well, I know one has moved recently. I don't know if it was a Skywalk location, but
this
there
may
was...
be more of a staff one. It was a different location?
Yeah.
Oh, okay, because we had an issue with one location, and I think that might have been part of some of the council's reasoning to change some of our ordinances on how we do look at the smaller retail, quote, grocery stores.
Yeah.
You know, your client might be real close to the line now, but are they looking at expanding like fresh fruit, dairy, fresh meat? I hear that all the
Yeah.
time from people downtown. You know, if you're selling a lot of liquor, or if you put a lot of liquor, or, well, not liquor, but if you put a lot of alcohol out there, that's what people are gonna buy.
Well, and with the Hy-Vee that's,
Right,
on the
right.
agenda.
But if
we
they
have to.
continue to look at getting more into the grocery thing, I think that will help them in the future maintain their status.
And I think they're building that into the business plan. I mean, that's kind of the whole point of the conditional use permit is so
Right.
we can return and revisit.
Got it.
And at this point, I believe we meet all the criteria, so we just ask for the permit.
So you're trying to work more toward that side of the coin, just to keep yourself with a significant enough buffer there, right? Okay. And there's good CPA firms right here in Des Moines, just like there's good attorneys.
Correct.
Right?
And we have 2 more locations, and you may see a change in guard in that regard.
Okay, so
Not lawyers.
any other questions for Brandon? Okay, thank you, sir. Anybody here to speak in support of the applicant? Is there anybody here to speak in opposition to the applicant? Okay, seeing none, no need for rebuttal by the applicant. Any further questions for staff? All right, hearing none, we'll close the public portion, go to board deliberation. Thoughts?
Move staff recommendation. I'll second.
We have a motion and a second to move staff recommendation. All those in favor, raise your right hand, say aye. Opposed, none? All right, 5-0, motion carries. So thank you for your patience and keep up the good work down there. Okay.
I think is it 14?
Let's
13,
see,
yes,
we've
13.
got to do 13. 14, we moved to
I'm
consent.
gonna have to get reading glasses, I think, 'cause I
Well,
was on the completely.
Eric, you're getting to that
I know, I'm-
age, trust me.
Earlier, I was on the wrong staff rec entirely, so apologize for that.
All right, item 13, variance request at 3518 Southeast 19th Street.
Yes. I believe this area, this is just off of Evergreen. Evergreen is east-west street, and the address is off of Southeast 19th Street, but the location of the proposal. What's that?
You skipped. I'm sorry. I thought you were on 12.
No, 12 was continued.
12 was continued to next month, yeah, so we're on item 13 here.
So they have an existing box here. It's at the southwest corner of the
Sure.
property, so when you look at the, if I point to the location here.
Sure.
We're talking about that.
Okay.
There's a driveway just to the west of it on the
Yep.
property that does front Evergreen Avenue. You can pretty much see what's being proposed. Their proposal extends this little lease area so that they can accommodate 2 additional cabinets and then maybe a future 4th cabinet that would be an additional power source, I think, if they get to that point with their growth. So they have supplied us with a site sketch of how this was submitted, as to how this is the existing, and you can see they're about, I think they're about 3 feet off at this point.
Okay.
With their little cabinet there, and if you scale it, we determine that. They're bringing this, the new box is taller and will be a little bit closer. They're about 1.9 feet. The other elements to this are there's two other, this is, I think, a future, not immediate. This is the power source, and then there's a meter that faces interior to the property. Now, note on here, there's a pet burial site here.
Yes.
That prevents them from going even further in their negotiations with the owner.
Okay.
So they've got some constraints that are kind of outside of the typical in this case. Otherwise, I think we would be having them push it back and, just relocate everything, including their pad. So, getting back to the, we think it meets all of the standards that are applicable for these utility boxes that are pushed within the front yard setback. And we think because of that proximity of that other pet burial site, they're limited in being able to shift it to meet the setback. And there is separation on these cabinets from a safety and access perspective. So you can't just cram them together and not have clearance for doors and people to work on them and maintain them. So there's some acceptable separations between those. So and they've placed these in an orderly fashion to meet the standards. And they're, you know, they're following all the other elements. So in staff's review of it, we believe, based on the public utility need and the reasonableness that this meets the test for the variance that they're applying for. We do want to make sure that it's in compliance with all permits and the sketch that you just saw, and that in addition, they do need to put some shrubs along that west edge to screen from that neighboring property to the west. So I don't think a fence would be a good thing there, because normally we want fence heights to be less than 3 feet when they're in the front yard setback, so we want to push that.
Well, and then we would create an alcove or something, wouldn't we,
Yeah.
as well? Kind of a
The
hidden
plant
area.
material's probably going to soften it up better anyway. So.
Right. Is there a reason this was not on the consent agenda?
Other than it was a variance, I don't know.
Okay.
Yeah.
All right.
I don't recall the discussion as to why we didn't. put it in the consent.
No opposition then on the map?
No, that's the consent map here.
Yep.
We notified the 250 based on a
Okay.
variance.
Okay, great. Any questions for Eric? All right, thank you, sir. Applicant or representative of the applicant? Okay.
Okay, I'm Dave Harris. I'm an CenturyLink employee, and I would like to point out just a few items on this.
Sure.
I don't think I need to give you a long history of the telephone company.
Dave, I don't need a long history, but could you give us your business address?
Okay, it's 2103 East University here in Des Moines.
Thank you.
50310. Okay, the existing, what I was want to point out is the existing cabinet is about 6 feet north of the sidewalk. And on his sketch, the fence, the property line is actually 4 feet north of the sidewalk.
If you maybe want to lay that picture by the camera and then point at it, that might help us as you refer to it.
Okay, yeah, that's.
Or maybe that plan view, I don't know if that would help.
This one's
Okay.
almost the same picture.
Oh, yeah. I think I like yours better.
Okay, but that existing cabinet, we can see that it's not up against the sidewalk.
Right.
And there's like 8 feet between the sidewalk and the curb, so we're not going there. Traffic actually going westbound on Evergreen won't see that cabinet or the new one.
Right.
Until you're right in front of it.
Yeah.
And you mentioned some shrubbery. What I'd also proposed, we have to move those fences, which would be at our cost. And if you'd like, I could extend the fence along that chain link so it'd be consistent with the wood fence all the way along, or we could do some shrubs.
Would you be planning to take out that section of chain link fence, or is that, no?
Chain link is on the other
Okay.
person's property, and that actually runs a long ways north.
Sure, okay.
And
just that section.
Yeah, and what they've done for privacy fences, that fence goes through many yards as it heads north.
So is what you're saying that if you have to take out these sections of the fence to get your installations done, but when you're completed, you'll kind of put the fence back?
We will
Is that what you're saying?
actually move the fence a little bit to the east.
Sure.
And a little bit north. In other words, our cabinets will be outside of his backyard.
Okay.
Part of the reason for requesting a variance is this provides the least amount of inconvenience to the property owner and takes up the least amount of space. What there is a 10-foot public utility easement running north and south along there, and we were making every effort to try and minimize the amount of property we would use.
Okay.
So, if you got questions,
Yeah, any questions? Very brief one. The staff has that you'll put some shrubs then on that west side, which would be just to the right of that chain link. You okay with that? Put a couple decorative plantings in?
Yeah, we can
Okay.
get some in there.
All right, so you're okay with the staff recommendation with those 3 conditions?
Yes.
Okay, great. Okay, thank you.
Okay, thank you.
Anybody here to speak in support of the applicant? Anybody here to speak in opposition? Okay, hearing none, we'll close the public portion, go to board deliberation. As a South Sider, I drive by this thing at least once a week, never noticed it. Very nice area on East Evergreen. As such, I'd make a motion to approve the variance as requested, subject to staff recommendations. All right. All those in favor, raise your right hand, say aye. Opposed? Nay. Motion carries unanimously, 5-0. Okay. Now, that will move us on to item 15 at 4502 Southeast 14th Street, a conditional use permit.
This item is a request to convert the existing building to a tavern use, and it would also, they also propose to construct a 576 square foot deck on the east side of the building, so it'd be the side facing Southeast 14th Street. The subject property is at the corner of Southeast 14th Street and East Emma. It's along a commercial corridor. The business was previously, or this building was previously occupied as a payday lender use that's since gone out of business. Staff, I guess here's the site sketch that the applicant submitted. It shows the existing building. We have the kitchen at the south end with a bar and then some tables in the middle and the restrooms at the end, and then the deck would be on the east side of the building. Here's a photo of the building. Hopefully it shows up on your monitors better than the screen. You can see there's an existing billboard on the property, and there's the building, and then the parking lot to the north. And the consent map, we did get a couple cards come back in opposition. Then the police reports, it's the first time I can remember that the police reports for the 500-foot radius only showed up, or could fit on one page, so I don't think this is a hot spot for crime. So staff looked at this and we felt it met the criteria necessary for granting the conditional use permit. A new tavern requires 150 feet of separation from any church, park, school, or daycare, and it does meet the separation distances, so no issue there. So we've recommended approval to subject to 10 conditions, and for the sake of time, I won't read through those individually. Any questions?
Where was the deck again, Eric? I'm sorry.
It would be on the east side of the building. So if you see the building, the aerial, it would be in that area right here.
And Bert, is it going to be covered, or what kind of railings do we have? Do we know? Do we have any profile drawings?
No, they didn't provide the profile.
Okay.
I know
I mean, it almost looks like the deck isn't entirely on the paper there for the drawing.
In order to get the liquor license, we'll have to demonstrate the outdoor service area is surrounded by a
Okay.
4-foot tall
Okay.
fence or barrier.
On the cards here, it looks like we're about half and half, but one of them is addressed, Jim Kern of 6145 138th Avenue in Indianola, thinks it would be great for the south side. Does Mr. Kern own one of the properties nearby?
Yeah, he owns.
Is there a J. Kern, or?
There's a
Okay.
property right here, yeah.
I think that's an abandoned house, if I remember right, isn't it?
There's
You
a-
familiar with that? Sue Ann?
Mobile home park.
Yeah, there's an abandoned house there. Looks wonderful. All right. Any questions for Bert? Okay, let's go ahead and hear from the applicant or representative of the applicant. Is the person who would like to have this done here? Did you have a conversation with him?
Talked to him in a couple weeks.
Did he kind of understand how the process works?
Yeah.
Okay.
We had a pre-app meeting too.
Okay. Since he's not here, I'm going to come back to staff. Is there anybody here to speak in support of this? Is there anybody here to speak in opposition? This is extremely surprising all the way around. Okay. Further questions for staff? You haven't heard back from Easter Lake or South Park?
I've spoken with Jim Ballard on the phone a couple of times,
Okay.
and he wasn't overly enthusiastic about it, I can tell you that.
Yeah.
It didn't sound like he had the he was busy this afternoon, so he couldn't come down and address the board, but we
Which is
didn't get anything in
understandable.
writing.
Okay, he didn't send anything in, okay. So from staff's perspective, are you looking at there's adequate separation from residential and seems to look okay to you guys?
Right, it's along a major commercial
Okay.
corridor, so if there's a place we would put taverns, it would be along major commercial corridor.
Did they talk about live bands or anything?
They didn't, one of the conditions we were recommending was on number 2, we had said that should have no outside speakers or amplified sound except in compliance with a Type E sound permit, which
Okay.
the Type E is just the auditory background noise, so it can't be very loud.
Okay. Okay, I'm a little concerned that the applicant isn't here for. Yeah, let's come back to that in just a second. Well, let's see, first of all, do we have any other questions for Eric, or Bert?
Well, I was curious about the deck. It's on the
On-
busy side. Is
right.
there a reason they're not putting it on the quiet
Well-
side?
Well,
It
then-
would be awfully noisy sitting out there.
Right.
But then you can see everybody driving by. Yeah.
I personally think the east side would be better since there are residential uses.
True.
I know the Mr. Six, who owns this property, also owns this house here. But, so I guess his own property would be most impacted.
Right. Did the car lot directly to the south recently discontinue operations? Sue Ann, you remember? Okay, that's okay.
Photo does look.
Yeah, I think that was one with the 57 Chevy with the flames on it sticking out the front. Yeah, you can see it there. Okay. Just curious if we got the same landowners here or if, people are looking to combine properties and redevelop.
Are they going to take the existing building and rehab it, or are they going to tear that down?
They are.
Well, we're going to rehab it.
Building.
Would they be allowed to reuse the freestanding pole sign that's there now? Okay, yes, okay. Okay, all right, any other questions for Bert?
They wouldn't be able to use the full sign, would they?
Hey, Sue, what the?
If it hasn't been in
Yeah,
use for
even under the old ordinance, how long before it, quote, expires?
like 6 months.
Chair, members of the board, Susan Donovan, zoning enforcement officer. There's a pending ordinance change regarding pole signs. If that pole sign became, well, if it was vacant for more than 6 months, if the new ordinance passes, yes, it would
Okay.
have to go away.
But under the old ordinance, before the moratorium and all that, what was the idea on unused signs? Did they have a limit on time?
No, they did
No,
not.
they did not, okay. That's why
We
bullet.
made them take the
faci-
advertising
fascia.
off,
Okay.
but they could
Okay.
leave the sign and the.
Okay, got it. Okay. Bert, one other question. Do you know anything about the applicant's history with liquor licenses or operating bars?
I do not.
Just anecdotally, nothing?
No,
Okay,
the title holder is Mr. Six,
okay,
but the people operating the bar were going to be leaseholders.
okay.
So.
All right. Okay. Thank you. Okay, well, we don't have much to work from here today except what has been presented with the staff. So let's close the public portion and go to board deliberation. Thoughts on this?
I would accept it. In no staff, correct?
Okay, all right.
Thinks it's okay.
But before we do go to vote, I will say this, Southeast 14th has been coming a long way. This is probably one of the key areas that still has a long way to go. We've got a dilapidated trailer park, that green house in the green square, that is a derelict abandoned house. The city's had to come in and clean up that guy's lot. We already have a bar to the north at Donna's Lounge. We're trying to seek reinvestment down there from a lot of the neighbors that have been working on things. If I was to vote in favor of this, I'd want to know a little bit more about what's going on. We have a sketch. We don't have the applicant here. I don't know anything about their background. I don't want to create another zoning issue down in this neighborhood, but that's just me. I know we have a motion out there, so we've got a motion and a second. All those in favor of granting the requested conditional use permit, raise your hand, say aye. 3. Opposed?
I'd like to see the applicant show up.
Okay, so the motion does not carry, correct?
Where does it say the applicant has to be here?
Well, that's true.
It doesn't, but for me to make an informed decision, I don't really have anything besides a sketch and some brief
So we're going to
comments.
cost the guy an extra $300 to come back?
Well, we could put another motion on the table, couldn't we?
Yeah, someone from the prevailing side agrees to a
Right,
motion to
right.
continue.
Someone put a motion out there pretty quick to vote on. I would have been happy to continue the issue, but there was a motion already out there that was thrown out pretty
Is
quick.
there anything in the code that says the applicant has to be here?
No. But
Thank
Brooke,
you.
I've heard you say before that you want to hear from the applicant before you vote on things. And don't swear while you're up here. Don't do that. Don't swear while you're up here. I won't put up with that. You did too. Don't take somebody's name in vain like that. You want me to tell you what you just said? Okay, do we have another motion on the table?
I'll move for a continuance, or do we have a motion?
Great, get out of here then.
And I'll second that.
Okay, all those in favor, raise your right hand and say aye. Motion carries to continue, 4-0. Stay tuned at home for more interesting things at Zoning Board of Adjustment. Moving on to item number 16. Blue Heron Properties has a variance request at 3117 Grand Avenue.
Yes, Mr. Chair. I got several photos, so, and we had many cards in response, so we'll have to make sure you have plenty of time. This property is located west of downtown along Grand Avenue corridor on the north side. The character of the area is a kind of an eclectic mix of ages of higher density housing and office use, condominiums, rental apartments, assisted living. So you have a kind of a blend of types of residential uses there. Looking at the subject property, it's a little bit smaller scale compared to some of the surrounding properties. There's two parcels going on here. This sits on the easternmost parcel, and I think I have a photo here of the one that's further west. This is looking at it straight on from Grand. And this sits quite a ways back, so you have this parking area that forms the front of the property, and the desire is to place the enclosure in this area right here, if I can get it to focus. I don't know if... Okay. You can see it might be hard to see with all the shrubs and so forth, but this is where the container is being kept at the current time. My understanding is there's no historical, basis to allow that to continue to stay there without the enclosure. They're under enforcement action. So their primary argument for not placing it outside the required setback, which would put it back 50 feet, is still well within the front area of the building here. They believe their only other alternative was to put it around back, which requires the servicing vehicle to back off of Grand. I don't really see how that, and I don't see any templates. Nothing was provided that would demonstrate that a servicing vehicle couldn't make it into this site to service a location back in this area. But the reality is it could set anywhere in this area. They could, take out some of this open space to make an enclosure. They have to abide by our current standard, which is a masonry brick enclosure with solid metal gates. That's the standard that we impose now for new enclosures. Trex and wood are not sufficient in this case. Given the character of the area, most of the buildings are of high quality material in this area, so the character demonstrates a high quality as well. So at this point, we just don't see any basis for granting the variance. We don't see an unnecessary hardship. So at this point, we're recommending denial. And then I'll show you the consent map, which I just had. Well, I apologize, there was 2 letters that I didn't pass around to you. One from Norfolk Grand Group and one from Des Moines University, and then another card that was a photocopy. So a lot of the responders were the owners within this condominium to the southeast. And then the larger parcel areas are in red too. I think I'll probably have Bert zoom out a little bit to get a feel. But the people that are the most impacted are the ones that have it in their front yard or have to look across the street. And this is a taller structure as well. So.
All right. Anything else to add, Eric?
I don't think so.
Okay. Any questions for Eric? Okay. Hearing none. Applicant or representative of the applicant?
Hi.
Good afternoon.
I commend you all. Believe me. My name is Dennis Arthur. I live at 2729 Lakeland Drive in Urbandale, 50322. I own the 2 properties, 3119 and 3103 Grand. I'm going to have to figure out how to do this. One of my requests, you might need a color picture.
Oh, cool. Thank you.
And I have a 3rd set if I don't use the overheads, which you should all, you want that? Okay. I guess with our one disappearance,
You're welcome to use the
I have to bat 100 against your terrible leaving.
Point counterpoint, right?
I do have to commend Bert also. This is a first for me, and he did it.
And do you have a picture that you can put on the overhead too, or did we steal your last one?
Well,
Yeah.
I can,
That'll help members of the audience and those watching at home.
the way I put this together, I'll have to stand over here. This circular area is the area that we would like the dumpster.
Okay.
It is also the area where the dumpster lived for 35 years until 3 months ago. This winter, we have a building at 35th and Grand, and we've never had bad pipes, but we had a horror story this winter. And my daughter, who manages the buildings, had to spend day after day down there. While she was down there, we had some people drop off some mattresses, a couch. It was unsightly, I agree. She didn't know it was there. When we did find out, she paid her brother to get it out of there, which he didn't. So it was there. It was there 4 or 5 days, and I could be the first to agree that it shouldn't have been. We did get rid of it. We got a letter from the city, which I'm sure you probably have, and I have a copy, which threatened us with $750 a day fines if we didn't do what they wanted. And the city inspector, zoning inspector, told my daughter we had to move the dumpster. And we said, we can't, there's nowhere to put it. And he said, you'll have to move it. And so I called him. And I said, we can't move it, but there's nowhere to put it. I'll show you here in a minute. He said, I'm sorry, you'll have to move it. So we moved it. And we moved it to the first place, and that didn't work. And we moved it to the second place that I'll show you in a minute, and that didn't work. And so I went down to zoning. and talked to the zoning inspector. In fact, I talked to 2 inspectors. And they both told me, you didn't have to move it. We could not make you move it. Now, we own 4 properties in the city of Des Moines. We pay $50,000 a year or provide $50,000 a year of property tax. And for a city official to tell us that we had to move the dumpster when we didn't actually have to, I think is a pretty shoddy way to treat a person that tries to do a good business and tries to run a good property. And if it wasn't for just circumstances, this would have never happened. So if you go to picture number 2, where you see the rock, that's the first place we moved it. And there must be some fill dirt or something there. Worked fine until the frost went out of the ground, and then the garbage just sunk. The garbage truck just sunk. If you look in the bottom right, it says 5-foot drop off. I'll show you in the next picture the 5-foot drop off, which is the reason that we can't put any dumpsters back there or trucks back there. So this is picture number 3. There's a 5-foot drop off all along the back. Trucks, big trucks like that, heavy trucks, could possibly pull the whole hill down. And Phil Portman said, he was the one that I was talking to. He's the one that said that I had to move it. But when I was down talking to him, he said, there's no way we can put garbage trucks back there. So he's the one that told me that it couldn't be put back there. If you go to picture number 4, this is a view down the hill to the back of the lot and the 5-foot drop off. This has been parking for the last 30 years. You can see where it would be difficult, this is a pretty steep hill, to drive a garbage truck down there and back it out, especially in the winter. If you go to picture number 5, you can see the picture that you got was where the dumpster used to be. It is currently down here, and this is the location that for the driver to back out of there, he has to back blind into Grand Avenue. It's the only thing he can do. It's the only thing that can be done. It's also pretty narrow. This was an 80-year-old building, and pretty narrow to get down there in the wintertime. Now, the little circle is the location where the dumpster has been since the 70s, where the city told us that we had to move it and then told us that they couldn't have made us move it if we hadn't have done it. What I want you to do is look at the setting. I wish I'd have brought some pictures that didn't have the red marking on it, but look at the setting of the pictures and imagine a brick or block dumpster enclosure up there, and then imagine what a Trex or a wood dumpster enclosure would look. It would be more in keeping with the area. I would think that the block or brick enclosure would be an eyesore, where a Trex or wood enclosure would sort of blend in, where to me the other would jump right out at you. And if you look at number 6, this is a view from the east to west. You can see there's also cars parked all along that area. The back of the dumpster enclosure, there's a little hill right there, so it isn't encroaching on anybody's land, or it isn't on land that can't be used. And quite frankly, it's the only safe place to put the dumpster. And I asked the city a number of times to come and show me where to put it, and we didn't get any response. So, believe me, if I could put it out back, I'd be more than happy to, but it's just not possible. Now, I went to the Trex website. Trex has 25-year limited guarantee. It's fade and stain resistant, won't warp, rot, or split. Mold and mildew resistant, is termite resistant, splinter-free soap and water cleaning. A brick enclosure would cost probably $7,000. With a pad, it'd be $10,000. And in my mind, it would look very out of place in that neighborhood with trees and wood, and it just, in my mind, would look very out of place. Trex would cost us probably about $2,500, maybe $3,000. My builder has talked to Ryan Moffett. Ryan has told him exactly how it would have to be built, and he said he can build it. I'm certainly not going to let a $2,500 investment be ruined. I would plan to put posts out front so the trucks won't back into the enclosure. I'd have a side door for the tenants so gates wouldn't be swinging open. I can certainly understand why you would want a brick or block enclosure for large new projects. Most smaller owners, this would be unaffordable, and I'm going to guess that you will probably see this problem many times in the future. I also believe that a brick or block enclosure in these older neighborhoods with smaller buildings would just look out of place, where wood or Trex would blend right in, at least in my mind. The more natural look of the wood or the Trex would have a tendency to blend more into the neighborhood. That's all I have to say. Thanks for your attention, but you need to know I think that I've shown you that there's nowhere else to put it unless the city wants to come and show me somewhere. I don't think you can have a truck banking out on a Grand Avenue forever. Obviously, we can't have huge garbage trucks down there where that 5-foot drop-off's are. You'll just push that right down the hill. But I'll be glad to do whatever you want, and I have asked.
Okay.
But I don't know where I'll put it if you don't let us put where it sat for 35 years.
Okay, questions for the applicant? Got a couple brief ones. Right now, where the dumpster had been, the truck does drive off the street, and he can do a quick backup and maneuver and get to it, right?
Where it is now,
yeah.
he can come in, see there's a drive.
Right.
Connected to a drive. He can come in, the drive over there, come over, back up, and go right out forward.
Can you help him show that on the overhead with the plan view of the site? That might be helpful. All right, so where the dumpster was, kind of point to that.
Where am I?
Yep.
Okay.
Okay.
The dumpster has always been for, as far as I know, since the building was built.
Sure.
Right there.
Okay.
There's a drive here.
Yep.
A drive here, and a drive here.
Sure.
To come up out of this hole, they can't back over there because of that. I showed you earlier, there's a...
Right. But that's on somebody else's property, so I'm not too worried about that.
It's mine. I own it.
Oh, all right. So as far as access to that,
Right.
you'd potentially allow it then, per se.
Yes.
Okay, but still. There may be some discussion here about the dumpster enclosure itself, but based on the way your parking's laid out, would there be a way to set it back further from the street, still have it where the truck could come in and turn? I've been in other apartment complexes where sometimes there's parking on both sides of that dumpster enclosure. And the dumpster enclosure is within the parking area, but designed so that a truck can do like a 2-point turn and get to it. If you put that other picture back up there, which you had, yeah, like where that Oldsmobile sits, that brown one. What if you had the dumpster there where he could still come in and back to it? Could you rearrange your parking there to facilitate that?
I thought of that.
Yeah.
But it's better off hidden sideways over on the lot line than it is out in the middle of the parking lot looking at you like this or looking at the street like this, I would think.
Okay. And based on what you might know about your required setback for parking, can you park cars all the way up to the edge of the curbing? Do you have authority to do that now?
I haven't any idea. This parking's been there for.
Okay.
It's been.
Bert, Eric, based on the history of the site, does he have rights to park cars closer to the street? Does he have to have some kind of a setback there?
I don't have the research on his site
Okay. Because what I'm getting at is if we adjusted a few cars forward, then maybe the dumpster sits back a little, enough to where they can pull off the street back into it. You know, putting it all the way in the back may not be feasible, but that's just one part of the puzzle here. So I was just kind of curious, so we'll just leave it at that for now. Okay. Anything else you want to add?
No, just, you gotta help me. Somebody's gotta
Okay.
help me, because I
Okay.
have nowhere to put it.
All right. Do you know anything about the paving on the site? When you talk about it must be over bad fill, well, asphalt doesn't have a lot of strength properties to itself. Are you 3 inches thick or 9 inches thick with it? Any idea?
Would guess we're probably not 9 inches thick.
Okay.
I would
All right.
guess
Somewhere in
that.
between.
Yeah, somewhere
Okay.
in between. That area is the worst possible place to put it anyway. It really shouldn't be there.
Okay.
But we didn't have anywhere else, so we tried.
Well, I think everybody agrees with you on that. Yes.
Okay.
Okay. Any other questions for the applicant? All right. Thank you, sir. We'll check back with you here in just a little bit. All right. Is there anybody here to speak in support of the applicant?
Oh, you can have it. Sure.
You just called them 1, 2, 3, 4, and 5, but I'm gonna give them A, B, C, D, and E.
Yep, do whatever you want. That's fine with me.
All right. No one else here to speak in support? Is there anybody here to speak in opposition? Step right up. Just need your name and address for the record and a full 5 minutes if you need it.
Try to be brief.
You've earned your time today.
I also commend the board for their patience this evening, and it's the first time I've ever attended. I'm a lifelong Des Moines resident. Jim Hager, 3100 Grand, lifelong Des Moines resident, never attended these proceedings. So it was informative and impressive to see the way the gravity, the seriousness you bring to these deliberations.
Thank you.
I've got pictures also. I guess I'll just start with this one. Okay. Yeah, that shows up. That's taken from our property, 3100 Grand. To give you a little visual context, the view to the north to the gentleman's properties, and the tree that was in those photographs that were just earlier displayed is no longer there. And there's a stump now where I believe is where the owner wants to install the dumpster. This is another exhibit showing the stump, and I think that shows about where he intends to install the dumpster. And this gives you a sense of the proximity to Grand Avenue, Grand with a capital G, Grand Avenue. And that building in the background is 3100 Grand, the condo that I represent here tonight. Here's another view showing Des Moines University, and gives you a sense of the proximity of Des Moines University campus to the location we're concerned with. Okay. A little background I should mention, I guess. We really were made aware of the problem here in late fall when the dumpster, to which we've long objected, although not formally, started getting piled up with mattresses, box springs, all kinds of trash. After waiting 3 weeks to see the owner remove the stuff, which didn't happen, I contacted the city, exchanged emails with Sue Ann Donovan, who had the dumpster, well, first had the material moved, then 2 weeks later, more large trash that couldn't go inside the dumpster and be removed by the driver, found its way to that dumpster site. Then after that, I think she compelled the owner to relocate the dumpster. Here's a view of the dumpster now. You see the stuff around it. The driver empties the dumpster, but I think probably they're not required to pick up trash. They don't get out of the truck. Here's another view. That photo was taken 2 days after I got the letter that you're having this hearing. And as far as I know, and that was a couple weeks ago, as far as I know, that material is still there. So that's the kind of situation we're dealing with, and we would encourage the board to deny this, this appeal, so.
Thank you, Jim.
Okay.
Any questions? All right. Thank you. Okay, is there anybody else here to speak in opposition? Okay, hearing none, appellant, you've got 3 minutes for any closing comments or rebuttal.
I will grant you, it has not been ideal. I don't think they've had problems before this year. My daughter has had we had major ice plow problems at the Addison, and those maybe have been there. I also don't doubt that. She's been having yearly inspections.
Okay.
They've sort of been driving her nuts, and I could guess maybe she thought they were back there and hidden, and so she's neglected that. I can assure you they will be gone in a hurry. Don't believe that we've had problems in the past other until this year, and it was pretty much special circumstances this year. We just cut that tree down about 2 weeks ago. It was very rotten. If we hadn't cut it down, it would have been in the middle of Grand Avenue. I try to be a good neighbor. Not everybody can have shiny new properties, and not everybody can afford to live in shiny new properties. We try to keep our properties up as best we can. I believe these were somewhat special circumstances that obviously went too far.
And how long have you owned the property there?
Probably the one on that side,
Yeah.
3103, I guess maybe 12 years or so, and the other one maybe 10.
Okay. All right, any other questions? Okay. All right, thank you, sir. Okay, any other questions for staff? Okay, hearing none, we'll close the public portion and go to board deliberation. Thoughts, comments? Okay. Yeah, it looks like we're asking for a lot of variances here. Okay, all right, we've got a motion on the table to move staff recommendation for item 16, which would be a denial of the variance. All those in favor, raise your right hand, say aye. Motion carries 4-0. You have to come back with a better plan next time, it looks like. Okay. All right, item 17 is a conditional use permit request at 1621, you bet, 1621 University Avenue.
Mr. Chair, members of the board, this request is for a conditional use permit that would allow continuance the property to be continued to be used as a limited food and retail sales establishment. The subject property is on the north side of University Avenue, just across from Good Park. It has been operating as the University Grocery. However, the previous operator that had been operating there for some time was sent a notice back in, I believe, March or April of this year, requesting an audit of their business in order to prove that they're truly operating as a limited food sales establishment. Upon receiving that, they have just since walked away from their business, so the title holder has now taken over operations at this site, and they're not able to provide an audit since they don't have access to the previous operator's records. So. Here's the floor plan of the building. It's a 50-foot by 50-foot building. As noted on the photos you're about to see, they also sell Chester's Fried Chicken in here, so it is a mix of different uses. They're showing the liquor would be, or is displayed behind the counter. And then here's the liquor agreement that shows they've been operating or been able to obtain liquor licenses in the past because they're the grocery store or a limited food sales establishment. And here's a site photo. And again, you can see Good Park is directly across. So if this were subject to separation distance requirements, it would not meet those separation distance requirements. However, since they've been operating as a food sale or a limited food sales establishment since prior to July 1st of 2012, they're not subject to the new separation distances. However, if their sales ever would exceed 40%, if their sales of alcohol and tobacco would exceed 40% of their overall sales, then they would have to come back to this board to get a conditional use permit for a liquor store, and at which time those separation distances would apply, so they would be looking at a variance to that requirement. And here's one more photo. than the consent map. We had some cards come back in opposition. You can read those. One of the cards specifically mentions some shootings and some property damage that she's had from customers here. So I would point out that that likely was from the previous operator. I don't know that the current operator's is operating long enough to have a track record that we could look at. I did provide you copies of the police reports. I believe there were a few instances not noted or assigned to this property. But other than that, we feel they have satisfied the criteria necessary for granting the conditional use permit. I won't read through all the conditions, but one that's kind of unique is number 3, that we've said within 6 months and/or prior to the issuance of any liquor license, wine or beer permit after January 1st of next year, the business shall submit an audit that shows they are in fact a food sales establishment and not a liquor store. So we do want them to be well aware that that is a requirement and that they need to be working to ensure they're not functioning as a liquor store. So. Any questions?
I have a question, maybe I just need some clarification. Because this is right across from the park, I didn't think they could sell, I didn't think they could sell liquor. We had that one over on the east side where they wanted to sell beer and cigarettes.
But that was for a newly established business, where this has been operating since before July 1st of 2012. And when the city council revised the liquor requirements, they grandfathered, I guess grandfathered is probably not the right word, but they said all the existing food sales establishments and gas stations,
Food sales.
and restaurants.
So it's never gone, it's never stopped?
Right, correct. Yeah, when the previous operator, I can let the applicant speak to it, but when the previous operator walked away, the title holder stepped right in
And not that
continue.
this matters, but is this the same person who owns the Chester's Fried Chicken down on East 14th that came before us? One of his friends was running it or something?
I believe it's the same family. I'll let them answer that as well.
I don't think there's too many Chester Fried Chicken.
You're talking
No.
at Southeast 14th and Maury?
Yeah.
Okay, all right. Okay. All right.
I think the Chester's might be a chain, though.
Yeah,
that they
yeah,
can
yeah.
buy
You're
franchise.
buying a franchise of,
But I just think those,
yeah.
so it's never changed, never stopped business. It's, okay.
Correct. And if they ever would stop for more than 6 months, then in order for it to go back in here, they would be subject to the separation distances. Or if they would ever have to get a conditional use permit for a liquor store, then they would also be subject to the separation.
So if he goes below, if he goes more than 40% by whatever date you give him,
Right,
then he could not sell liquor.
correct.
Correct. Okay.
Without
All right,
getting
I'm
a
with you.
conditional use permit for that.
Okay.
Yeah.
Thank you.
Or if beer and wine and tobacco exceeded 40%.
That's fine.
Okay.
All right, any other questions for Bert? Okay, thank you, sir. Okay, applicant or representative of the applicant. We'll turn the podium over to you. You've got 10 minutes. Thank you for waiting this afternoon.
Oh, no problem. I'm Harmala Dasan. I represent the property, Qatar Properties. We bought this property in 2009, and we came to the zoning and tried to figure out if we could put a liquor store in there, and they said we could have not a full liquor store. So we bought the property with that in mind. We renovated the property, and we ran the business for a little bit, and then we moved on and we leased it out to somebody for 3 years, and he had an option to continue. That was the person who was running it, and he just vacated the premises without informing us on time 3 weeks ago, approximately. So we had to break the locks and come in, and it has been vacated, and we are trying to reopen the store and the location. So we are trying to push Chester's Chicken, which is the franchise we put in. And there's a lot of groceries are sold in that location because a lot of walk-in customers, a lot of frozen food. So we are hoping we can push those more than anything else. And also we'll be hiring new employees because we're starting all over again, so.
All right. Any questions?
What
Cindy?
what are your hours of operation?
At this point, we're thinking 9 to 9.
Okay.
We haven't gone too further in because I haven't run the location for more than 3 years now.
Right. And even if it was being run well before, are you looking at making any changes or improvements yourself to the facility or
It
how you
already
do
is
your
pretty
business?
run down. He has really run it down.
Right.
It's pretty damaged inside, so I'm actually already getting it all cleaned up. So we will be improving it, yes.
Okay, good. Always good
And
to
our
hear
goal is to push groceries because that's what the neighborhood is asking for, so.
that. Okay.
Yeah.
All right. Any other questions for the applicant? All right, thank you very much. Okay, is there anybody here to speak in support of the applicant? Is there anybody here to speak in opposition? Okay, hearing none, I don't think we need any rebuttal by the applicant. Any other questions for staff? Okay, hearing none, we'll close the public portion and go to board deliberation.
I would move staff recommendations.
Second.
Okay, any other discussion? All right, we've got a motion and a second. All those in favor, raise your right hand, say aye.
Aye.
Okay, motion carries 4-0. Okay, keep spiffing that place up, and we wish you well. Okay, item number 18 is an exception request for 4301 Boyd Street.
Yes. Mr. Chair, the subject property is on the northeast side of the area of the city in a fairly newer, it's a fairly newer subdivision. There's properties to the immediate west that are in quite a bit older subdivision. This is kind of stops right here, and then this area, and then area 2 blocks to the north up to Douglas are also within this section of newer homes. They're a blend of 1-story, 2-story homes. Most of them have the attached garage on them. They have varying lot shapes and sizes. Some are more narrow, some are wider. The request at hand is just seems simple, to widen the flare of the driveway so that a parking space can be accommodated outside of the front yard setback on the west side. And you do see other examples of where people have flared out their driveway. Some of those actually we're having to review, I think, because they've been brought to our attention now.
Yeah.
And they may have been done
It happens.
with needing the same relief that's in front of you today. We see further requests, unfortunately. But the thing about this situation is that this is coming about as a result of the parking space they had been providing in their attached garage being enclosed. And a permit has been requested. It hasn't been able to be granted yet because they need the board's relief they have to provide that space that they've removed outside the front yard setback, so.
Why does the zoning ordinance, and I'm sorry to interrupt, but why does the zoning ordinance allow when a house has been built with a garage like that it even can be converted into that kind of?
As long as they're providing the space.
As long as they're providing the relief. Okay. Okay.
So this is kind of a secondary effect.
Sure.
I want you to understand this.
Sure.
And it's the main reason that we're recommending denial of this is because they're able to provide, if they hadn't done the enclosure, they would be able to meet the standard.
Gotcha.
And so the standard, widening out the driveway and parking along the side in itself is not problematic.
Sure.
When they have a garage that's open.
Right.
They've taken away their ability to use that garage for vehicle storage, and now that's forcing them to do this. So it's not.
But there was no building permit taken out to even do that.
There wasn't initially. They've now applied for that, and it's being reviewed pending getting this space provided. The board's the one option for them to get that outside of the garage.
But Eric, is this a PUD? Because I thought these covenants called that you had to have an attached garage when this was built.
This is just standard. This is not a PUD.
Right.
This is just
Have you looked at
standard R1 zoning. I can't speak to the private covenants,
I think
what they would
covenants
require.
a
And you may be more knowledgeable of that than the city wouldn't enforce those covenants, but
Yeah, the covenants are between the private property owners, and they will, if there are covenants,
There are
that'll be a bigger battle, most likely, to get around, just because once they attach, they're really hard to get around. So.
Right.
Now, it's been, one of the building plan reviewers for residential properties has indicated that the way this is being done or has been done is set up so that it can be reversed fairly easily. So, so if they go to sell the property, a future owner might be able to occupy the garage rather easily again. However, staff just looks at this from the character test of the exception criteria, and we just don't feel, and even though this is a secondary effect, it's a direct result of the relief that they need. So we're recommending denial based on that. And then I've indicated in the staff report, should the board not approve the requested exception relief, the board could continue the item to renotice as a variance of the space itself. So I know that's sort of counterintuitive. If you're denying it, you're probably not wanting to consider a variance on top of that, but they would have that avenue available to them to just completely request not having the stall provided.
Eric,
Go ahead.
sorry,
That's
Mr.
fine.
Chair. Eric, you mentioned that there's some other houses in the neighborhood that have just added parking, but that they haven't tried to convert their garages. Is that right?
Yeah, I didn't see any evidence where somebody had
Okay.
enclosed their garage in this kind of newer developed area. I didn't do an exhaustive
So it's mostly
survey
just
of those
parking
homes in
lot.
the area, but I did notice that there was there's been a number of those flared driveways that may or may not be over that 25% that we're gonna have to look into, so they've been brought to our attention now, so.
Maybe you should do a door hanger around the neighborhoods to remind people.
And just so you understand, the paving on the private side generally doesn't drive a permit. If they widen the approach, that takes a permit. So the standard is, we do get a lot of people coming in and asking, and we explain it, but the standard that's in the zoning ordinance is not necessarily reviewed under any permit process. Sure. People do pave beyond that and in violation, so.
Okay. All right. What's the consent map show? Is that it?
No.
Not to be ahead of you
No
here.
responses.
No responses. One question I did have, I talked to staff before about some things in my own neighborhood with 90 houses with a very similar kind of plat, and we were a PUD. And I was told if somebody wanted to apply for a variance, everybody in the PUD would get noticed regardless of radius. Does that?
And again, this is not a PUD.
And maybe this isn't a PUD, but if it was, then there'd be a larger amount of people notified. So,
Yeah, because in that
this must
case, you
not
would
be a
be
PUD.
amending the standard applicable to the PUD.
So I think it goes back to Linda's point then, if this isn't a PUD, we probably don't have the same covenants unless there'd be something.
Well, there may be similar covenants because that's normally filed by the developer who sells off the property.
Okay, all right, thank you. All right, any questions for Eric? Okay, hearing none, let's hear from the applicant or representative of the applicant.
Hi, my name's Sam Taylor, and that's my house.
Okay.
I don't really know how to start because I wasn't really prepared, but that back area back there is all overgrown woods, and so we get a lot of rodents and mice and things, and they come directly into our house. And the way it was built, above the garage is the rafters, and it goes directly into our house. So I have mouse traps and things all by every single bed in my house and all throughout it, and I catch one almost every day. And my wife and I, our reasoning why we thought this, well, first off, I apologize for building the wall. I thought since it was not a load-bearing structure and it was on the garage that I was okay. And then, so I stopped, and I was trying to make it look nice, so.
We have a lot of people that come and ask for forgiveness rather than permission. It does happen.
I'm kind of new to this, so
Sure.
But so, they told us down at the permit and zoning place that we would be okay to put that wall there if we had the exception, and all we needed was part of that corner piece to fill the 25% mark for concrete in the front, and, you know, we'd seen that other people had done it too. And, you know, all these houses over here to the left, I know they're not in our zone or whatever, but they're on our street and they're right there. Not a single one of them have a garage. They're all duplexes. But our reasoning was we had a house fire, and so we had a lot of extra stuff, and we store everything in there that we had, and it's getting torn apart, and we get snow in there and everything else because of the openings from the garage. And but more importantly, it was more of a health concern because our daughter's been battling cancer for 3 years, and she's fighting a like a lung infection that comes from like rodent feces and things in this area, and so she almost had to have surgery and things, and we got 2 little babies too, and so we were just mostly trying to seal it off, and I didn't want to make it look ugly and try and put like thick plastic and nail it to the ground or do anything like that. I wanted to still keep my house looking nice because, you know, we've put a lot of money into it, and we bought it on our foreclosure, and we've put stone on the outside and just tried to make it look nice. And so this was sort of the best thing I could come up with.
What year was your house built?
01.
Oh, 01, so it's 13 years old.
Yep.
So it's pretty new.
Yeah, it's pretty
Okay, I'm just kind of surprised you're being overrun with rodents getting inside the house.
I believe it's because of the wooded area, and because that whole front of the garage where the door comes down, it didn't seal up. You know, there you could see light and everything all around it, and I tried stuff in towels and, you know, just different stuff around the house in there to try and close it up, but
Okay. All right, any questions for Mr. Taylor? Okay, we'll check back with you in just a little bit. Is there anybody here to speak in support of Mr. Taylor's application? Is there anybody here to speak in opposition? Okay, you guys are all hanging on till the end. Okay. Hearing none, any other questions for staff? All right, we'll close the public portion and go to board deliberation. I'd like a few thoughts here before any motions are put out.
I feel for him, I understand it, but this neighborhood, I mean, when that development was developed, you know, everybody has garages. I understand the homes to the west may not, but it's really a different neighborhood. I just think it will be out of character to have this made into a room. I mean, it's not heated, it's a garage. You know, there are other ways, you know, you could put in a different garage door, seal it up, they have insulated ones. I'm sorry, I just can't support this when it is out of character with the neighborhood. So I have to support what the city recommends.
Yeah. Mr. Taylor, I have no doubt you've got some challenges on things, but what we have to keep in mind are the things related to how we look at exceptions and what criteria that we have. And when I look at a house that's built, it's relatively new. It doesn't look much different than mine. But when we start to transition neighborhoods into these kinds of things, we had a big discussion about property values earlier. These are the kinds of things that do affect property values. And when I drive through a neighborhood and I would see something like that, I would kind of scratch my head a little bit. You know, repairing a garage door, sealing it up. If Bob Vila was your neighbor, he'd come help you out with that. But I think what you're trying to solve here, we're doing more harm than good if we were to grant something like this. So I can't support it either. So I don't know if there would be a motion on the table to look at granting the exception, or if there would be a motion on the table. Did you say you wanted to move staff recommendations, or you agreed?
I was
Okay.
I
Okay.
agree with the city's recommendation.
All right, would anybody like to put a motion out there?
I would move staff recommendations.
Okay. Thank you, Dave. Okay, we got a motion and a second to deny the requested exception. All those in favor, raise your right hand. Say aye. Aye. Opposed? Okay, motion carries 4-0. So staff will have to work with Mr. Taylor on some explanations here as he moves forward. Okay, item 19 is a variance request at 739 20th Street.
This item's a fairly unique item. It's a variance that would allow for one property to have two single-family dwellings on it. It's a parcel located in the Sherman Hill Local Historic District. It has an existing dwelling oriented towards 20th Street, but then there's also a two-story carriage house that's on the back portion of the property. The ground level of the carriage house is the garage, and then the upper level is a big room that the applicant would like to convert to a dwelling unit. Here's a photo of the front of the house on 20th Street. And then here's a photo of the carriage house. Hopefully it's showing up better on your monitors, but it has a double garage door on the east side, so it's accessed from the alley. And then the upper level is a large room that would be the dwelling unit. This is looking at it from the south. Another view from the south. And then the consent map, we did get one card in opposition. I can show you the plans real quick. Can you zoom out there? Yep. Thanks. So this shows the lower level of the garage, and then the upper level would be a studio apartment with a small bath. So I would point out that this is in the RHD Historic Residential District. It does allow for two-family uses and also multiple family uses. So having two dwelling units on one parcel isn't uncommon. It's just that the zoning ordinance doesn't allow for two standalone dwelling units on one parcel. So they need the variance. Staff does feel that this is in character with the Sherman Hill neighborhood, so we've recommended approval, but we've made it subject to 3 conditions. One, that the primary dwelling shall be occupied by the property's title holder as their primary residence. 2, that any tenant of the secondary dwelling shall be provided with at least one paved off-street parking space or a garage stall. And 3, any additions constructed or building modifications shall be in compliance with the building code. Any questions?
Does this stay with the property? So even if this homeowner decides to sell the property, he can rent the carriage house if he lives in?
Yeah, if this property owner sells it, that next property owner would have to live in the primary dwelling in order to lease out the secondary dwelling unit.
Unless they take action to change it again.
Yeah, unless they come back to the board.
Because we had
to have
one
that
not
condition.
too long ago, where they bought it and they said, oh, we bought it because there was another apartment, but they weren't able to do that, so,
Yeah.
okay.
Yeah,
So this one, the homeowner always has to live in the main.
that's our recommendation, at least. If
How are
you
you getting plumbing back there?
let him address that.
Okay,
Have to do it.
all right.
Okay, let's hear from the applicant or representative of the applicant.
Oh, look at her, she's sound asleep.
Yeah, finally.
She's a trooper.
She is. My name is Jason, 739 20th Street.
Okay.
What was the question about the plumbing?
No, it doesn't really matter. You'll figure it out.
Right?
Yeah, it's plumbed right now. It's basically, I built it, or we built it for my wife's shop. She works out of, or she did work out of it. And then she bought a house, or a commercial property just 2 streets, or a street down, so.
Which is good, because she probably would have needed a home occupation permit.
Exactly.
Yeah, okay.
So basically, yeah, it was more for us because it was just a totally unused big space that was just kind of like, well, why don't we just take something, so thought I'd put my legwork into it, see what we can make happen. Turns out we might just be moving, and so who knows, we'll see what happens. But for the time being, I'm gonna continue on with the path that we set out to, just to save some money and, help.
So do you park outside elsewise then?
Yeah, we have a right out in front. We also have, right alongside the garage, there's, plenty of space there.
But if you go through with this, there'd be no covered parking for anybody on the site then?
Oh,
Everybody
no,
park-
they would,
no?
we would actually give them a space in the garage.
In the garage?
Yeah,
Okay,
exactly.
okay. All
Uh,
right.
we, yeah, it's kind of like everybody else's, or, I don't know, I see my garage and I go, well, there's no room for anything other than my crap, so.
Right, okay.
Yeah.
Any questions for the applicant? Okay, all right, hang tight, we'll get right back with you. Okay, is there anybody here to speak in support of the applicant? Is there anybody here to speak in opposition? Okay, any other further questions for staff? Hearing none, we'll close the public portion, go to board deliberation.
I would move staff recommendations.
I'll second.
Got a motion and a second? All those in favor, raise your right hand, say aye. Aye, motion carries 4-0. It's a good thing here late in the day, these fours are working out for everybody. Okay, item 20 is a conditional use permit and variance request for 2428 Southwest 9th Street.
Yeah, help me.
The request is for a conditional use permit for a liquor store. The subject property is located on the west side of Southwest 9th Street, just to the north of the Lincoln High School campus. In fact, this property right here, immediately to the west, is owned and used in common with the Lincoln High School use. In fact, here's a parking lot, and I believe there's some tennis courts over on the west part of the property. This site recently was successfully rezoned from C1 to C2. As a C1 property, they weren't allowed, or they weren't able to apply for a conditional use permit for a liquor store. So they did have to go through the rezoning process, which required the public hearings at the Plan and Zoning Commission and at City Council. And I can tell you that at the City Council, they did have quite a few neighbors come to speak in support of the use. So the City Council did rezone the property to a C2, subject to the subject to this one condition, that any use of the property and structure shall be limited to the following. A, any use as permitted in the C1 district, which is what it previously was. And then B, a liquor store for the sale of alcoholic beverages within the portion of the property locally known as 2424 Southwest 9th Street. So because they were rezoned, they are able to apply to this board for the conditional use permit to allow them to be a liquor store. As part of the application, they submitted this site sketch that shows the layout of the building. As you can see from the aerial, it is kind of a misshapen building. The parcel has 3 structures on it, so the liquor store or the subject business is within that building right here. Here's a photo of the business with Southwest 9th being right here. So it's the South Side Tobacco and Liquor Store. Here's it from another angle. And the consent map. I was surprised we didn't get any comment cards back in support or opposition, considering all the support they had at the Plan and Zoning Commission. So staff took a look at this with the request for a conditional use permit for the liquor store. As a liquor store, they are subject to the separation distance requirements, which require at least 500 feet of separation from any church, school, park, or licensed child care facility. Since this property immediately to the west is owned and used as the Lincoln School or campus, they do not meet those separation distances. So technically, they do not satisfy the criteria necessary for granting this conditional use permit. So I guess for that reason, we've recommended denial of the conditional use permit for a liquor store. However, we do feel that they've satisfied the criteria necessary for granting a conditional use permit for a food sales establishment. And again, that's how they have been operating. They've been obtaining liquor licenses for the past few years as a food sales establishment, meaning they've been supposed to keep their sales of liquor and tobacco products under 40% of their overall sales. But as the applicant can tell you, they're nowhere near to keeping or to meeting that 40% threshold. So I'll just go through the staff recommendation quickly. Like I said, we've recommended denial of the conditional use permit and variance to the separation distance necessary to allow a liquor store, but we've recommended approval of a limited food sales establishment, with the first condition being any food sales establishment shall derive less than 40% of their grocery receipts from the sale of alcohol and tobacco products. 2, that they shall operate in accordance with a liquor license obtained through the city clerk and approved by council. 3, that prior to issuance of any liquor license, wine permit, and beer permit after January 1st of 2015, they shall submit an audit to the satisfaction of the neighborhood inspection zoning administrator that demonstrates they meet that 40% requirement. And then the rest of the conditions are standard, so I won't bore you with those, but are there any questions?
Okay. Thank you for that. We'll see what the applicant has to say. Applicant or representative of the applicant?
Good afternoon, Mr. Chairman, board members.
Good afternoon.
My name is Richard Bartlett. I'm the owner of Southside Tobacco and Liquor, 2424 Southwest 9th Street. My home address is 3838 31st Street. I started as Southside Tobacco at 2432 Southwest 9th Street in 1996. In August of 99, we were granted a beer and wine license. And in September of 2003, we moved to our current location at 2424 Southwest 9th Street, and were granted a full liquor license. In that time, when I started my business, just me and my girlfriend, and now she's my wife and the mother of my 3 children. Thank you.
Very good.
So I've gone from being a single man to a husband and father. I was also someone who rented a house at that time, and I now own my own home.
Very good.
We're open from 9 to 10 Monday through Saturday, and we are closed on Sundays. I don't stay open any later because, like someone said earlier, nothing good happens after dark. We have a low volume of police calls. We've had 2 in the last year, hit and run in the parking lot and a shoplifting. My family is, we're lifelong residents of Des Moines. My 3 children are in the school system that will be going to Lincoln. My oldest son goes to Lincoln South, plays on the soccer team, and we'll be going to Lincoln proper next year. Me and my wife have built our lives around this business. We tried selling food items when we first moved over, but we've got a discount supermarket down the street. When you're offering a can of soup for 79 cents and they're selling it for 39, you just cannot compete, unfortunately. With respect to the school, this area here where we meet is basically a jungle. There's no direct access from the school to our business. There's a 20-foot cliff along the precipice of that right there. I've talked to the resource officer at the school, and she assured me that all of her problems lie to the south of Lincoln, not to the north where we are. She's been in my store one time in 10 years.
And Richard, I'm just curious, since you mentioned, are we talking other retail sales establishments that have alcohol to the south? You don't have to name them, but is that where her problems are? Or is she just saying the kids go to the south?
Yeah, generally gravitate that way. There's a McDonald's down there. And
so whether it's jaywalking or staying on the curb or whatever.
Whatever it is.
If they're going somewhere, they're going the other direction.
Usually, yeah. We, like I said, you could bulldoze Lincoln tomorrow. It wouldn't really make a difference to my bottom line.
Got it.
Yeah. And there is no, like I said, there's no direct access. You can't even see Lincoln from my property. The economic impact would probably bankrupt us if we lost our liquor license. And like I said, that's how I support my family. Both me and my wife work there. That's our only job. We don't have like some of the other applicants in here have multiple locations. We don't have a multiple location to go work somewhere else. If we were to lose our liquor license and go out of business, it would put the property in a negative cash flow and perhaps foreclosure from the landlord. And I do have some petitions. Do you have copies of them?
I don't know if we do or not, but we could take a look at them here. Okay.
Was this the same petition you used?
Yes.
The rezoning?
Yes.
Okay. Yeah. We didn't carry that forward, but you can submit it.
Okay. Thank you, sir.
Those are specific petitions, and I do have a general petition that was signed by the general public that has about 400 names on it. A couple notables in there are, there's a member of the city council, and Bill Hansen, the president of the 9th Street Merchants Association, also signed that.
All right, Richard, since you mentioned it, who is the member of the city council?
Joe
that
Gatto.
signed it? Joe Gatto, okay.
Okay. And the first one is from the residents of the Lincoln Plaza. That's where we're at. We have every resident signing. We have every member signing, except for one resident who did not speak English. Taylor Shop also signed. And so we have everyone there signing up for petition. The next one is Southwest 9th Street. We have every resident on each side of the street from Bell Avenue to Kirkwood signing on that. And the next is directly across from us, 2417 is a place called Southview Manor. It's a city-owned building. And we have about 30 of the 40 residents who live there signing in support of our zoning change. We have a few that didn't sign because they were disabled or didn't speak English, and the rest were vacant. And we come to Southwest 8th Street, where we have every resident signing except for two. One was a city employee, cited a conflict of interest, and the other we were unable to meet. Southwest 7th Street, we have 3 vacant residents, and we have every resident signing except for one that I couldn't reach right on the end here.
Okay.
Bell Avenue, between Southwest 9th and Southwest 7th, we have every resident except for one that did not speak English, one I couldn't get a hold of, and one who is the only person who actually refused to sign my petition. She was a religious woman, cited religious views on alcohol that she couldn't sign. I said to her, well, you know, really, it's not about alcohol, it's more about whether my business has a negative impact on the neighborhood. And she agreed that we didn't, and but she still said she couldn't. But as I walked away, she said she would say a prayer for me, so that was very nice.
That's good.
So I didn't feel like I left empty-handed, that's for sure.
That's good.
Yeah. And then the next we have Southside Cares. That's a charitable organization I work with. Whenever someone's sick in the neighborhood, we put a jar up and collect money for them. And there's about 30 members there that signed. And then we have the business community. We have about 20 members of businesses all around us, Skeffington's, First, what's their name? We've got the Heminger Law Firm, you know, all the people right around us have signed. And then last, I don't think there is one in there, but this is actually Lincoln High School staff. Some of them actually signed our petition. A few teachers, guidance counselor.
I'm just glad you said staff.
Yes.
Yeah.
Not the students. The staff, yeah, we've actually got a few teachers and a guidance counselor that signed that for us. So those are the petitions. So being a small businessman, it's not real easy, and sometimes there's not much left over when you're done paying all the bills and everything like that. But this is how, for the last 18 years, that I've clothed, fed, and provided for my family. And I'd like you to keep that in mind when voting tonight. Thank you for your time. I really do appreciate it.
Do we have any questions for Mr. Bartlett? Just a very brief one, and I'm asking you this to be as honest as possible. Your policies on selling to minors and how you deal with minors, with the law?
We've never had an alcohol compliance violation or anyone arrested from our store who...
Okay, all right. You're
you're
picking up what I was laying down there.
Yeah, when you own the business, the fine's $2,000 if you get caught, as opposed to being someone who's just selling it. So, you know, it's economic necessity and, you know, also, you know...
And you aren't the property owner there for that parcel,
No,
correct? So you lease. Now, there was a fire in that little 2-story office building thing there, right?
Yeah.
And they've fixed that now, and that's been reoccupied. And you had somebody run into the front of your business a few years ago with a car, didn't they?
Ooh, that was about 10 years
Or
ago.
was that 10 years ago? Well, I noticed you fixed up the front and changed your landscaping, and so there's been improvements to the property over the last few years to kind of keep it looking good?
Yes, sir.
Okay. Which we need in that part of the corridor.
Right.
Okay. All right. Let's go ahead and hear from, are there any supporters for Mr. Bartlett's request?
Your Honorable Board, I'm Jerry Hoots, the property owner.
Ah, well,
I
there we
live
go. Hi, Jerry.
4200 Markport Lane in West Des Moines.
Yep.
I've been trying to get out of this rental business for about 15 years, and I keep coming back and haunting me.
Okay.
The latest thing that haunted me is, of course, the fire, which that building's been completely rebuilt. But as I make my presentation, which I'll try to make it in 5 minutes or less since I've been here all afternoon. But just in support of Rich, his business, as well as my own business, things that I think I'm requesting that the board take under consideration are the following. Southside Tobacco Liquor would out of business due to the expense of bringing space back to as-is condition, paying landlord loss of rents and et cetera. That's part of his lease. So not only would he be out of business, he would probably go in the hole because I would be being a landlord, since that's my livelihood. I'm going to go after him for loss of rents, and it's in his lease that he has to bring his space back to the way it was, which happened to be an Edward Jones space, so it was pretty elegant at the time. Southside Tobacco and Liquor no longer would have a sellable business, obviously, because they wouldn't be able to have a license, so all their work would be right down the drain. It'd be a net loss. It's a mom and pop operation. That's their livelihood. That's their only source of income. That would put the property in jeopardy of foreclosure, which I can provide P&Ls if you request it, because it would put they are the key tenant, and it put the property in a negative cash flow situation, which I have the property up for sale presently, and so it would not be sellable, and that potentially put me in jeopardy of foreclosure. Speaking of that fire, when that building burned down, that had 4 apartment units and it had 4 office retail spaces below. Those 4 office retail spaces have not been rented yet. That's how tough the market is. And the other half of his building, or the portion of his building, that space has been empty for over a year because of the commercial market. Everybody wants to go in West Des Moines. It's hard for them to get financing to purchase commercial property unless they have a special relationship with the officer or CEO over the bank. And leasing property, I mean, it's just, even in the good times, they would set there 6 to 8 months to rent. And now, as I can say, since that's been rebuilt, brand new, they've been sitting there since that period of time.
Right.
The additional vacant space in Southwest 9th would be directly in counterproductive what the association, I don't know what the name of the association is.
Southwest 9th Corridor Improvement Group or something, Merchants Association.
Right, is counterproductive what they're trying to achieve. It would just add additional blight right off the streetscape of Southwest 9th. That property sitting empty for, I can assure you, for a bare minimum a year. Technically, I don't think that the city, when they changed the codes and so on and so forth, had any intent of putting anybody out of business that's been a good business neighbor and been good business in the community. And last but not least, but it certainly is counterproductive to what the state of Iowa is doing as far as encourages small business and entrepreneurship. And therefore, I'm asking that the board approve his liquor license to not only save his business, save his livelihood, and potentially save my business and my livelihood at this point. And I thank you for your time.
Okay, Jerry. Any questions for Jerry?
One other thing I'd like to add. In the period of time that he's been there, not to my knowledge that there has ever been a police call out of there because of fights related to somebody buying liquor and getting a fight out. And there's been no police calls out there for loitering. I'm over there at least once a week. I found nobody loitering. So I don't think it's created any additional crime in that neighborhood because of its establishment, because of how they run their business.
Okay, great. Thank you, Jerry.
for your time.
You bet. Okay. Anybody else here to speak in support of the applicant? Looking for support here.
Hello, good afternoon.
Yeah, probably good evening now.
Good evening. Grumble, grumble.
Yeah.
My name is Tina Goheen. I live at 3135 Southwest 13th Street, Des Moines, Iowa. Live not far from Rich's establishment. I have been using his establishment for my lottery tickets and other items since he opened. Hopefully I'll win lottery there so he can get some of that too. That's my goal.
Okay.
I've been friends with Rich and his wife for many, many years. Even before this, it was just a nice coincidence that he opened up a business near me. I believe in supporting local, and that's one of the reasons I like supporting Rich and his family. It's not a get and go, it's not a quick trip, it's a ma and pa. I was there when they did try to bring in food, but it is very difficult in that spot. Save-A-Lot is right there. That's where I shop. It's cheaper. He runs a clean business, a good business. You never see anybody loitering out front. You never see fisticuffs. You never see any of that stuff. In fact, I dropped my wallet in there last fall. Driver's license, ID, cards, everything. I got them back intact the next day. How many places do you drop that on the floor of a business and you get your credit card back the next day unused? So it's a good establishment. It's a well-respected establishment. Important to also think about the impacts of Southwest 9th. It's a difficult area. You see buildings on Southwest 9th that stay empty for years and years and years. The tattoo parlor down the street that just went in, I worked in that when it was a little bistro. And it closed almost 15 years ago. So it took 15 years for something to go back into that space. Let's keep our tax dollars moving, keep Rich in business. He does a good business, and I will say this much. The gentleman that works in the tobacco enforcement for minors at one of these meetings that we went to recently pulled Rich aside out in the hallway and wanted to shake his hand. He said, "I'm here for you. No violations. You have the best record in the city of Des Moines. You never sell to underage folks." It's important to consider. He's very responsible. It's his business. Like he said, him and his wife would take the fine because they are the only employees. But think about what you're doing to the economics of the area. Another empty business along Southwest 9th, even though a small business, very devastating to that area. We've taken enough hits along there. It's time for us to build. Thank you so much. I hope I've kept this short and that everyone has a lovely evening. We get to go outside when this is all said and done.
Thank you, Tina. All right, anybody else here to speak in support? Anybody to speak in Oh, you here to speak in support? Yes. All right, great.
Excuse me, my name's Larry Scott, 2832 Park Avenue. Excuse me. A little bit unusual because I'm here for the next issue.
Right.
Number 21.
Right.
But I'm also here because Mr. Rosenberg threw a fit and left. And because of that, this poor gentleman has to have 4-0 vote. One guy will kill his request.
You're right, Larry.
One negative vote, which is, number one, not fair. But I was also here during the zoning meeting a month or two ago when he happened to be ahead of us again on the agenda. And I listened to 20 or 30 people over here for him. And they, one after another, just kept telling you what a wonderful guy he was. I'm a lifetime South Sider. Everything I've heard then and everything I heard here tonight is true. There's a reason that he won his request with the Plan and Zoning Board. There's a reason he won it with the City Council. And I would just hate to have him go down in flames tonight because one person voted against him when, under a normal situation, he could have had 2 votes against him and still won. Consider that, please.
Thank you, Larry. You here to speak in support, sir? All right.
My name is Lowell Scott. Our business is 6111 Fleur Drive on Des Moines. I'm here for the next item also, but I was also here last time when his zoning was changed. And I'm a Lincoln grad and born and raised on the south side. And I know the street on the north side of Lincoln Avenue is a steep hill both ways. And at the bottom of that steep hill, there is a parking lot to the north. And that's the only reason the staff's against this that I've heard is that it butts up to school property. And like he said,
you need a rope to get from that school property up to the back of his parking lot. I just think that's a really weak excuse to turn him down. I don't smoke and I don't drink, so I can't believe I'm speaking for this, a liquor store on the south side. But frankly, the reason his wife's not here with him is she's running the store. He's a mom and pop operation, literally. They have no employees. The reason they have no violations, the owners are always there. One of them runs it or they're closed. And that's the type of people we need on the south side, people who step up, who care about a business, try and improve. And I hope that you don't shut them down just because we need people like that who, especially trying to help turn around the Southwest 9th corridor right there, where we don't need another Southeast 14th developing there. Thank you.
Thank you, Lowell. Anybody else here to speak in support? Is there anybody here to speak in opposition? Is there any further questions for staff? Okay.
I have a question for
Yes.
staff. I mean, it sounds like everybody's supportive of this, and if we were to grant the request for the conditional use permit and variance, there are no conditions. Would it be okay just to grant it as is, or would you?
Sure. What I would recommend is granting the conditional use permit for a liquor license, just striking conditions 1 and 3 listed here.
Okay, that's what I thought. Okay.
I'd like to know, and while the applicant doesn't need to rebut anything, there have been a lot of positive comments. The staff has here, you got 4, 5, 6, and there's 7, 8, 9, 10, 11 on the second page. You probably had a lot of time to read that agenda item. Would you be in support if we need to have a discussion here, but if the discussion was leading to allowing you to continue your business, could you comply with those other conditions, -1 and 3? Do you think you could? Yes. Okay, all right. I don't know if he needs to come back up here for that, but. Yeah, we have one like displaying alcoholic liquor only in a locked case or behind a counter accessible only to employees. That wouldn't be a problem? Okay. Okay, so I think at this time with Bert just kind of clarifying something just in case, we're just going to have a discussion here now. So we'll close the public portion, go to board deliberation since we're kind of having one now.
No,
that's fine. Thoughts?
I like how Linda's thinking.
Well, I mean, I've just heard, this is a business owner who's there all the time.
Right.
It always bothers me when people come before us and then they have, 16 employees that are working there. This truly is a mom and pop business. They're always there. They don't have employees. They've not had any problems before. The only reason they're here is because their back property line touches a little bit of Lincoln High School, which the kids can't get to or from it anyway. Right. And it's because of a change that we've seen with the city council trying to stop some of our problems, but this business has not been a problem. It doesn't sound like it's been a problem. There's not been any police calls. Everybody says, hey, this is the way a business should be. So my thoughts are, I would support granting it. And I usually agree with what the city says, but at this point, I mean, I think they're doing what they had to do. We've listened to the evidence. I think there's exceptions for things.
Other thoughts?
Well, I think this is a classic case order. This isn't a one-size-fits-all necessarily.
Right.
I mean, there's some unique circumstances here, and it's.
Right.
I guess my question is, are we setting a precedence here? If we approve this, are we going to have people lining up saying, but you did it over here, and you did it over there, and I realize you had a 20-foot hill, and I have a 5-foot hill, or, I mean, is that going to be, should that be something I should be concerned about? Because I'm just going to speak for myself here and ask the
Good question, Dave.
Well, I think the most unique circumstance here is you had a rezoning by the city council to allow the liquor store. So it's kind of a reverse direction from the usual. So I would say this is a very unique circumstance where I think the city council has actually indicated this is actually a very good business as well. So
I think I might be able to weigh in additionally, although I'm not an attorney. the way that we have to decide if we can grant the variance is we have to meet the necessary criteria. You know, we always got to go back to the books. Staff has said the appellant has not demonstrated that an unnecessary hardship exists, as the land in question can yield a reasonable return from other uses permitted on the property, as the conditional zoning on the property permits any other use allowed in the C1, and there are reasonable permitted uses for the premises that do not require the separation distance. That's the staff's logic. And I understand what you're trying to do here. You're trying to follow your ordinance. But I think from the testimony presented here today, and anybody who's familiar with that corridor, I don't believe that the property can yield a reasonable return from other uses that could be permitted on the property, because we have evidence. All you gotta do is drive down the street. Jerry's TV is closed. The old Subway, or whatever you want to call it, next to Lincoln, constantly closed. Corlano's Pizza, closed. Joe Henry was marketing businesses to the south there as you dip down the hill, closed. We have tons and tons of vacant storefronts. He's got one model that seems to be working in this business and working well. If we screw around with this, we're going to sink the whole thing. And odds are the landlord might even go under with this. So I think it is reasonable to state that he does have an unnecessary hardship. It would be hard to do anything else here and get a reasonable return. Not any return, but a reasonable one. And I think with all the support we have for that, most of the speakers have gone to that. So I would definitely support allowing the requested conditional use permit and variance. In order to do that, I'm just going to go ahead and put the motion out here myself. I want to recommend approval of the conditional use permit and variance to the separation distance, subject to the conditions noted by staff minus 1 and 3. So basically 2 and 4 through 11, if that's okay with the appellant, if he seems to think he can comply with those. Does that make sense to my colleagues as a motion?
Yeah, I'll second
I'll
that.
second.
Okay. All right, we've got a motion and a second on the table to approve the requested conditional use permit and variance. All those in favor, raise your right hand, say aye. Motion carried. And Lowell, you were correct. We either all sink or swim on this one, because one vote one way or the other. So I appreciate your comments. Okay. Item 21. Let's pick on the city of Des Moines for a variance request at 6215 Fleur Drive.
Yes, and the city of Des Moines is the landlord, but
Okay.
the tenant is the main applicant here that will represent this. The Des Moines Airport Authority, who operates the commuter long-term parking. The subject property is in the gold. As you can see, there's a split zone to it. Initially, the Airport Authority sought rezoning of this parcel, and they were going to look at a third entrance on the Leland Avenue side in about this location, which would have been a service-only entrance. That in itself drove the provision, because this was granted through a previous ordinance that allowed extension of parking as a matter of right into residential. The current requirements would require that to be only done as a site plan under certain design guidelines, but then the second thing that came into play here was the desire to bring this into being an entrance to the lot, and then they would convert that to an exit on the west side. Right now, my understanding is they're leaving this west entrance off of Fleur. However, there's some possibility that that would be looked at for closure. That brought some concern at the rezoning stage. And you're going to hear tonight from property owners that have concern about that. They've given us written evidence that they've conducted a study of the usage of that lot, and I think they're averaging on 8 exits per hour, which even if you sealed off that Fleur Drive entrance, I think it's only placing 8 trips into the lot. You're assuming for every exit there's an entrance at some point in time. So in terms of volume, 8 per hour is not undue in terms of capacity of this facility on Leland and the fact that it, up to this point, also serves as a commercial entrance for parking on the hotel property to the north. So, so they've abandoned the concept of, introducing another egress further into the neighborhood, which might have some impact, I think, and arguably would be presenting a new impact. So staff's evaluation of this at this time is to grant the request. It's going to provide an improvement. It'll allow them to put a canopy in this area over the entrance to the property. I think it'll flow better. It'll be more usable for the tenants or parking lessors. And that always enhances the services provided by our airport. So and I'll let Ryan kind of speak to the airport authority's motivation on this. They did provide us a photo of the canopy that they're locating there. And I want to show you this, and I apologize, I should have handed some cards at the beginning. So there is, very strong opposition to this. There was also at the zoning stage. So, and that zoning again was withdrawn by the Des Moines Airport Authority at the time.
Thank you.
And Eric, are the entrances on Leland, I mean, I would imagine people are going to come down Fleur, and is the entrance for Leland, the entrance is only on Fleur, and then the exits are on Leland?
That's my understanding. And then this is right now, this is an access, but it's only used for the service purpose. But this would be the one that would become the entrance, and this would be an egress. And so people would only be entering there, and then the exiting activity is away from the neighborhood. So.
And Eric, help me out here with the red above there. I see red for.
Yeah, it's hard to. I don't.
Yeah,
If I lighten it up if it's easier.
Well, we've got the hotel there on the west, and then I see that's the yeah. Then right there where your pen is that the first house?
Yeah, and it's also let's see, that's also owned by one of the interests in the hotel, which is Scott.
Okay. So. But straight north of where the proposed new entrance would be.
It's aligning right now with the drive.
The drive of the hotel there, the back lot. Okay. Yep, I've got you. Okay. Thank you. That helps right there. There was a question where somebody said they didn't want their street to be closed in one of the comment cards.
That might be I don't know if that's a construction concern.
Did they maybe, when it was announced or the notice was sent out, did it say closure of the entrance on Fleur Drive was part of the motion?
No.
Okay.
There was some, that didn't come up until the hearing at the Plan and Zoning Commission.
Okay.
I mean, from a staff perspective, it's there.
Yep.
We don't see it as an absolute necessity, but there was some concern by removing it at some point that it would place all the trips into the neighborhood.
Right.
Which I think is a valid concern. When we looked at that, when we looked at the numbers just aren't telling us that that's an undue amount of traffic to be putting on that area. So.
Okay. All right. Okay. All right. Is that your presentation then?
Yes.
All right. Thank you, sir.
Yeah, we do want to make sure they have the permits and site plan requirements met.
Okay.
But other than that, we're recommending approval of the request.
All right. Let's hear from the applicant or representative of the applicant. And good evening.
Good evening, Mr. Chairman, board members. Appreciate the time. I'd like to give just a little brief history of kind of what brought us to this point, I guess. Back in 11, 12, the airport demand has increased significantly. It's putting pressure points on the airport, and we're trying to alleviate those. It's a good problem. Still a problem we got to address. So this last summer, we actually installed a new signage plan to help pull passengers off the front curb that were basically just going to all of our economy lots, parking, and then taking shuttles to the terminal instead of having to come through the front curb and still park. So with that, our new signage plan directed all the traffic or passengers that wanted to park at our economy lots to the Leland-Fleur intersection. So if you want to go to economy 2, 3, and 4, you'd head west on to Leland, and you can go to the economy lots. The decision point to get to economy 1, you would head east on Leland to get into the lot. So this diagram that I have up here actually is what I sent to the traffic engineer of the city of Des Moines, Jennifer Bohack. And I kind of just want to go over everything. So
Could you move your map down a little bit? Yeah, there we can see it better.
So the entrance
Thank
off Fleur is existing. It's entry only. It's a 2-lane entry. Just to the north, where my finger is, that is the current exit lanes. There's 2 exit lanes, and we are not modifying those.
Right.
Where my finger is now, there's actually an existing 2-lane entry, and our proposal is to put revenue equipment on those 2 lanes, so we could have traffic that is diverted off Fleur and Leland enter the lot as well from there. What my request is, really, we can put the revenue equipment on there. It's classified C2. However, the canopy that would be installed infringes on the 10-foot easement. So the canopy really is to provide 2 things. We always want to treat our passengers well at Des Moines. We want to protect them from all the environmental factors as they're pulling a ticket to get in the lot. The second item is to extend the life of our revenue equipment. Protects the equipment as well from all the weather elements. I do want to hand out a study we did. Actually, I should say the numbers. Eric brought it up. Do you mind if I guys pass these out?
Thank you, sir.
Thank you. You need one for your record? So the first page is a email from Jennifer, basically saying there will be no impacts if all the vehicles were to enter on Leland. Again, we don't change the exit patterns. The exit stays as it is today. So all the vehicles, if we did enter, as she states there, you're okay to move forward. So sheets 2 and 3 is the data that we gave Jennifer, and Eric is correct. When he said 8 vehicles an hour, that's actually in our peak month, which is March. There's about 850 stalls in that parking lot, and March is the only month that is full. So if you look there in the second sheet, with 1 hour at 1 o'clock, we actually would have 8 vehicles exiting that lot. And it corresponds, there's 8 vehicles entering sometime. So just for that month is when we have the 8 vehicles per hour on Leland. If you look down at the bottom of that sheet where it says hourly average 2013, 3 cars an hour is the average for the rest of the year that would be impacting Leland. Sheet 2 is actually the entries for that lot in this past year. If you look there at the bottom, 3.6 is the average. So sheet 4 of the study, I actually had an independent firm that we use quite regularly on the airport, Foth Engineering. They reviewed the same numbers that I had given the city traffic, and they are in the same agreement that 8 vehicles max per hour will not affect the traffic flow on Leland. So, and I guess I just would like to reinforce, the airport is just requesting the variance on the canopy. The existing lanes are there. It actually used to be an old entry. There used to be old revenue equipment on it. We'd just like to reinstall revenue equipment on those lanes. And I guess we'd like to protect our investment and our passengers.
Questions? Just a very brief one. Now, you also have a shuttle that accesses the lot, correct?
That is correct.
And how often does that come and go?
The shuttle only enters that lot if a vehicle enters the lot. We actually have the shuttles coordinated with a buzzer.
Oh, cool. Okay.
So if somebody enters that
Okay.
lot, it sends a signal to the shuttle, and the shuttle comes over.
Okay.
So if nobody's entering that lot, we don't send the shuttle over there.
Okay.
It actually saves us.
So on average, and I know trips aren't always like equal, but does it go over there twice an hour maybe?
probably at the most, like I said, if we're only getting 3 exits, and some of those exits are corresponding close together,
Right.
we might get to, at max, three an hour.
Okay, all right.
Is it safe to say this is your least desirable lot to park as far as a traveler, because it's
Yeah.
the furthest away from the terminal?
That is correct.
Yeah.
It's the most economical, because it's the furthest away.
Right. I picked the $6 a day lot over this Memorial Day holiday, not the, what is this, 5?
Yeah, this is $5 now, yeah.
Yeah.
It's just, it's across Fluor,
Right.
a little harder to get to, so you definitely have to rely on the shuttle to
Yes.
get back.
That's what I
into-
wanted to avoid, so I did the
Yep.
$6.
Most people, when they get back from flying, they want to get to their car right away.
Yeah.
So they're going to pick the lot that's closer.
Yeah.
So.
Okay. Dave, anything else?
No, thank you.
Okay. All right, thank you, sir. We'll check back with you here. Is there anybody else here to speak in support of the applicant? Is there anybody here to speak in opposition? Whoever would like to go first.
Larry Scott, 2832 Park Avenue. I'm here representing 6111 Fluor, the Airport Holiday Inn. Just to correct something Brian just said, that's not the farthest away parking lot. They've got a brand new one. I don't know how many cars it holds, must be 700 or 800 on down Army Post Road. But just want to clarify that.
Where would that be at?
Actually, can I clarify that?
Sure.
That lot is only open 1 month a year, so this lot is open 12 months, so actually
Okay.
that's not the farthest lot.
Okay, without getting too much off the record here, so it sounds like he's got some reserve lot 1 month a year. Okay, all right. Go ahead, Larry.
I too just want to bring up a little bit of the history.
Sure.
And that's when, just going back to last March, we were invited to a public meeting at the airport by Brian, and it was to rezone an area that is across from all those houses on Leland. And at that point, they had said the same thing you're saying tonight. Why is it 100% red? There's reasons it's 100% red. And it's neighborhood concerns is why it's 100% against.
Okay.
At that time, what we were told was that nothing was mentioned about closing Fluor, and I noticed Brian tonight did not mention closing Fluor. That is our fear. We have exactly what we need, and I think the airport has exactly what they need now. They've got an exit, which is on Leland, which we are not happy with, but we live with it because it's a long ways from the neighbors. And it does dump out into Leland, but it heads right to Fluor and is towards Fluor. The exit on Fluor, it's a beautiful entrance, I'm sorry. It's a beautiful entrance. It works. It's where people coming off of Highway 5 would come into it before they ever get to Leland. I think it's the proper, I think what they have works and it needs to stay just like it is. At the zoning meeting, we went through the reasons, and there are many from the neighbors, as to why we don't want Fluor closed, which makes it one entrance on Leland and one exit on Leland, a residential street. He said, what, 800 and some cars going in and out off of a residential street. That's why it's 100% against with the neighbors. You've got what you need. You don't need to dump 800 cars in and out of a residential street. That's why the zoning commission said, you know what, we'll give you what you want, but you can never, ever close the Fluor entrance. That's what happened that night. Right before it went to the city council, he pulled it because he wants to close Fluor entrance and dump them and make them come in and out off of Leland. That's our problem. And I know your job is, as a commission, is to protect the neighbors. And we hope that you do that tonight. Thank you.
Thank you, Larry. Mr. Scott, welcome again.
Lowell Scott, 6111 Fluor Drive. At that meeting at the airport, we just kept asking, why are we doing anything? If nothing's going to change, why are you rezoning it after all these years? And that's when it came to light, well, because we have a consultant, and the consultant told us that the intersection of Leland Avenue and Fluor Drive needs to become the intersection of decision where they will decide which way they're going to turn to park. And consequently, we want to close the entrance on Fleur Drive. We really don't have a problem if they want to do this on Leland, if they keep the Fleur Drive entrance open, because that's where the majority of the traffic is. It's a 4-lane commercial road. It just makes sense. It's a major entrance to the city, both from the loop to the south of them and on into the downtown area. But to close that, then you have the only entrance well down Fleur Drive, down Leland Avenue, which is why the neighbors are all against it and up in arms. They recognize that it may be 850 cars, it may only be 8 cars in an hour, but that's nearly 200 cars in a day, and the timing is not at noon. You go to the terminal at 6 a.m., that's when it's jammed, and those people are parking at 4 and 4:30 a.m. in order for early flights, and they're returning late flights. So it's something that is a distraction to them in the use of their neighborhood, and I hope you help save them from that. It's the one thing I would just point out also is that there is really no undue hardship here that is not of their own making. The drive is where they put the drive. They knew what their zoning was when they did that. There is a electrical transformer just to the west of the drive that they don't want to mess with. That is of their own making. They allowed it to be there. Economics are not to be considered in granting a variance. Is only undue hardship, not of your own making, and they don't have any that qualifies. And so I would ask you to turn down this variance for the good of the neighbors.
All right. Thank you, Lowell. Anybody else here to speak in opposition? Okay, applicant, you've got 3 minutes for rebuttal.
Appreciate the time. Again, I just had to kind of bring this back to why we're here. The variance is for the canopy. I'd like to refute a little evidence. The data I gave you is broken out per hour.
Right.
Mr. Lowell can state that it's busy in the morning, but the data doesn't lie. That data is actually from our revenue equipment. It's 8 hours at 1 p.m. and then at 11 at midnight, I believe. It gets close to 8 hours. It's not 8 hours a day. You can't say it's 200 cars a day. I just want to clarify that, I guess.
Okay.
Again, I'm just asking for the variance on the canopy.
Right.
The use of the entry lanes are there. It's in the proper C2 zoning. We can install the revenue equipment over those lanes. We're just trying to protect our investment and most importantly, the passengers at Flyover Airport.
Let's talk about your canopy for a second. The biggest thing that I see when I see canopies or I get concerned about is light pollution or, light that's getting out from the canopy. Sometimes they stick lights on them and they stick way out. How would the canopy look, or do you have lighting that will be in it or on it?
Actually, it's all down lighting. There's
Okay.
2 lights per lane. I was hoping we could see from the photo. If you can lighten it up, see those 2 right there?
Right.
Those are the only lights on the canopy itself.
Okay.
What you're seeing out here in the front is actually just turns red X or green arrow.
Sure.
If you can get in or if it's full.
This isn't the precise canopy style you're going to build over there, though, is it?
It's pretty close. Actually, this
Okay.
canopy,
See, because those lights don't look recessed there. It looks like the fixture hangs down.
it does, about a couple inches.
Well, if you're in West Des Moines, you can't do that most of the time at convenience stores. If we're going to look at approving a canopy, I'd like to have something about some lighting that stays recessed, or we don't have any issues with off-site lighting concerns. Because I am concerned about the residents, and frankly, the concern that I would have would be the lighting of the structure.
The airport would definitely work. I know we run all of our items through permit and development.
Yeah, I think staff
it's covered.
would understand how to work with that. Would you be improving some landscaping around there while you're at it?
I believe we affected a couple of the bushes that are right there. There's some existing evergreen bushes.
Okay.
So I know there's requirements through P&D for landscaping.
And in looking at the shuttle, I know it's not the biggest deal, but most people probably aren't going to have a big diesel short bus cruising around except for the shuttle. Could you have the shuttle come in at the old Fleur entrance exit?
Correct. I just want to clarify that there is no plans on the table. The study that they're referencing was done about 5 years ago.
Okay.
And that was it was an old study done by Walker Parking Consultants. They recommended that you make it a one interchange decision.
Okay, so you aren't planning on that?
There's nothing on the books right now. I can't
Okay.
tell you what the
Okay.
airport board is going to do in a month or a year. I
Okay.
wish I could.
But you aren't suggesting that they close the Fluor entrance?
No.
Okay, all right, that's very helpful to me. If the Fluor entrance stays open, would you be trying to run the shuttle through that entrance instead?
It
More
would-
away
if you-
from the
It would
neighborhood?
make a loop. You know, currently it comes here.
Yep,
Our shuttle bus pickup points
Okay.
are there, so it makes a
Mhm.
loop and then out.
okay, so the bus would not be coming in where your new exit gate would be located?
That's correct.
Okay.
Because I'm going to be honest with you, AMCO runs all of our parking.
Yeah, yeah.
They can't cross 2 lanes of traffic. It's in their
Right,
safety SOPs.
Yeah,
So how they get there, they come here, they can't cross across Leland.
but they can come south
They actually have
and
to
turn
turn to
left.
get in, correct?
Gotcha.
They can only
Okay.
make a right-hand turn.
Yep. All right, that's very helpful.
Thank you for time.
You bet. Okay, any further questions for staff? Hearing none, we'll go close public portion, go to board deliberation. Thoughts, approaches?
Well, I understand the neighbor's concern, and I heard one of the gentlemen say that they would not be opposed to it if we put something in there saying that the Fluor Drive entrance is to remain open. If we were to approve this, could we add 2 things? That Fluor Drive entrance is to remain open and make that a condition. And if you want recessed lighting only, we add that.
Do you want to make that a motion?
Is that, I mean, can we do that? Is that, okay.
If it's quid pro quo, can we do that? If they're asking for one thing, can we require another, like that you keep Fluor Drive open?
You could place any conditions on the variance.
Right.
Meet it, that ensure that it meets the criteria.
Okay. Yeah, to not create congestion or undue traffic or noise.
And
Oh,
I think
sorry.
It's going to have to be because they can't make that, they have
Right.
to make a right turn. But I would recommend approval of the requested variance, subject to items 1, 2, and add number 3, Fluor Drive entrance to remain open, and number 4, that the canopy used recessed lighting.
Okay, we got a motion on the table. Is there a second? Motion and a second. All those in favor say aye. Aye. Opposed? None. Motion carries 4-0. Okay. All right, we have one agenda item. No, is that it? We have one left. Item 22, our public school
Mr.
friends.
Good always gets out of here
Yes.
early, so he's done his penance now for all those times that we approve him.
Okay, Des Moines Public Schools has a request for a special permit variance and exception at 1,000 Porter Avenue.
The appeals would allow for installation of a monument-style sign with an electronic reader board component. They need a special permit for the sign and then a variance to allow a type that's not permitted in a residential district, and then an exception of a half foot over the allowed 8 feet of height. The subject property is the Lincoln Rails South Academy. It's the 9th grade high school, or the 9th grade portion of the Lincoln High School use.
Man, blinded by the light, what's up?
It's just the way it,
Gotta
it's the light coming
recalibrate.
in from the side of the window.
This sketch here shows that
Means we're
the
here too late.
site would generally be located in this area. It would be at least 30 feet back from the front property line, which is the setback. This also shows the existing sign is located within the required front yard setback. So this would actually be bringing the sign into more conformance with setback requirements. Here's a picture of the sign. You can see it looks familiar. It's very similar style to what the board has considered for other schools throughout the city.
And Bert, please help us with this, just, it's kind of an optical illusion, but ground level for the sign is there. So that's just showing what the foundation.
Glad you brought that up, yeah.
Yeah, the subgrade foundation,
It would have
okay.
a 2-foot brick base,
Yep.
then a 4-inch, cement sill.
Sure.
And then a 2.75 foot tall electronic reader board, and then a almost 3.5 foot tall component with the Lincoln Rails Academy logo. This just shows the dimensions of the actual electronic component.
Mm-hmm.
And this is the base. Here's the school. I drove by at the wrong time. School was just letting out, so I didn't get very good.
You were in the way.
Right, I was that creepy guy taking pictures.
The police responded minutes later.
That's what I thought right away.
So here's the consent map. A couple cards in support. The two in opposition are located on the opposite side of the school from where the sign would be, so it wouldn't be visible from then. And I would mention that right now there is a moratorium on sign permits for electronic signs, so the school wouldn't be able to get a sign permit for the sign until after that moratorium expires in June. That said, the moratorium, stops permitted electronic signs, whereas in this case, it's already zoned R160, which does not permit digital signs. So that's why they're allowed to proceed with the board case. They just won't be able to get the sign permit until after the moratorium expires. We've recommended approval subject to quite a few conditions. One being they can't get the permit until after the moratorium expires unless City Council grants a waiver of that moratorium. Two, it has to have a monument-style sign with a brick base that matches the school. Three, shall have parallel sign faces not to exceed 8.25 by 8.5. Electronic component shall not exceed 21.54 square feet. 5 and 6, I'm going to make a slight change to recommendation. We had said, like, the electronic component of any sign shall not scroll, flash, or display video animation and shall not change messages in intervals of less than 8 seconds, or shall comply with the revised sign regulations adopted by City Council. It should be, it says it should not change messages in 8 seconds or comply. We want that to be the more strict. So right now, the city code requires any billboards or digital signs over 24 square feet in area to not change messages more frequently than 8 seconds. But as a result of the moratorium, they may be changing that frequency hypothetically to like 30 seconds or 60 seconds or even longer. So we're saying that they shall not change messages in intervals of either 8 seconds or whatever the new standard that City Council adopts becomes.
But what if the new standard is less restrictive than the old one?
8 seconds.
Okay.
I can't imagine it's going to be.
Well, and Larry, I need your help. I don't want to be picky here, or shall comply with the revised sign regulations. Well, if the revised sign regulations are more lenient, then they can comply with something more lenient.
Right before the meeting, I asked Bert that question because it was ambiguous. Was the intent to make it the most restrictive or the least restrictive?
Exactly.
And
Help me with that.
so Bert made the quick decision, the strict.
So does the language need to be changed?
It'll have to be tweaked.
Yeah, I just made note that the stricter one would apply.
Okay.
Yeah.
Okay, I'm with you now.
Okay, and then the next condition was.
Or shall come, okay. So it's the same deal, okay.
Just the automatic dimmer switch. Then 7, the light shall be shielded to not direct light directly to other properties. 8, we said between 9 p.m. and 6 a.m.
Okay.
And then number 9, any sign shall not be located within any vision clearance triangle. That's not an issue in this case.
Great.
So I would point out, in the past, we've had a more strict recommendation for like between 8 p.m. and 7 a.m., but the board's always granted generally this time, so we.
Okay.
Yeah, so we went with what the board has been granting.
Okay.
And this really isn't any different than what we did at North High and some of the other schools, yeah.
Right.
All right. Thank you, Bert. All right, applicant or representative of the applicant.
Doug Odie, 1917 Dean Avenue, representing the Des Moines Public Schools. Again, as we have in the past, come before you with requests for electronic message boards to better communicate with our students and staff and community. We do that again here today on the Rails project. We have looked at the staff recommendations. I think they're consistent with the conditions placed on past approvals by this board.
Okay.
So we don't have any issues with the restrictions. They seem consistent and hopefully will be somewhat in line with what the city council votes in the long run. So.
Okay. Any questions for Doug? All right, well, very straightforward. Thank you, Doug. Okay, is there anybody here to speak in support? Anybody here to speak in opposition? Hearing none. Any further questions for staff? None. Closed public portion, go to board deliberation. Cindy moves staff, Dave seconds. All those in favor of granting the requested appeal, raise your right hand, say aye. Aye. That's a yay by you. Okay, all right, so that's 4-0, motion carries. All right. Thanks for sticking around, Doug.
I think next time we go first.
Doug, do you qualify for overtime or not? No. As management, you don't, right? Okay, ladies and gentlemen, we have one item of business yet. We need to approve minutes from last month. Those who were here.
I'll make a motion to approve last month's minutes as written.
We got a motion and a second. All those in favor? Aye. Aye. Motion carries.
Are we going to discuss to the other things, there's an email flying back and forth about an item?
Well, we can do it after the meeting. Yeah. I think we're not in this round, but in the discussion, we look at the entire ordinance. We need to take a motion.
Oh, make a motion to end the meeting. Thank you, everyone. Good night. Appreciate you watching. Motion carries. That wasn't very Roberts.